ನಮಸ್ಕಾರ, ಕೇಳ್ತಾ ಇದೆ? ನಮಸ್ಕಾರ,
ಕೇಳ್ತದೆ ಸರ್.
ಅಲ್ಲ, ಕೋಟ ನಂಬರ್ 4 ಅಲ್ಲ ಇದು?
ಸರ್
ಮೇಡಮ್, ಕೋಟ ನಂಬರ್ 4 ಅಲ್ಲ? ಕೋಟ ನಂಬರ್ 4 ಅಲ್ಲ? 4 ಅಲ್ಲ? ಸರಿ ಸರ್, ಓಕೆ. ಸಬ್ಮಿಷನ್ ಅದಕ್ಕೆ
ಒಂದು ಯಾವುದು ಬೇರೆ ನೋಟಿಫಿಕೇಶನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡು ದೇ ಆರ್ ಸೇಯಿಂಗ್ ದಟ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಆಗದಂತ. ನಿಮ್ಮ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಗಳಿಂದ ತಗೊಂಡು ಹಾಕಿ, ಯಾಕಂದ್ರೆ ಇವ್ರು ಕೊಟ್ಟಿದ್ದು ಹಾಕೊಳ್ಳಿಕ್ಕೆ
ಫ್ರೆಶ್ ಮಾಡಿ ಬರ್ತಾವ ಸರ್.
We have produced the record to show that it is up. ಏನಾಗುತ್ತೆ ನಿನ್ನೆ ಇವತ್ತು ಅವ್ರದ್ದು ಬರ್ತಾನೆ.
ಎಸ್ ಪಾಟೀಲ್ ಅಂತ ಇದೆ. ಎಸ್ ಪಾಟೀಲ್. ಬರ್ರಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ಹೇಳ್ರಿ? 33 ಎಸ್ ಪಾಟೀಲ್. ತಗದ್ ನೋಡ್ರಿ. ಸರ 33 34 ನಿಮ್ದಿದೆ ಅವ್ರ ಹೆಸರು ಇಲ್ಲ ಇದರಲ್ಲಿ. 33 54 50
ಸರಿ ಮುಂದೆ ಬಂದಿತ್ತು
ಒಂದು ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀನಿ. ಹೌದು ತಗೊಳ್ಳಿ ಅಂದ್ರೆ ಅವ್ರು ಬಂದಾಗ
ಮೇಡಮ್ ಸ್ವಲ್ಪ ರೀಸನ್ ಸ್ವಲ್ಪ ಹೊರದು ಕೊಟ್ಬಿಡು. ಮೇಡಮ್ ಹೇಳ್ತೇನೆ. ಸರ 40 ಸರ್ ನೀವು ಪ್ಯಾಸಿವಲ್ ಬಂದ್ರಿ ಮೇಡಮ್, ಸಬ್ಜೆಕ್ಟಿವಲ್ ಬರ್ಲಿಲ್ಲಲ್ಲ, ಈಗ ಬಂದ್ರಲ್ಲ? ಹಾಂ ಹಾಂ ಆಯ್ತು ಬಂದಿರಿ. ಹಾಂ 40 ಯಾವಾಗ ಸರ್? ಹಾಂ ಡೀಟೇಲ್ ಬರ್ತಿರಲ್ಲ ಮೇಡಮ್ ಕಡೆ ಕೊಡ್ರಿ. ಅವರು ವೆರಿಫೈ ಕಮಿಟಿ ಅವರ ಬರೀ ನಾವು ಬರೀ ಅಪ್ರೂವಲ್ ಕೊಟ್ಬಿಟ್ಟು ಅಷ್ಟೇ. ಮೂರಾಗ ಸೇಮ್ 100% ಹೇಳ್ಬಿಡ್ರಿ.
ಡೀಟೇಲ್ ರಿಟರ್ನ್ ಆಗ್ತದೆ ಇಲ್ಲಿ ಹೊರಗೆ ಹಾಕಿದಾರಲ್ಲ. ट्राई डिसेबल होके नहीं चलता मेरा प्रेस कर देगा।
कौन सा सर?
हां हां प्रेस कर देगा अर्जेंट नॉट बिफोर मी एक्चुअली उनके सामने क्या पता नहीं बोल पर्सन मैडम डिसेबल किए सर को इन्फॉर्म करो और इनके सामने नहीं चलता उस पे बाद में प्रेस कर दिया सर को बोल दो इन्फॉर्म कर दो उनके सामने आया था क्या हां यार वहां चले वो भी मत डिसेबल कर
ಮೇಡಮ್ ಹತ್ರ ಕೊಡಿ. ಮೇಡಮ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಕೊಡಿ. ರೀಸನ್ ಡೀಟೇಲ್ ಆಗಿ ಬರ್ದು ಮೇಡಮ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಹ್ಞೂ. ಹಾಂ. ಹಾಂ. ಅಷ್ಟೇ 50%.
With your ladyship's kind permission, my lords, one matter for tomorrow. I filed vacating IA. Lords, there was a settlement which was arrived under section 12 of the ID Act. Petitioners have challenged that settlement, my lords, due to which the respondents are now unemployed since 2 months, past 2 months. My lords, please, highly obliged. My lords.
My lords, I made a submission regarding the issuance of the police notice, my lords, under section 35(3). It was directed to be listed yesterday. You want? I do not know, my lord.
Complied with the
Office objections are complied and now they.
If office objections are complied, let it come and also find out why it is not coming. When there is an SOP that it has to be listed within 24 hours. Yes. Fresh matters don't give just like that.
Please.
Don't mention, give it to the court officer.
To MFA LSC matter, my lord.
Huh?
To MFA LSC matter, my lord. Dismiss
MFA?
LSC. Dismiss for non-prosecution, my lord. I have filed a recalling
For that. Will come. Anyway, it is dismissed for
my
non-prosecution.
lord. I have
Yes,
My lord, it is for being spoken to, my lord.
it will come tomorrow. Yes.
Please.
For the list.
tender matter, my lord. Tomorrow.
My lords, may I make?
Tomorrow is the last
submission, my
date of
lord?
application.
My colleague is there, my lords. Who
Today I am
knows where
filing
file?
right now.
File will come.
There is
Don't have to
urgency,
give
my
a-
lord.
Yes.
Lordship, 2025 matter, your lordships.
Huh?
2025 matter, your lordship.
May I seek
It is a case
permission,
of
my lord?
amputation. So that's why we are filing, it is a
Which year is that?
2025 lordships.
Uh,
It is a case of amputation, your lordship. That's why we filed IA for it.
The amputation matters which are pending from long time.
He's facing hardships. It's above the knee level, your lordship. So that's
We'll
it.
see, give it to the court officer.
Your Lordship, the Tahsildar is vacating, signed to vacate the suit schedule property.
My lord, make some submission, my lord.
Before your Lordship.
Then what is urgency now in 26?
Within 1 week, he has to vacate the suit schedule property. It is ordered by Tahsildar, your
It
Lordship.
was ordered in 24.
Right? No, your Lordship. Now, recently, they have come up with
That has to be questioned.
that has posted for.
We can't hear a 24 matter. You have to question it, you have to question it. Yes,
Majority.
on the list.
Page what adjournments?
My lord,
List
may I
number
make
1.
submission, my lord?
Page number.
My lord, make submission, my lords. My lord, since there is urgency in the matter, my lord. My lord. Since there is
Yes.
my colleague is there, my lords, there is urgency in the matter. Kindly wait on any date on next week, my lords.
I should know
Any
what
date
is
in next week, my
urgency.
lords.
If you say urgency-
One for my lords,
Huh?
not urgency, my lords, respondents are disturbing my suit property, my lords. We have challenged the local order, this honorable court grant interim order, even though my lord, grant order, my lord. Yes, or no,
I'm not able to hear.
Page number 2, serial number 3 to 10.
Serial number 8, my lordship, I am petitioner. Kindly have it on next week.
Why?
Some personal inconvenience,
To
my
whom?
lordship. For petitioner advocate, my lordship.
I will not extend the interim order. I'll adjourn the matter. This is matter after 2 weeks. Yes, next.
Page number 3, serial number 11. Page number 4, serial number 12 to 16. Page number 5, serial number 17 to 25. Page number 6, serial number 26 from admission. Page number 10, serial number 43 and 45.
Lord, serial number 44. 44.
Hmm.
My lords, I appear for respondent number 2 to 4. I request short accommodation objections, we need to file.
Interim order is there.
Interim.
2021 matter, how can you file objections now?
Lords, I appear on behalf of Avinash MND, he needs to file objection in this matter. I have not.
That's what I'm saying. A repetition of 2021, where is the question of filing objections now? We will see when the matter comes.
Please.
I will not adjourn any matter that is in the list without a
Please.
valid reason.
Please.
Yes.
Page number 11, serial number 45 to 48.
My lords, settle.
Serial number 48, Mars. I am
48.
appearing on behalf of respondent number 2. Santosh Nagar, his personal inconvenience, family function is there.
Pendu?
Taken on
Mr.
16th.
in the month of March.
My lords, there's urgency, my lords. My lords, on 13th, my lords, there is urgency in this matter. It's inconvenience for them.
Tomorrow, my lords, tomorrow.
Tomorrow, day after tomorrow, for Thursday, Friday, my lords, 13th.
Day after tomorrow, court is not sitting. Let's just matter on Wednesday, next Wednesday.
18.
Please.
Page number 12, serial number 49 to 54.
Lord, serial number 49.
52.
52. It's appear for petition this matter. It's short of notice.
Why?
Council who is arguing is not keeping well. Council on record, my lords, is not keeping well, my lords. It's short of
This matter in the month of March.
serial number 49, my lord. I represent on behalf of my lord, respond number 6. Advocate on record is not, my lord, in station, my lord. It's weeks accommodation, my lord.
Request of land council respondent, this is matter.
Respond number 6, my lord. Please, my lord.
Page number 13, serial number 55 to 56.
My lord, 54 and 55, my lord, my colleague, 54 and 55, my lords. Is disabled before your lordship, my lords, may kindly, my lords, please to.
54 and
55 and 33 also, my lords.
55 and 33.
Please, my lords.
List before the other bench.
Great.
Page what? List number 1, preliminary hearing matter, serial number 1, Sangram S. Kulkarni, Nos B. Naik.
Yes.
My lord, on the last date, my lord, the state was directed to produce the records.
Yesterday's matter, my lords. Yesterday's matter, my
Whether
lords.
it is a district road or a state highway.
As per the information given by the other side, my lords, it is a, as an date of my lords notification, it is a rural, it comes under the rural area. The
So it's a
road.
district way.
Yes, but I have to confirm and verify it. I have to verify and confirm, my lords.
That is what the matter is adjourned for.
Yes, yesterday only, it was listed yesterday, my lords.
It was not listed yesterday.
Day
It
before.
has listed so many.
Day before
also. Way back in 2024, there is a direction.
At least kindly pass over, my lords, officers.
No, that matter.
In fact,
Passover is not at 2:30, Passover is at 1 o'clock. By the time you have to get instructions, or else I will ask the concern to appear before.
In fact, in this.
Agitated before this court. That matter is now agitated before this court. There is a findings of this court on the not.
With regard to the very same road.
Yes,
Where
very same.
is that?
In the second writ petition, I produced the copy of the writ petition. I'm for the respondent number 2. I have filed statement
What is a writ petition?
My lord, this road was declared as a state highway in the year 2020, my lord.
1 minute. To quash the impugned NOC dated issued by respondent district magistrate.
The first matter, that is a consequential, my lord. In the 1.1.
So I'm looking at 107286.
Your lordship may kindly take 1.1.
This is 2023.
Yes.
What is the prayer in this?
My lord, directing to cancel the allotment of rural retail outlet.
The respondent to cancel the allotment of rural retail outlets process initiated as per the advertisement of location number so and so. Who are you?
My lord, I am also a applicant who wanted to start a petrol pump at that particular spot, my lord. My lord, we were not allowed to participate in the said tender, and therefore this writ petition came to be filed, my lord.
So what is this?
My lord,
possible
now,
direction to the respondents. Why should we direct them to cancel the notification?
my lord, they want to set up a retail rural outlet. My lord, that road has already been declared as a state highway in the year 2020, my lord. So as per the guidelines, which is.
What should be the prayer? Prayer should be, the notification is contrary to so and so.
Yes, my lord.
That should be, how can there be a direction to cancel the allotment of rural?
My lord, under the rural, they should have done it under the retail outlet, my lord, not under the rural quota. Because as far as the guidelines.
There is that order.
My lord, annexure R3, page number 25, along with my statement of objections. Here also identical for the same locations, the same state highway. Page number 35, annexure R of my statement of objections.
Yes.
Yes, ma'am. The relevant paragraph, my lord, is.
This petition is the same.
The matter is already covered by this decision. Same. Same notification
Petitioner
and
is
same
different.
road.
My lord, annexure C with the writ petition may kindly be, yes, annexure C may
Yes.
kindly be seen, my lord, with my writ petition.
Para 10 is relevant, my lord.
Let's see this. Advertisement notification in what? Retail outlet dealership at so and so. Which para?
Para 10, my lord. The admitted facts.
Yes. So, as per the notification came into being on 12/7/2023. When
Yes.
is the notification in this case?
That is at annexure R1, my lord.
Date?
R1 dated 12/7/2023. 12/7/2023.
Advertisement.
Advertisement, my lord, is
28/6/23.
28/6/2023.
Same.
Same, my lords. Even the road is also same. In fact, his contention, my lord, in the year 2020, certain notification was issued. It was only a proposition which got approval at the hands of the state government. That's all. But every state have, my lord, it requires to declare under section 3.
Notification. One agency says that a retail outlet will be established. The other agency says that a rural outlet will be established. This honorable court has now considered and held that they can establish a retail outlet and not a rural outlet. My lord, for a moment, page 19 of my writ petition may kindly be seen, my lord. Page 19. Type of RO is mentioned as rural. Page 19, my lord.
Have you read this order? This order of Justice Suraj Gonjas.
Yes, my lord.
Why is it not applicable to your case? That you please argue.
Yes, my lord. As per the
You only, this order, whether it is applicable to you or not. We will not hear any of the merits of the matter. Whether it is applicable or in the same similar set of circumstances. Basing on the very same advertisement, this order is passed or not.
for that only I am clarifying, my lord. HPCL, BPCL, IOC. There are three different agencies who appoint retailer.
The notification issued in this case in
It,
page
it,
number
it is
30.
by
HPCL is the respondent.
yes, ma'am.
In your case.
No, in my case it is BPCL.
But ultimately road will not change.
Roads will not change. For that purpose, I am submitting, my lord. Abutting a state highway, a retail outlet can be established and not a rural outlet.
What is the finding in this case?
They say that they can set up a retail outlet.
Finding in that case.
Look at it, you can see the papers in the order. There is an order passed by the judge. Let us read it. Read from paragraph number 14.
Yes, ma'am. Though I answer the point raised by holding that it is the date of the notification which is required to be considered for purpose of designating the establishment of a rural outlet or a regular retail outlet on the basis of the qualification of the location. In the present case, considering the peculiarity in as much as once the notification submitted was issued on 28/6/2023, the road was notified as a state highway on 12/7/2023, with the last date of application to be submitted being 27/9/2023, and the complaint filed by the petitioner was only on 30/12/2023. I am of the considered opinion that even if this court were to intercede in the matter at this stage, then the same would only result in a fresh notification being published by HPCL, and this notification would indicate that location is a state highway, thereby requiring the establishment of a regular retail outlet. Here, if hence no particular purpose would be served by passing such an order. My lord, in this case, they want to
complete the order.
In that view of the matter, the action on part of respondent number 1, officers not being as per the applicable law as on that day, thereby depriving the petitioner of his participation in the application process, cost of 50,000 is imposed on HPCL payable to Karnataka State Legal Services Authority. So here they wanted to set up a retail outlet.
So HPCL, well, to ascertain the nature of the location, before issuance of a notification.
Yes.
So they have issued a notification.
Notification.
Even as per this order, as on the day when the notification was issued, it was not a state highway. It was a district. After the notification was issued, a notification is issued declaring it as a state highway.
No, my submission is, my lord, annexure C may kindly be seen, which is produced along with the writ petition.
Annexure of which writ petition?
106770. Annexure C.
Hmm.
This is a letter issued by PWD,
Where is that? Annexure?
page 21, my lord.
Yes, what do they say?
Yes. With reference to the above, you are requested to this office for providing information of category of road from Kaveri Hotel to Azra Road, its state highway or major district road. If it's state highway and its number and from which year it is upgraded as a state highway. As per verification, road which starts from Kaveri Hotel towards Azra is Tawandi to Hadalga.
Dispute on this.
My lord, the date is 1/9/2020. It is already upgraded as a state highway on 1/9/2020. It is only renamed on 12/7/2023.
On
For that purpose, my lord, this was brought to the notice of this honorable court, and PWD was specifically directed to produce.
Is it required when the
Yes.
it is an information given by the office of the
Yes.
Assistant Executive Engineer?
Not even under the notification date 1/9/2020, the state government just gave an approval, that's all. But that gets fructified when the notification under section 3 of Karnataka Highways Act is issued. Because what is important?
Please read 21. It is upgraded as state highway as per GO number dated 1/9/2020.
It's not.
Government order. Under section 3 of Karnataka Highways Act, there has to be a notification by the state government. Unless until there is a notification by the
They're
state
talking
government.
about this notification.
No,
GO.
that is an Lord cabinet approval. That is a cabinet approval. That is not a notification. Section 3 provides for notification by the state government to Lord publishing any Lord major district way to the Lord state highway. Unless until Lord it is notified under section
Such a
3.
simple issue, such a simple issue, because of the inaction on the part of the government, that is, without filing your objection, you're just making them fight.
As per the notification, my lords, annexure G in the my lords, the second case, it is stated that my lords on 12/7/2023.
What is this?
It is notified.
You have only given it, no, this page number 21, Office of the Assistant Executive Engineer. Why did you give that?
As far as notification is concerned, annexure G, my lords, in that case. It is on my lords 12/7/2023. Subsequent to the notification issued by the my lords, my lords, petroleum.
We'll ask the Tehsildar to come to the court and tell the court what exactly it is. That's better, I think.
In fact, this
This is
notification.
nothing but wasting the judicial time for unnecessary things, which can be clarified with one instruction. If somebody asks you an information, then what is this information given by you? Saying that so and so is upgraded as state highway. So this was given on 25/10/2023. Whatever is the subsequent thing dates they are giving, by that time it has already happened. That should have been stated. No responsibility.
Notification gains importance.
Huh?
Notification gains importance.
Who stopped you from saying it when you have given a communication?
In fact, this particular notification dated 1/9/2020 is referred to in para number 10 of the judgment, which have annexed at annexure R3. These aspects were discussed at length. Para number 10, my lord. The facts are not in dispute. The road on which location number 3 and 15 has been marked as on the date of notification, that is 28/6/2023, was a major district road. Though there was a proposal, this is what my friend is relying upon.
Let us see the State Highways Act.
Karnataka Highways Act.
Karnataka Highways Act.
And in the writ petition which they are relying, this honorable court says that you set up a retail outlet, not a rural retail outlet.
No, what happens is, as of now, it is more of an academic interest now. Today, it has become a state highway. right or wrong. Nothing has been in view of the orders passed in this
Because
case.
I am the allotee. I am the allotee under the Lord,
Rural,
secretary.
rural quota.
And Lord, I am affected. In his writ petition, Lord, I am not made as a party. Without, Lord, a beneficiary being a party, Lord, he wants to, Lord, challenge that notification.
Anyhow, now you are before the
No,
court.
he is a party in the first writ petition.
Allah, first, that is consequential. You have challenged the NOC.
So the gazette notification,
Now the first notification of 2020 is done under which provision?
it is just a general notification.
Not general.
Under which provision?
No provision, none of the provisions have been invoked. It just states that
Where is that notification? Take that.
Annexure 3, my lords, on page 28.
That is a cabinet approval to, Lord, upgrade the, Lord, road.
that second page is a table of roads, my lord. The ones which get upgraded to major district road.
Yes.
Here only approval is given, that's all, my lord.
We'll set aside this notification. Go with the fresh notification.
As on now, my lord, the
happens
successful
if-
candidate,
No, I am not made as a Lord, party in the writ petition.
In the second
Lord,
writ petition, he is a party member.
They have challenged the consequential, Lord, issuance of NOC. Lord, kindly see, Lord, as on date of, Lord, the advertisement, it was a, Lord, rural category. It was a major district road, not a, Lord, state highway. Going by the, Lord, judgment of passed by the, Lord, coordinate bench, Lord, where it has been clarified, since though the, Lord, there is a cabinet approval, Lord, on 1/9/2020.
Implead him in your writ petition, will pass orders. Implead him in your writ petition.
Yes, ma'am.
This is matter on 24th of February. By the time the
Lord, the first,
allotee shall be a party.
Lord, in the first
shall be
case, my
made
lord,
a-
I am not made a party, my lord.
Huh?
In the first writ petition,
Who are you?
I represent BPCL, my lord.
PPCL is not a party.
Lord, we have issued this notification and we have selected,
A party.
My lord,
Not
in the,
made.
in my writ petition, that
First-
is of to 2023, he is a party. Since DC had issued NOC, I had challenged only the issuance of NOC in the writ petition serial number 1, wherein the name, the person in whose favor NOC was issued, they have been made party. My lord.
NOC is issued in my
Lord,
name.
in the first writ petition, I may be permitted to implead BPCL, and in second, the allotee. My lord.
Yes.
Serial number 2.
Lord, interim order may kindly be explained.
Number 2. Girish Yadav.
Please.
Paper.
Yesterday's matter, my lord. I'm making an objections, let's
Take that objection. I was served on him.
yeah. So I'll just bring to your lordship notice, my lords. Along with the objections, my lords, 2 photographs I have produced. These, my lords, I have also produced along with the vacating stay application. Now, even in the, the report of the commissioner, my lords, there's one photo at annexure C, my lords. If your lordship would see, from the coconut tree, my lords, the behind the coconut tree, my lords, that is the sugar cane of the petitioner, my lords.
The other day when the matter came up, you are submitting before the court that there is a standing crop. Now, when you look at the land, it is freshly blown.
Standing crop is sugarcane, my lords. The season for sowing the sugarcane crop will be, my lord.
You said as on that.
No, now they have sown.
The day it is there, and now if it is, if the vehicle is permitted, it would be, it would cause injustice to the petitioner. That's what is.
No, yes, my lord. I was saying that, my lord, my standing crop cannot be destroyed for, my lord, letting him pass through that.
Where is
Even
the
as per the report of the court commissioner, my lord, there is cultivation in that land.
standing crop?
It is sent to the sugarcane factory, my lord. The season will be between November to January of the sugarcane.
Now, if he takes his product, whatever it is that the produce outside, nothing is going to happen. No, it is open now.
No, there is cultivation, my lord. It may not be so much. Yes, yes. I understand what my lords are, my lord, posing the question at me, my lord. If the complete fully grown sugarcane is there, my lord, a lot would have been caused to me. But now there is cultivation, the damage will be lesser. But my submission for my lordship's kind consideration will be that, my lord, his claim that there is a 12-feet road is completely now falsified by the filing of report. You only once. Let me.
According to you, where is this road?
Please, my lord.
Where is this?
My lord, this photograph, my lord, he produces, my lord, it is dated 7/3/2025 without any explanation.
No, 10.
Whether, my lord, it is at the same place or not.
Where is this? It is not, this is not the same land?
Same lines. Google minutes.
There are Google Maps, Google Photos.
Yes, yes, my lord.
So your client has to be, before saying that this is existing or not. And if you upload the land after before the commissioner's visit or before that, then we have to.
No, I have, my lord, grown sugarcane.
I'll ask him to file if any other photographs are not.
Yes, yes,
Then
that
I
may be,
will
my
do
lord.
that.
My submission will be, my lords. My legal submission may kindly be. I'm not saying that, my lord, because even my client is an agriculturist, my lord, she knows what will happen, my lord, if the sugarcane, my lord, is totally damaged. But my only submission for my lordship's
In a relation, when both of you are related, this is the manner in which you are fighting.
My lords-
Not that the court is not declaring any rights of anybody. No, standing crop is there. Let him take the crop away. Then after that, let the court decide. No, once it is done.
No, that's why,
then
my
the
lord,
court
I
will-
may be permitted to complete. I am exactly in the line of what my lords are saying, my lord. But now the first appellate court's order is wrong based on the, my lord, court commissioner's report. Even, my lord, in his own land, as per the court commissioner's report, there is only a pathway of 2 feet. My lords may kindly assess, my lord, what I am trying to submit. My lord, he claims a road of 12 feet into 1600 feet, which is roughly about, my lord, 15 to 16 guntas. When the matter was referred to mediation, my lord, I said, either you give 15 guntas of land to me, take this road completely, make a full-time road in my land, you can always use it for sugarcane, or pay, my lord, a reasonable value for the said extent. But he was ready for neither of the proposals. This is one aspect. And 2 feet pathway in his own land, he claims for a 12 feet pathway in my land. This is second aspect. That's why, my lord, the other day I was making a submission on legal submission. Trial court, having found that there is no, my lord, prima facie evidence to show that there is a road, it declined to grant injunction. I can understand if there is no road for him to take sugarcane road, then I, being his sister-in-law, should permit him. My lord, to that I am not objecting. But let this not be made an evidence before the trial court during the course of trial that there is a road. That's what is the claim, my lord, stated by the plaintiffs.
That your
That is
lordship
the,
may clarify.
let me complete. Therefore, my submission is, my lord, on principle, I am also, my lord, supported by 2 judgments of the Honorable Apex Court regarding, my lord, how the first appellate court, while considering an application under 13 and Rule 102, has to, my lord, deal. Now, in this case, without finding that the trial court's order is perverse, and on completely different, my lord, opinion, the first appellate court allows his application, which is completely bad. Therefore, my lord, I am requesting this writ petition may kindly be allowed. Trial court's order may be affirmed. He may be, my lord, permitted to take out his sugarcane, and for that damage, my lord, for this 1 year, let him pay. And in between, my lord, let the trial court decide. Or, my lord, at the same time, either even as on today, my lord, let him take instructions. Out of the 2 proposals, his land is measuring, my lord, 4 acres and 12 guntas, which is abutting me. His total land is 10 acres. Elsewhere, he has got 6 more acres. Behind my land, there is 4 acre, 12 guntas of land. She is a widow. He wants to suppress her and, my lord, take advantage of it. That I am not permitting. Let him, my lord, part with, my lord, that at least 12-13 guntas of excess land. Let him have a compact, because there is a, even as per the report, there is a 7 feet wide bund between his land and my land. That itself shows that, my lord, there is no such road existing. So let us, my lord, forget about the road. If he wants to make use, my lord, let him make use. But let there be a fair proposal. Both of us will be happy.
No,
Market value, my lord, for each gunta there, my lord, is about 1 to 1.5 lakh. So he says, I'll pay 10,000, 20,000 rupees, my lord, for taking such huge amount of my land. That is not agreeable for my client.
No,
so what I'm saying is, my lord,
why
I will.
Existing, my lords, when, my lords, I have come to the court, my lords, because, my lords,
That,
since
my lord,
from 72, my lords, that is being done.
That is not
notation-
established, is what the trial court says.
That's my, that's coming to the court. If I had any alternate way, there was no reason for me to come to the court. It's only that way which is there, not since from 72 milliards that is being used. Now, because milliards, the value of the property, not the her property, milliards, it is near to the road.
So there is no material, as of now, the court cannot, at this stage, cannot say whether there is a pathway, whether there is a pathway for you in the, as the schedule pathway.
No,
or
since-
not, we don't know.
Yes.
No,
Not.
option, like in the other matter you have appeared, like how I have disposed of that.
Yes,
matter.
but-
This matter also.
Yes.
Without going into the merits of the matter, without even considering whether there is an existing pathway or not. Without any observation, I'll set aside the orders of both the courts. And I'll say, let he be permitted to use for the present. Only for this crop, let him be permitted, and let the court decide the matter on the merits.
No, my lord, first appellate court's order may be set aside, trial court's order, my lord.
So you heard that I'm setting aside that order.
No, my lord said, my lords will set aside both the orders. But that will cause serious prejudice to me because the trial court,
No, without setting aside that order, why will the?
no,
court say
on,
that,
on equity, my lord, on legality, my lord, I may permit it only for one moment, my lord. My lords may kindly hear me for 1 minute and then, my lord, pass any equitable. So, my lord, I'm not opposing for any equitable order. But on legal principles, my lords,
Those
there-
are all settled principles. For that, we don't require judgments and.
no, yes, because the reason I'm submitting is what trial court says, he relies on the 1972 partition to say that there was a road. But he does not produce the 1972 partition deed. He says it's an oral partition. Then he produces more than one mutation entry. In that mutation entry, there is no mention that there is a road. But the first appellate court assumes that the trial court rejected his application on the finding that there was an alternative road, but allows his application. That is completely, my lord, a wrong order. Therefore, my request is, my lord, trial court's order may be, my lord, confirmed. On equity, my lord, he may be permitted to take for once.
What the court says is, my lord,
Or, my lord, there is-
alternate way is not being shown by the defendant.
That is not my duty. It is for him to show that there is a road first. If he does not prima facie establish, then, my lord, it has to come to me.
There is an order in the MA,
Order in the, my lords? Trial court's order, my lord.
appellate courts.
Appellate court's order, my lords, it starts from page number 45, but I have filed, my lord, translated copy.
Speak with the orders passed in.
Para 18.
MA number 7 of 2025. 22nd April 2025. The defendant is before this court. The respondent herein has filed a suit. And filed a suit seeking declaration of his easement right of easement to make use and enjoyment for ingress and egress for transportation of the agriculture commodities, passing of their cattle, carts, etc. over the 12 feet with the suit ABCD road. In that, he has filed an IA seeking injunction that came to be dismissed by the trial court by order dated 4 January 2025. While discussing the said IA, the court has observed that both the parties have admitted partition that was taken place in the year 1973 between father of the plaintiff and father of the defendant and other family members, and allotment of RS number 15/2A to the share of the father of the defendant, and allotment of RS number 14/2A and 14/6 to the share of the father of the plaintiffs. It is a contention of the plaintiff that the defendant have led suit ABCD road measuring 12 feet and 1600 meters in length towards southern portion of RS number 45 and 50 between the boundaries, and the defendant has denied the same. And according to the defendant, the plaintiff has a right of way in another uncle's from on a pass in the land of the paternal uncle. The court observed that the plaintiff has not produced any document on record to show the existence of such ABC road in the land. On perusal of the mutation diary number 1956, the prima facie appears that there is no recital with respect to leaving of 12 feet width road in the southern side of the land. And the plaintiffs have not produced any partition deed. The court observes that the plaintiffs have produced two photographs. On perusal of the said photographs, it prima facie appears that there is no suit ABCD road measuring 12 feet in width is appearing, but a pathway can be seen in the said photographs, and there is no marks of passing of bullock carts and tractors can be seen. And hence the court felt that court has come to the conclusion that at this stage, plaintiffs have not made out any prima facie case against the defendant, and balance of convenience also does not lean in their favor. If the temporary injunction as prayed for is not granted, no loss or hardship will be caused to the plaintiff, and accordingly dismiss the same. The defendant has carried the same in appeal by filing the same by filing MA number
7 of 2025.
Plaintiffs have not in appeal minutes.
1 minute.
Defendant on,
By filing MA number 7 of 2025, which came to be allowed by order dated 22nd April 2025. While allowing the said MA, the court has observed that based on the settled principles of law, the appellate court, while exercising its jurisdiction, is under duty to interfere with the jurisdiction of the trial court. If it is found the trial court has acted on surmises and conjectures or has neglected the facts and adopted an illegal, and also the appellate court cannot exercise its discretion to substitute the discretion exercised by the trial court. The court observes that there is no dispute that the properties allotted to the share of the plaintiffs and defendants are ancestral property. And they have been enjoying the land since 1971-72. However, the trial court has rejected the IA number 1 on the ground that the said road is not mentioned in the record of rights of the said properties. And on the ground, as stated by the defendant, there is an alternative road, the land of Shivappa, Madan Kandi, to reach the land of the plaintiffs. Without there being any document, the court has observed that there is an alternative road. The defendant has also not produced any document in the trial court regarding availability of the alternative road. The rejection of the interim application by the trial court without properly considering the evidence and pleading produced by the plaintiffs and defendants by wrongly exercising the discretion is not justified. The appellate court has come to the conclusion that the court has failed to consider the application in the light of the settled law and accordingly granted injunction. Accordingly, the granted injunction against the defendants from interfering with the use of the ABCD road as shown in the hand sketch map produced along with the plaintiff. Expert. When agreed thereby, the defendant is before this court. When counsel appearing for the defendant submits that when the plaintiff has filed a suit and sought an injunction restraining the defendants, he has to place the burden lies on him to prove the same. According to the defendant, the plaintiff could not prove by adducing evidence that there is a pathway for the ABCD pathway, and the defendants have been the plaintiffs are using the same. According to them, as per the partition date, this pathway is provided. The court has rightly observed that the trial court has observed that the partition deed is not part of the has not been placed before the court. when the petitioner, plaintiff could not prima facie prove prove the existence of a pathway and his exercise of the easementary right, the trial court had rightly dismissed the IA filed for injunction. However, the appellate court, contrary to the settled law, and without there being any other material before the court, and had interfered with the discretionary relief with the order passed by the trial court. It is submitted that it is not the appellate court without any basis cannot interfere with the order passed by the trial court. It is submitted that there are no reasons given by the appellate court while granting injunction. Next part. Land counsel appearing for the respondent plaintiff submits that both the parties are related to each other, and from times immemorial, they've been using the same as a pathway. Now there is a standing sugarcane crop. If the petitioner, if the defendant is not permitted to transport the crop, it would cause lot of hardship to the plaintiff. This aspect was rightly considered by the court, appellate court, and granted injunction. It is submitted that, as submitted by the defendant, there is no pathway, there is no alternative road to the plaintiff. The trial court has failed to appreciate all these contentions raised on behalf of the plaintiff and dismissed the appellate court, considering the submissions, had rightly granted injunction, and there are no grounds to interfere. Next part. Having heard the counsels on either side, so and so. In the light of both the counsels have argued, in the light of the submissions made by both the counsels, this court has appointed an advocate commissioner to inspect the site and submit a report whether there is any pathway that is ABCD road as shown in the plan, whether there is a pathway road existing between the land of plaintiff and defendant, which can be used for the ingress and egress and for transportation of the agriculture produce. The advocate commissioner has filed a report before this court. As far as the first query is concerned, it is stated that there is no such pathway existing, that is ABCD road as shown in the plan. The sugarcane is planted in the portion shown as ABCD in the plan. The photograph of the land shown as ABCD in the plan. No, this one. Portion shown as ABCD in the plan. Then when it comes to the next query, it is stated that there is no pathway road existing between land of the plaintiff and defendant, which can be used for ingress or egress or transportation of agriculture produce. The subject properties, that is survey number 15/2A and survey number 14, are separated by a bund which is 7 feet wide and 3 feet height. The entire survey number 15/2A is cultivated with sugarcane. The western portion of survey number 14 is cultivated with sugarcane, and remaining eastern portion is uncultivated. As shown in the hand sketch, a rough walkway about 2 feet wide is there on the southern portion of survey number 14, which continues up to bund, but does not continue in survey number 15/2A. The defendant has filed his objections to the commissioner's report. It is a contention that earlier when he has filed the photographs, a pathway is clearly shown. Later, the plaintiffs have plowed the land. The defendants have plowed the land. As such, the existence of a pathway is not seen in the photographs or by the commissioner. The same is disputed by the land council appearing for the defendant. Land council also further submits that if the petitioner, if the defendant, if the plaintiff wants to settle the dispute amicably, it was always open for, they were always ready. But the plaintiff wants the land, but land oblique pathway, but he is not ready to part with the land or with the money. It is submitted in the light of the advocate commissioner's report and in the light of the respective contentions raised on behalf of both the parties. This court has to appreciate the order of the trial court as well as the appellate court. When the plaintiff is seeking his right of easement and also sought an injunction, the burden lies on the plaintiff to prove that there is a prima facie case, balance of convenience, and irreparable loss. According to him, there is a partition, which is as per the partition, this ABCD is the pathway, and the plaintiff can use the same. If that is a contention of the plaintiff, he could have produced all the documents before the court to prima facie show that as per the partition deed, and they have been enjoying the pathway. In that regard, the trial court observes that the no partition deed is placed before the court. As there is no prima facie material before the court to accept the contention of the plaintiff, the plaintiff has the court had dismissed the IA seeking injunction. When it comes to the appellate court's order, the appellate court, on what basis the court has granted injunction, this court is not able to understand and appreciate. There is no other material before the appellate court than what was it filed before the trial court. And why was on what basis the appellate court has come to the conclusion and has reversed the finding of the trial court. Court is not able to appreciate, understand the said reasoning given by the appellate court. Without appellate court and in the constituted opinion of the court, the order of the appellate court has to be set aside. Next. Both the parties are related, and by virtue of the partition, both the parties are enjoying their respective lands. There is no dispute about the fact that there is a standing crop in the defendant's, in the plaintiff's field, and he has to cut the same, and he has to transport the same. For that, he requires a pathway. Whether there is a ABCD pathway or not, as that is a sue scheduled property, this court is not going into that issue. If the plaintiff is not permitted to take the standing crop, that would cause lot of prejudice and hardship to the plaintiff. Hence, without going into the merits of the matter, whether there is a pathway in suit ABCD scheduled property, this court is passing the following order on the ground of equity. Next one. This court is passing the following order. Accordingly, the order dated so and so passed by the appellate court in so and so is set aside. Number 2, the plaintiff is permitted to take the standing crop of sugarcane, and the defendant as a one-time measure shall permit the plaintiff to take the said produce through his land.
Yes, sir.
And my lord, little more qualification.
Of this court has not expressed anything on the merits of the matter, only as on a ground of equity, this order is passed.
Only I would request my lord for little more qualification to that my lord permission to take, because my lord, he may use my lord tractors or trucks that may not be permitted. By cart my lord he can, because it's only 2-acre sugarcane I'm told. Out of 4 acres my lord he has.
But the plaintiff, by way of the carts,
Carts.
he can transport the produce through the.
What
land
I'll
of
do,
the-
what I'll do is, Millards, because I don't know how much is the quantity of sugar cane.
Understand, this
No,
is a. this
Millards,
is
what
a-
I'll do, what I'm saying is, Millards,
On equity, there
true,
can't
Millards.
be any other
No,
demand.
cart,
but
Millards, if cart, what happens, Millards, it's not
Yes,
possible.
next, no.
We'll take a tractor, we'll plow it back how it was. And instead of, Millards, Lordship may put it, Millards, I'll plow it back and give it how it was. Instead of, because
If the petitioner, if the plaintiff requires to use the tractor, once after the transportation of the sugarcane, as and where in condition, he shall.
Please restore the condition.
Restore
Please.
it to the petitioner.
And my lord, for the present damage that would be caused, my lord, he may have
no,
to.
they have not sowed, Millards, I
I
don't
have
know.
plowed it, I have sowed my lord sugarcane. my lord.
Yes.
And one more observation may kindly be made, that my lord, this shall not be used, my lord, for the subsequent years, my lord, as
I said it is
one-time measure,
only-
one-time measure.
That's what.
Yes.
As a one-time measure, I said. Yes, next.
Please, grateful.
And trial court, Millards, shall consider, Millards, the on merits, Millards, because evidence has to be led now.
My lord, so observe
Yes,
that no expression is, my lord,
But I have not expressed
on anything
It's
on
only
merits.
on equity I have done.
Great.
And independently court has to deal with it. Yes,
Great.
next.
Please.
Till number 3. Shatamanor.
My lords, annexure E and F has been challenged, the endorsement issued by the respondent number 1 and 2 before this honorable court. The annexure E and F is in Kannada language, my lords.
Huh?
That is in Kannada language.
1 minute.
My lords,
Quashing the endorsement issued by the respondent number 1. Who is respondent number 1?
my lords, the joint director of agriculture and the assistant director of
What is the endorsement?
endorsement not, my lords, the petitioner has been, the respondent number 2 has called for the tender.
Let
work
us see
order.
where is the endorsement? Page number?
Page number 25, my lords. 25.
What did he say?
23, 124.
My lords, wherein they stated that, my lord, after filing the writ petition, after filing the contempt petition, now at that time they have issued the endorsement before this honorable court, my lords. That has challenged before the, wherein in the contempt proceedings, the honorable court has given the liberty to challenge in the proceedings I have before this honorable court, my lords. My lords, as per their contention, my lords, they contend that all the only some of the work has been.
It requires an objection from them. The respondent so and so takes notice
Yes.
on behalf of respondent 1 and 2. The HA takes notice. They shall file the objections within 2 weeks, or else the writ petition, the order shall be passed basing on the contentions that are raised in the writ petition. In all the matters wherever there is a objections shall be filed by them. Only 15 days. After that, the matter has to be, and the right to file the counter objections shall be forfeited after 15 days. Yes.
Till number 4. Srinivas Vinayak.
My lord, as far as when B report is pending, the coordinate bench has passed one order.
Let's see.
Lordship kindly peruse page.
Let's see. Where is the operative portion?
Yes, madam. It starts from page number 11, last line.
In the light of the efforts that extracted order, that the
Adu
petitioner
ಒಂದು-
shall submit a fresh application with the authorities and also appropriate course seeking any direction to travel abroad.
ಅಲ್ಲ, ಅದು relevant paragraph, page 11, last line. Start from last line, page 11.
Yes.
The involvement of the.
That is in another order. Which
ಅಲ್ಲ,
order is that?
another order consider, after considering.
Order on being spoken to. What was the first order?
In that manner, that was not ordered.
Granted to the petition, lacking in the merits. If you look at what is the writ petition about? Petition seeking direction to issuance in the name, so direct the first respondent to renew, reissue the passport. Facts, sir?
In that case also, B report was filed, my lord.
Between the dates of the scene's expiry and indicated so and so. Into the crime and filed a charge sheet. Agreed by registration of the crime and filing charge sheet. Criminal petition. A coordinate in terms of the order has stayed the proceeding. It is only where is the B report?
Page 12 ಅಲ್ಲಿ lordship.
No, that we will. The facts are here.
Yes, ma'am. Adರಲ್ಲಿ two cases were discussed in this. Another one this also.
Police. From the learned council for cancellation of the transport. So in the first order, there is no mention about the.
That's why my lord.
Your lordship, may kindly see page 9, para 3.
Page?
Page 9, para 3. Brief facts that leads to petitioner to this
No,
court.
another order passed which was directing the petitioner to approach the concerned court and seek permission for this petition is moved for.
Para 3, your lordship, may kindly see. In para 3, page 9. Page 9, para 3, page 9. Brief facts that leads the petitioner to this court in the subject petition has borne out from the pleadings are as follows. The petitioner is in possession of an Indian passport bearing so and so. The petitioner becomes involved in a crime case in a so and so registered for offense so and so. In the said case, the B report police after investigation have filed a B report. The B report is pending consideration at the hands of the learned magistrate. The first respondent in terms of his communication dated so and so directed the surrender of passport within 21 days from the receipt of said communication. It is this communication that derives the petitioner to this court in the subject. Therefore, in that case, there was already a communication by the passport authority to surrender the passport. Here is a case, Lord, I am seeking for a simple mandamus to consider my representation. Since, Lord,
No, without going into all these, let us understand.
Yes.
What is the relief he is seeking.
Yes.
No, the crime.
Issue.
No, that is police have filed a B report.
Yes.
It has to be adjudicated by the court. No, at this point of time, he has no role to play, and court also cannot decide about any other things at this point of time, permitting him or not. Well, what is the jurisdiction of the court at this point?
This also same case.
But it is not where is
page 12, page 12. Page 12 ಅಲ್ಲಿ the learned single judge has opined petitioner as an accused, top of the page 12.
These facts are totally different. In this case, there is a direction by the
passport authority to surrender.
Because
that
there is
extent
expression of facts by the. Let us read paragraph number 8, at page number 11.
Yes, ma'am. Yes. The aforesaid narrated facts are not in dispute. The petitioner was in possession of a passport which had expired at the relevant point in time. A petitioner seeks reissuance of his passport on his expiry. On the basis of the document submitted, the respondent RTO reissues the passport in favor of the petitioner. Later, when police verification is done as a routine in every case, it's come to the knowledge of the respondent that petitioner is involved in a criminal case number so and so. Noticing the fact that petitioner has suppressed the factum of pendency of a criminal case against him, had secured the passport by any permissive petition, issued a notice directing him to surrender the passport. The involvement of the petitioner as an accused in crime number so and so is not in dispute. B report is yet to be considered by the learned magistrate. Therefore, B report being filed will not absolve the petitioner of the crime section 6 of the so and so reproducement. Hence, my lord, the conclusion order.
What are the orders passed on the B report?
No, according to my.
Is that accepted?
No, it is not yet accepted because I'll seek instruction in that.
Huh?
I'll seek instruction further.
Clear whether it is land council, the petition shall get specific instructions whether the B report is accepted by the magistrate or not.
Please.
Please.
Seal number 5, Sandeep Hosmat.
Yes. Huh. In 2016, there are about 44 matters are pending, and before that also there are so many matters pending on the file of this court.
My lords, the facts of the present petitions are that the petitioner one is the senior citizen of about a 63-year-old, and she is claiming family pension under Schedule A properties. My lord, since the family pension is considered as a crucial financial safety net and the form of livelihood to the dependents of the government servants, the present petitioners 1 and 2 are the legal heirs of the deceased Parashuram Kashinath Palkar. Even because of the inordinate delay in the legal proceedings, they could not claim it even after 10 years from the date of death of the deceased husband, my lord.
What is the relief you saw? Decree of declaration that plaintiff 1 and 2 are the legal heirs of deceased.
Deceased person Palkar, they are claim.
Decree of declaration declaring the gift deed dated 2011-2015 as null and void.
My
Where
lord,
is the pension and all other things?
my lord,
You're just so submitting about pension or something. Where is it?
my lord, in the play, annexure A plaint, my lord,
I am looking at your prayers only.
my lord,
Look at prayer at page 19.
my lord, since petitioners in the said original suit are claiming the family service benefits of the deceased husband of the petitioner one, and unreasonable delay in the legal proceedings, petitioners have filed the present petition.
It is not here in your prayer. What you are submitting is not what is the suit for.
My lord, my prayer is not with respect to merits of the case. My prayer is only to
Understood.
issue direction,
That I understood.
whatever may be the merits, my lord. I am seeking the petitioners are seeking the direction from this honorable court to issue necessary direction to adjourn.
The Honorable Supreme Court said that is not for the High Court to direct the trial court how to decide the matters unless and until there are exceptional circumstances. That's why I called for the report. There are so many matters of 2000, much older than that. The matters from 2008 are pending on the file of that court. That is the way I am trying to understand. If I have to give a direction, what is the exceptional nature of this case? You must have seen the latest judgment of the Supreme Court on this. Mandamus is not a matter of routine to the courts. So that is why all these
My lord, in
efforts
that
is made by the
respect,
court.
my lord, in that respect, my humble submission is that considering the relief claimed by the petitioners in the said original suit under Schedule A properties, they are seeking the service benefits, that is family pension. My lords, even after 10 years, they could not claim the family pension, which is considered as a form of livelihood to the petitioner one, and she is the senior citizen, my lords. And
The present petition is filed, seeking a mandamus, directing the third additional civil judge Belgavi to adjudicate the original suit number 490 of 2016 at the earliest. It is a case that the petitioner is a senior citizen, aged about 61 years. The Honorable Apex Court has time and again has passed orders that the High Court in every case shall not pass an order to shall not issue a mandamus to the trial court to dispose of the matters, as it is for the trial court to decide the matters as per their board, unless and until exceptional circumstances. The court cannot pass any order. Hence, in that regard, considering the submission of the counsel for the petitioner, this court has called for a report from the concerned court. What is the pendency? The total pending cases suits before the court up to the year 2016 are about 137. Right from 1994, the matters are pending. And the latest in the 2013, there are 17 matters, 14, 15 matters, 15, 29, 2016, 44. In the light of this court cannot fix any timeline to the court to dispose of the matter. However, considering the case of the petitioner, who is aged about 61 years, this court is passing the following order. So and so is requested to expedite the hearing of so and so.
Please.
Number 6, Girish Sharma.
Yes.
Lord, this is defendant's writ petition. Before proceeding, my lord, I must place on record, my lord, this matter was listed before my lords on the previous occasion. And in fact, my lords had also granted a stay. But then, my lord, I found out that, my lord, the appeal was disposed
Order is
of.
also typed
Yeah,
and kept
it
in
must
the-
be there, my lord. Later on, I clarified that appeal had been disposed of. Appeal is disposed of, my lord, for the reason of death of the original defendant, that is my father. What had happened is, my lord, initially the ADLR,
That order remains to be there. That order is not interfered with.
the petition.
For the fact that it is, the applicant is.
No, that's why it gains importance is for this in now the trial. But it is also in Kannada, my lords. The trial court, my lord, dismisses my application for appointment of court commissioner.
View that order, there is an order in the proceeding sheet, there is an order.
Interim order on
No,
dictate ಮಾಡಿದ್ರು.
an order must be there in the file. In this case, I have already passed an interim order earlier. They have typed and kept it.
The trial court,
Ask Megha. We'll see tomorrow. Business matter tomorrow. And tell her to keep that order copy in. Yes, 7.
please.
7, seal number 7.
My father holding the fair price shop, my lord. After his death, I filed application for the transfer of the shop. On the basis that the father of the petitioner died in the age of 70 years. As per this circular, the only age character is 65 years. So my application was rejected. For the first time, it is listed, my lord.
Not listed for the first time.
Yes.
Why it is wrong? Why that?
On the
No, contrary to their guidelines, they can't grant you.
Yes.
Why should they consider? You should tell the court. For that, no instructions are required.
I have not played any interim order also, my lord. Only my application rejected on the ground. Next, my father died in the year.
Seen that?
Yes.
As per the same, if you are required, if the license has to be transferred to you, the father shall be of 65 years.
Yes,
As you
at
should
time
not
of death.
have completed the 65 years of age, is it? And about your 10th class or something, is
Yes,
there? As
yes.
far as the 10th class is
Yes.
concerned,
13.
some orders are there.
3.
As far as the 65 years of age is concerned,
3.
there are no orders.
Yes.
And I am not inclined to grant any order. That is, on the face of it, what they have done is right. Why should we entertain the petition? That I am not able to understand.
To the.
That is the court. Business matter on Monday. Yes, next.
16. Seal number 8, urgent. Seal number 9. Okay, Kulkarni. Kulkarni.
Yes. No representation list after COVID. Is 10.
Seal number 10.
The petitioners are the employees of a society, my lord. That is respond number 1 society. The
Come to the prayer first.
it is at page number prayer is at page number, my lord. 9.
Quash the impugned order dated 21/11/2025.
That is annexure D, my lord. JRCS, that is respondent number 2, my lord.
Or what is the order passed?
I filed an application that is under order 1 rule 10 to implead some of the parties who are left out, against whom the FIR was registered for misappropriation of funds of the, that is society, my lord. While the inquiry was held under section 64 of the provisions of the act.
Under section 64.
Yes, my lord.
Basing on the inquiry report.
Yes, my lord.
these
Section
such
69 proceedings are initiated, my lord. Yes, I filed an application, my lord, stating that those persons' names are also appearing in the FIR, and those persons are also the proper and necessary parties for adjudication under section 69. That application was rejected, my lord. And reason assigned by the JRCS was that, my lordship, since under section 64 inquiry, when inquiry was held, they were not the parties to the proceedings. So those, for the said reason, application was rejected. In my submission, my lordship, since FIR was registered.
Oh, that is correct. What is, why the, no, this proceedings are initiated based on a inquiry report.
No, initially they filed a complaint that is for misappropriation of funds, my lord. And in FIR, the names of all the persons who.
Please take the court to the order. Where is the order?
But that was the only observation made by the court, stating that during the.
That is correct.
Section 64, the names of the persons who are to be impleaded are not read as, that is, parties. So at this juncture, they cannot bear it. In my humble submission was, since initially FIR was registered by the very cooperative society against those persons, my lord.
Look at the provision, what it says. Let's look at the provision.
No, provision as such is concerned, section 64.
But I am saying what the second respondent said is correct. 64, let's see where is the inquiry and what, under which provision these proceedings are initiated. They will be initiated based on an inquiry report.
No, they are making a discrimination against the other persons, even though a complaint is filed and FIR is registered against those persons, my lordship. Intentionally, they are left out with no, that is, and in very inquiry which was held under section 64 is also discriminatory. my lord.
Raise all your contentions before the authority, then if they feel that they will do that, like again, they'll say another inquiry to be conducted and he might set aside this inquiry also.
When 16 proceedings are initiated, where's the
On your own, that they should be.
respondent number 2 is of the opinion that since their names are not appearing in the inquiry, that is proceedings, though they cannot be arrayed as party in under section 69. In my humble submission, basic that is ingradient is that when FIR is registered,
Respond, I'll issue notice, but no interim order.
please.
Notice to the respondent.
Please. Respondent number 2 is represented by the state, my lord.
Respondent number 2, so and so takes notice.
Yes.
In all the matters, wherever they take notice, objections within 15 days, or else right to file the objections of food forfeited. 15 days. Yes.
Seal number 11. Vidyavatyam Corporation.
I am filing the date of events.
Number 11, kindly pass on. Officer is on the
Because,
Furnishing will translated.
Today afternoon, no passovers are possible because I'm taking up other matters.
List on Monday.
List on Monday.
Please.
Yesterday, our lordship told me that date of events I notes, my lord. I will file it in the registry, sir.
Seal number 12. Patil Balangoda, Pasaheb.
Is no representation after 4 weeks. Just 13.
4 weeks. Seal number 13.
May I seek next week.
Talavari Vidyashankar.
Why?
Lords, connected matter is posted next week, Lords. Similar.
Speak one matter adjournment. You will
No,
say connected matter.
there are,
posted,
Lords,
next
3
week.
matters, Lords.
That's not right.
Next week,
To the matter, then why are you filing the
Lords,
matter?
next week I'll argue, Lords. Please,
This is a matter on Tuesday.
please. I'm sorry, Lords.
14, my lords.
Seal number 14.
For the petitioner, my lords. It is under Surface Act, my lords. I'm seeking parties ready to deposit 25% of the amount, my lords, because
No, I will not entertain writ petitions like that.
My lord.
First of all, why are you before this court?
please,
Number one.
please. The order may kindly be perused.
This is a possession notice.
Please, my lords.
What is wrong with issuing the possession notice?
My lords, before that, page number 40 may be perused for a moment. 40. It is annexure G, my lords, wherein it clearly states that IndusInd Bank has secured the order, my lords. IndusInd Bank. They have secured the order for Surface, my lords, under 14. And now the possession warrant is issued by India Bulls. They do not have any locus to issue a notice because they have not even come up. They have not even come up or given a notice to us, my lord, saying that this is totally shifted to them.
What will
First thing, my
happen
lords.
is, when it is given to the asset reconstruction company,
Please.
they will step in from that stage, not that they should start from the beginning.
Yes, I completely agree, my lords. In fact, all other brothers and also the wife was made a party and they have
I
sent
will
a
interfere
notice.
in this only if you are ready to clear the amount and an undertaking, nothing else, or else you go to the DRT. We will not entertain the writ petition.
I'm ready, my lords. I'm not saying I'm not ready.
Ready for, then file an
Payment,
undertaking approval.
payment, but only reason, my lords, my 6 acres of land is already been sold. I have come up with an agreement to sale. They have not given me the amount, so it has not been registered, my lords. The moment it has come to me, I am ready to conclude the matter. And the matter,
To understand, that's not the scope of the writ petition, and we cannot. You have seen the judgment of the Supreme Court time and again, how Karnataka High Court is interfering in surface matters. The Supreme
Please,
Court has heavily come down.
please, my lords,
Because when the separate tribunals are constituted, one is supposed to go there.
please, my
No, we are, I am, as far as I am concerned, I'm entertaining on the limited ground. You file an affidavit seeking some time. That is the only accommodation. Otherwise, there is no business to this court to interfere in this
I'll file the necessary undertaking as well, my lords, please.
matter. Next Thursday. At the request of non-counsel, the petition.
Oblige.
Seal number 15.
Yes.
I am for the petitioner, who is a superintendent of police, my lord, for the apprehended threat to his life, my lord. He has availed a weapon license in 2005, my lord.
Let us see what is the relief you are seeking. Come to the relief.
Your Honor, my weapon has been, the renewal of my, sorry,
Requires the improved
The application for the
endorsement
renewal has
passed
been.
by the respondent number 1.
Yes, my lord.
Authorities to return the weapon which is seized to issue renewal license.
My weapon has been seized
And
by
who is the second?
the
The Commissioner
authorities,
of
my lord.
Police. Yes.
This, my lords, it was not issued on the ground that much. He has aged about 73 years.
71
73 years.
my lord.
71 years. And overaged, my lords.
No, what is this endorsement dated 12/1/2026?
Please. Endorsement with annexure A, my lords.
What it says?
That says that, my lords, since under the section, since he has aged about 71 years, license cannot be issued against because.
Give that. Give the.
My lord, there is
Arms
a.
Act.
Which provision?
Under section 15 of the 15(3) of the Minutes Act.
15(3).
Yes. Arms Act.
1 minute.
Yes.
Every license shall, unless the licensing authority for the reasons to be recorded in writing, be renewable for the same period of which the license was originally. Where do you get that? In 15(3) speaks about renewal.
But doesn't say about the age, my lords. Since he is unfit because of his age. And section 14(3) says, my lords, 14(3), 14(3), my lords. To be for reason unfit for license under this act.
Where do you get that?
Section 14(3), my lords. Refusal of licenses.
A license under subsection so and so.
Yes.
Such license is required in respect of any prohibited arms. Where such license is required by person whom the license authority has reason to believe to be prohibited.
1 and 2 is not applicable. My lords, subsection 3 says, is unfit because of age. He is aged about 71 years.
Huh?
He aged about 71 years. My lords, he was previously was superintendent of my lords police, and also on the ground that he was not having life threat. On 2 grounds, my lords. One is he is overaged. He is having age of 70.
The license given to him.
Initially,
Till
license.
24, my lord, the license was renewed. In 25.
When was it given to you? When was initially?
2005, my lord.
license?
Till 24, he has.
When did you retire?
In 13, my lord.
2013.
Yes, my lord.
Now he is 71 years.
My lord, he has already produced.
Is it basing on the age you rejected?
My lords, the section 14(3) says he is unfit.
It is, you can't take,
Yes.
you can't take something like, it says unfit for a license.
Because of
My
his
lord, we
safety
have
also, my
produced
lords,
the-
he can mishandle, my lords.
Huh?
Maybe because of his overage. It may be.
That is neither you can supplement the view of the authority by in this order. He should say that.
Yes.
He should say that categorically what it is, not like this.
Yes.
When 15(3) says there should be a reorder based on some reasoning.
Yes, my lords, unless otherwise he is, because of keeping in his age also, my lords, taking welfare of
I will
his,
set aside this order and I'll direct them to consider and
Because,
pass appropriate
reasonable
orders
orders.
in accordance with the law by giving the reasons.
Yes.
My lord,
Yes.
it is covered by judgment where the.
Don't tell me this covered judgment.
Yes, my lord. We have produced the medical records also, my lord.
Huh?
We have produced
That's
the.
not, you like, you will consider it
Yes, ma'am.
in accordance with the law.
Yes, ma'am.
Yes. The present petition is filed, seeking the following prayer. The case of the petitioner is that the petitioner is a retired superintendent of police and who is presently practicing educatively. During his service as police officer, he has come across many notorious criminals, communal gundas, murders, terrorists. Among these, many were arrested and many were convicted. Hence, the petitioner is having a threat of life and safety for himself and his family members. The petitioner, during his service as police officer, had obtained the arms license for weapon after inspection and training conducted in accordance with law. That is on 31/3/2006. Later, after the retirement from police department, the petitioner shifted to Hubli and resided in his own house with his family. And he retired in the year 2013. And his license has been renewed from time to time. Earlier, Later, the petitioner transferred the arm license from Additional District Magistrate, Deputy Commissioner Bidar to Hubli. And the last renewal was in the year 2024. On 2024, the petitioner submitted an application to respondent number 2, seeking renewal of the license for a period of 5 years for his weapon. On 6/5/2025, the respondent number 3 seized and deposited the weapon in Gokul Road Police Station and gave a receipt to show that the petitioner is and gave a report. On 28/2025, during the inquiry, the petitioner submitted his detailed statement and medical fitness certificate to show the petitioner is physically fit during the inquiry of renewal of the licensing by the respondent number 3. The respondent has passed the order before this court dated 12/1/2026 without considering the detailed statement and medical fitness certificate, rejected the application for renewal of the arms license on the ground that the petitioner is 71 years of age and therefore there was no threat to the life of the petitioner, warranting renewal of the license. So, and accordingly rejected the same. Land counsel appearing for the petitioner submits that, considering the fact that the petitioner worked as a superintendent of police and the life threat he has was not considered. Further, with regard to his physical fitness, when the certificates are submitted before the respondent ought to have considered it, and while passing the order, he should have stated on what basis the petitioner is unfit for issuance of license as per section 14(3) of the Arms Act, Arms Act 1959. It is submitted that the order that is passed by the respondent is bereft of reasons and without application of mine. Next part, Leonard AGA
Appears for Arun to
takes
R3.
notice.
Appears for Arun to R3, my lords.
Takes notice on behalf of respondents 1 and 3. It is submitted that considering the age of 71 of the petitioner, and there is no requirement, there is no threat, the respondent has rightly rejected the request for renewal and there are no reasons to interfere. Having heard so and so. The petitioner is a retired superintendent of police and he is having a license from the year 2006, which is annulled up to 24. Now, by way of impugned order, his request for renewal is rejected on the ground that he is unfit and there is no threat. As far as his fitness is concerned, he has placed the medical reports. In the order impugned, there is nothing forthcoming. And even as per that, there is no threat to his life. Basing on what such a conclusion the respondent has arrived, even on that count also, there is no reasoning. Section, before going into the merits of the matter, it is appropriate to look at section 14 of the Arms Act, which deals with refusal of licenses. And refusal for licenses, extracted. As per according to the AGA and as per the impugned order, he is unfit. When an order is passed under the provisions of an act, the order should disclose the reasons. In this, the order impugned is bereft of reasons, and the same needs to be set aside. Accordingly, this court is passing the following order. Look at the period. So and so is set aside. And the next number 2, the respondent, which respondent it is to, the second respondent shall consider the case of the petitioner for renewal of the license in accordance with the Arms Act and the rules laid thereunder, And the order shall contain the reasons either for, if in case, if the respondents are rejecting the case of the petitioner, the order shall contain the detailed reasons accordingly disposed of.
Next, seal number 16, Rajshekhar Burji, Jagdish Patil.
But, the petitioner herein, my lord, is an impleading applicant to the suit, my lord. The application came to be rejected, my lord, saying that he is not a proper and necessary party.
What is the suit for?
Suit is one for partition and separate possession.
Who is the third party?
Yes, ma'am.
Who is the third party?
But third party is a society, my lord, registered under the provision of Society Registration Act. My lord, the defendant number one, my lord, was the father of the plaintiffs and other defendants. My lord, admittedly, my lord, the defendant number one, my lord, was a Swamiji of a mutt. He was running religious institutions, my lord, and he was taking care of the other religious, spiritual, and other offices also, my lord. And all the properties, my lord, were self-acquired property of the defendant number one, Swamiji. And these properties were purchased, my lord, by the donation given by the devotees and the contribution of the devotees. Admittedly, my lord, there were no properties standing, ancestral properties standing in the name of defendant number one, Swamiji, even before he go into the spiritual life or to the subsequent, my lord. Now, my lord, the very strange is that, my lord, the society is registered, my lord, under the Society Registration Act to carry on the religious and spiritual functions, my lord. The defendant number one, Swamiji, was the president of that society.
When after becoming Swamiji or before becoming?
After becoming Swamiji. And my lord, the society was registered and he was the president of society. On 29/11/2025, my lord, the Swamiji executed a will in favor of society. Bequeathing, there are more than 47 properties, my lord, in Karnataka and Maharashtra, other states also, my lord. Bequeathing the properties in the name of society.
He is very much alive.
No, that is the crux of the matter, my lord. 29/11/2025, my lord, he executes a will, my lord, in favor of the society. 2025. And the plaintiffs, my lord, were aware of the execution of the will. Because on the pleadings, my lord, in the plaint, my lord, they say that, my lord, the defendant number one is intending.
And then number one is before the court.
But
he is executed. He has executed. the
now,
will.
my lord, now
will come into play once the person
yes,
is no more.
yes, my lord. My lord, the plaintiffs, my lord, filed a suit for partition and separate position
Defendant will say
on 2/12/2025. 2/12/2025. My lord, the suit summons was issued on 3/12/2025. The Swamiji defendant number one expired on 4/12/2025.
4/12/2025.
My lord, when the suit summons was issued on 3/12/2025, my lord, the next date of hearing was 15/12/2025. My lord, on 9/12/2025, my lord, the plaintiffs, my lord, delete the name of the defendant number one, saying that, my lord, since Swamiji is no more, defendant number one is no more, they delete the name of defendant number one, and they file a application saying that the plaintiffs and defendants are the only legal representative of Swamiji, and suit is compromised on 9/12/2025.
9/12/2025.
Without mind, the defendants, my lord, suo moto or voluntarily they appear before the court and the compromise petition is filed. And the very next day, my lord, the society, on coming to know about this fraudulent act of the plaintiff and the defendants, my lord, filed an application, my lord, I number 6, my lord, to implead in the suit, my lord.
Where is the suit?
And next, my lord, an application under Order 23, Rule 3.
No. Where is the suit?
My lord, that precisely, suit was not pending, my lord, but an application.
What is the remedy available to your party?
Not the remedy is, my lord, to file an application under Order 23, Rule 3. An application to under Order 23, Rule 3, my lord. That application was also there on record, my lord, before the court will.
Their right to property or whatever it is, their partition is decided, they have compromised.
No,
No, according to you.
yes.
You are the.
Legatee under the-
Swamiji has executed a will in your favor.
Yes.
Now, by virtue of the will, whatever rights that flow, you have an independent remedy to question it. Even if those properties which are compromised, and if you are successful in proving the will, what will happen?
My lord, that is one aspect. My lord, an application under 23 rule or 23 rule 3 is maintainable, my lord. Because the,
Oh, I understood the background, come to the order. We'll
yes,
read the order.
yes,
The court said.
yes. My lord, the code below, my lord, the impugned order, my lord, annexure A, my lord.
Page number?
It starts from page 24, my lord. The relevant para, my lord, is para 16 in page 33, my lord.
Let's read.
May I read, my lord?
Para 16.
Yes.
Please read.
Here in this case also, the plaintiffs and defendants are brothers and sisters. The proposed applicant is a stranger to the plaintiffs and defendants. Moreover, as on the date of filing of the present petition, no such suit is pending between the parties to adjudicate the matter by this court. The plaintiffs and the defendants already settled the matter amicably by filing a compromise petition under Order 23 Rule 3 of CPC. If no suit is pending as on the date of application, nothing remains to adjudicate upon rights of the parties to the suit, nor question arise to court without impleading him. An effective decree cannot be passed. Moreover, the document filed by the proposed applicant reveals that on the basis of alleged will executed by Danaya Matava, that is defendant number 1, they have filed a petition seeking probate before the Honorable District and Session Court at Athani, which is pending for consideration. Further, under compromise petition, the plaintiffs and defendants are not at all divided the suit properties. Under the compromise petition, the plaintiffs and defendants entered their names jointly in record of rights by deleting the name of the deceased defendant number 1. Further, the decree obtained by the legal heirs of deceased defendant number 1, that is plaintiff and defendants, it cannot be reopened or remanded at the instance of proposed defendant number 14, who is claiming under will, unless he establishes a strong prima facie legal right through the strict proof of the will's execution and attestation. In the absence of such proof, the court will not interfere with settled rights of the plaintiffs and defendants herein. As already stated above, if the proposed party acquired the suit properties under a will, he has got right to prove in accordance with law. Under these circumstances, the applicant is neither proper party nor necessary party to suit, and there is nothing remain to adjudicate the matter, nor no such matter pending before this court. Hence, at this stage, impleading applicant as a defendant number 14 does not arise at all. If the applicant Sangha has got right over the suit properties, and the rights of Sangha denied by the plaintiff and defendants, the Sangha has to file a suit for declaration and get rights over the properties in accordance with that.
Yes.
Hence, next para 17 also.
I've seen that.
Para 17 is.
Yes, I've read.
The learned counsel for the proposed defendant number 14 relied on 14 ruling of the Honorable High Court of Karnataka, Honorable High Court of Bombay, and Honorable Supreme Court of India. Almost all rulings cited by the learned counsel in respect of party disputing about awareness of contents of compromise and decree is alleged to be fraudulent. Such decree can be determined only by the court which passed such decree. Here in the case, the proposed applicant is not a party to suit, nor it is their contention that compromise decree obtained by playing fraud upon him. Therefore, due respect to the facts of the judgment cited and facts of the present case are entirely different, and therefore they are not at all applicable to the present facts of the case. Under these circumstances, I am of the considered opinion that the applicant not made out grounds to implead as defendant number 4 in this suit. If the applicant not made out a grounds to allow IA, the other IAs filed by the proposed defendant under IA number 7 filed under Order 23 Rule 3 CPC prior to set aside compromise decree order dated 9/12/25 and staying compromise decree as prayed does not arise. My Lord, may I request, my Lord, the remedy, my Lord, I cannot maintain a separate suit, my Lord, in view of bar under Order 23 Rule 3B. Or, my Lord, I can file an appeal under Order 20 under Section 96(3). Notes may kindly see Section 96.
Seriously, you want to make a submission on that?
No, I'll just bring to my Lord's notice. Not I just.
No, if it is not a serious submission, let's not waste the time.
No, but this honorable court, my Lord, had an occasion, my Lord, whether a stranger can file a separate suit or
Here,
can,
your right to the property is not at all crystallized. It will be crystallized only after you prove the will. So now a party who is supposed to be a party to the proceedings,
yes,
one of the family members, they come up with this thing, we can understand.
yes.
You are saying that I have by way of so and so the rights are flown to me. That has to be established.
Yes, that is
Your
decided.
hands are
Definitely,
not tied.
definitely.
Your hands are not tied. Go before. Now, by virtue of this, only because our father is no more, the properties are now in the name of the children. Nothing when
My
there
lord,
is no other compromise.
the very intention, my lord, of these plaintiffs, my lord, is they said, my lord, once the father
You
is,
can seek injunction restraining them from alienating the
no,
properties.
that application was, my lord,
in your suit, not in this. The court was perfectly right in dealing with it.
once, my lord, the defendant number father died, my lord, they have deleted the name of the father, saying that they are the only legal representative. My lord, here is a case, my lord. The legatee, my lord, under the will, my lord, is a legal representative, my lord, under section 211 of the CPC.
No, according to you.
Yes.
According to you.
Yes.
That will has to be proved. If it is you are a will, you are that is not a partition suit. In some other suit, you are saying that you are a legatee for the purpose of the under order 22 rule 3 compliance. You will be representing the estate.
Definitely,
not in
my
these
lord.
circumstances.
My lord, to that aspect, my lord, I am not disputing. But whether an application under order 23 rule 3 is maintainable or not, my lord.
No, I will know. I'll dictate the order whether it is maintainable.
No, I'll just bring to my lord's
Yes,
notice.
give the judgment. If you are relying
Wherein,
on
my
something.
lord, this honorable court had an occasion, my lord.
Yes.
My lord, the right from 1960s onwards, my lord, the Supreme Court has held, my lord, that remedy available to the parties to the proceedings, my lord, to a compromise decree is to approach this court, my lord, which has passed the order. My lord, there are divergent views, my lord, whether a stranger can also file an application under order 23 rule 3 and other, or he can maintain a suit as my lord suggested, my lord. Now, my lord, this honorable court, my lord, had an occasion, my lord, wherein, my lord, a suit was compromised between the respondents in the.
What is the suit for?
Suit was one for specific performance of contract.
Specific performance.
Yes. So the suit was compromised between the respondents in the said case. My lord. The petitioners before this honorable court, my lord, they filed a writ petition calling in question the compromise petition.
According to them, who are they?
They were also the family members of the respondent number 1. So, my lord, considering all the judgments, my lord, cited by the apex court and this honorable court, my lord, this honorable court, my lord, has come to the conclusion that even a stranger can maintain an application under order 23 rule.
Yes. Please come. Agreed with
But, may I make one more submission?
Which paragraph you're relying on? I will extract it in order. Paragraph number?
Para 17, 18, my lord.
17 and 18.
19.
Yes, 19.
20, 21, my lord.
20 rows, right on.
And the operative portion is at 24 and 25.
24 and 25.
Yes. My lord, may I make one submission, my lord? My lord, since, my lord, this application is rejected, my lord, and my application or also the court has observed that will not arise for consideration. My lord, my hands should not be tied, my lord, just because of this order, my lord. Because the remedy.
Nothing is tried. Court
Yes.
was very clear.
No, my lords,
You have so many remedies under law. Please avail it. Why do you want to?
My
harp
only
on this?
the reason, my lord, the petitioners are before my lords is, since, my lord, they are a stranger to the proceedings, they can maintain an application under order 23 rule 3 is my humble submission.
That is what now we will deal with that. The agreed with the order passed in. I number 6 in OS number 376 of 2025 dated 2nd February 2026. The third party is before this court. The respondents herein has filed a suit for partition and compromised the same.
Number respond number 1 and 2, my lord.
1 and 2 has filed a suit and compromised the same. The defendant number 1 in the suit died during the pendency of the suit. and later defendant number one's name is deleted, and the respondents herein, who are the plaintiff and
Defendants.
defendant, have compromised the suit. It is a case of the third party that the defendant number one in the suit has executed a will in the favor of the third party, and he is a proper and necessary party to the suit, and he should be made a party. Accordingly, he has filed an application under
IA number 6, my lord, is filed under order 1 rule 10.
Order 1 Rule 10. And
And
according to
IA number
him-
7, my lord,
And, and according to him, under Order 23 Rule,
3, my lord. IA number 7 is filed under order 23 rule 3, my lord.
Order 23 Rule 3. He is entitled to come on record, though he is not a party to the suit, and he can question the compromise decree that is passed. Along with that IA, he has filed other IAs to set aside the compromise decree, and other consequential reliefs are sought. The court, by order impugned, has dismissed the case has rejected the application that is filed by the petitioner. While rejecting the application, the court has observed that the plaintiffs and defendants are brothers and sisters. The proposed applicant is a stranger. Moreover, on the date on the filing of the petition, no such suit is pending between the parties to adjudicate the matter by this court. The plaintiffs and the defendants already settled the matter amicably by filing compromise petition under Order 23 Rule 3 of CPC. Moreover, the documents filed by the proposed applicant reveals that on the basis of the alleged will executed by D1, they have filed the petition seeking probate before the additional district and sessions judge at Athni, which is pending for consideration. Further, under the compromise petition, the plaintiffs and defendants have not at all divided the suit properties. Under the compromise petition, the plaintiffs and defendants entered their names jointly in the records of rights by deleting the name of deceased defendant number 1. Further, the decree obtained by the legal heirs of the deceased defendant number 1, that is plaintiffs and defendants, it cannot be reopened or remanded at the instance of proposed defendant number 14, who is claiming under will, unless he establishes a strong prima facie legal right through the strict proof of the will's execution and attestation. In the absence of such proof, the court will not interfere with settled rights of you're relying on any judgment?
No, Your Honor.
Settled rights of the plaintiffs and defendants herein. If the proposed party acquired the suit properties under will, he has got right to prove in accordance with law. Under such circumstances, the applicant is neither proper nor necessary party to suit, and there is nothing remain to adjudicate the matter, nor no such matter pending before the court. Hence, it is not the court is not inclined to allow the application seeking impleadment. The proposed party had relied on the 14 rulings of the High Court of Karnataka, Bombay, and Supreme Court. The court observed that almost all rulings cited by the counsel in respect of the party disputing about awareness of contents of compromise and decree is alleged to be fraudulent. Such decree can be determined only by the court which passed such decree. Here in the case, the proposed applicant is not party to the suit, nor it is their contention that the compromise decree obtained by playing fraud, etc. upon him. Hence, the said judgments are not applicable, and accordingly, court had dismissed the IA. When counsel appearing for the petitioner, the third party, submits that he is a proper and necessary party, and in the light of the settled law that any judgment is obtained by playing fraud, a party can approach the very same court. In the light of the same, he can come on record under Order 23 Rule 3, and also as such he has filed an application under Order 1 Rule 10. The court, without considering whether the petitioner being a legatee under the will can be brought on record as can be impleaded can be impleaded and without even considering the judgments that are relied on by the petitioner, had dismissed the application. He had relied on a judgment of an order passed by a coordinate bench of this court in WP number 202339 of 2025 arising in case of Venkatesh Bandinwar and others versus Lakshmi Bai and others. He had relied on paragraph number, you have written, no? Extract all those paragraphs. He has also relied on the judgment of the apex court in Trilokinath Singh versus Anirudh Singh, reported in 2026 SCC 629. Which paragraph?
Lord, para 17 and 22, my lord, in Trilokinath.
Para 17 and?
22 of Trilokinath.
Para 17 and 22, extract.
And my lord, in Mukund Bhavan Trust and others, my lord, para 17, my lord, their lordships.
Not given the judgment.
Their lordships have extracted the same.
Which para that is?
Yes, that is para 39, my lord.
In this case?
Yes.
No, in Justice Aru's judgment.
Yes, their lordship.
That is that you have
Yes,
already
yes.
said. Land counsel appearing to the respondent submits that the court had rightly considered the application that is filed by the petitioner in Order 1 Rule 10. And in the facts of the case, wherein a suit for partition, when the family members have compromised the same, and now when he is setting up a title to the property basing on a will, as he has a remedy of filing a separate suit, the court has rightly dismissed the application, and there are no grounds to interfere. Next part. Having heard so and so. In a suit for partition, the D1, the father has right. The parties have filed a compromise memo stating that in the name of the deleting the name of D1, their names may be entered into the revenue records. Further, the D1 is no more and all the legal heirs are on record. The suit may be, accordingly they have entered into a compromise decree. Whenever the party alleges that a particular compromise decree is obtained by way of a fraud, where they have to go before the very same court and seek the relief, and they cannot file a separate suit. In this case, the petitioner before this court is not a party to the suit. According to him, the father of the parties, the father of the plaintiff, that is D1, has executed a will in his favor. He is asserting his right to the property basing on a will. The petitioner is not precluded from filing a suit whereby he has to seek a declaration that he is the owner of the property by virtue of the will that is executed by D1. And for that, he has to prove the same. Now, in this case, in the compromise decree that is passed by the court between the family members, the petitioner, who is a third party, who asserts his right by way of a will, is not a proper and necessary party. And under Order 23, Rule 3, in the facts and circumstances of this case, he cannot be impleaded as a party. The trial court, by way of an elaborate order, considered all these aspects and dismissed the petition. Hence, this court finds no reasons to interfere.
Right.
The court has also left all the remedies that are available to the petitioner. In that view of the matter, this court finds no reasons to interfere. Accordingly,
So the observation made by the learned single, the court below, my lord, and this honorable court shall not come in there.
what is that it has been?
Since he has held, my lord, that application is not maintainable, does not arise for consideration also.
Correct.
The observation of the
No,
learned.
no, it says it is not. That is what I have confirmed.
No.
That I also said it is not maintained.
My lord, liberty, my lord, the liberty to.
Liberty is not to file an application under Order
No.
23, Rule 3.
My lord, my humble submission is, my lord, liberty to approach the appropriate court, my lord, in.
That the court already said what it said.
No, court has not said.
Therefore, with the facts of the judge so and so, I am of the opinion that the applicant not made out so and so. No, where some para it has observed that you have a right. At this stage, impleading of applicant as defendant number 14 does not arise. If the applicant has got right of the suit properties, the right of so-and-so, has to file a suit for declaration, get the rights.
My lords may clarify, my lord, otherwise that will not come in.
The court has, I said that the court has already said he has a remedy. Hence, the writ petition is dismissed. However, the petitioner is always at liberty to avail the, as he always at liberty to agitate his rights before an appropriate forum in accordance with law.
Great.
Number 17, Vijay's category.
Regarding the state amendment of CPC. State amendment of WS. Lord, amendment,
That amendment only applies to the commercial courts.
yes, but it is for even for general suits also. Now, my lord, yesterday
When once,
but
there is an amendment which says when there is no discretion left with the
court, yes,
we cannot deal with it.
yes.
You have
Allowed
to- Now you have to question that.
valid,
amendment to-
constitutional validity. Allowed, there are some other petitions are to be filed.
I have already dismissed several orders which have come up before the
Yes.
court because no discretion is vested with the
Yes.
court. Unless and until the amendment to so-and-so is questioned, the validity of the amendment. We can't,
Even
the hands of the court are tied.
Even I came to know that even they have not sought a consent of the Honorable High Court also as required under the CPC.
So can you, in
Yes.
an appropriate petition, you can raise.
The Lordship
Then I will
notice,
return it-
notice may be ordered.
Notice to the respondents.
Yes,
and,
now my lord, yesterday matter was there. They recorded the evidence of PW 1, 2 and 3 posted for arguments of the plaintiff, my lord, on 10/3.
But we can't do what is not in the hands of the court.
My lord, emergent notice to the respondents.
Notice the respondent, list the matter once the notice is served. Yes,
Please.
18.
Still number 18.
My lord, I am for the petitioner here. The decree holder is before this honorable court for a limited relief, Lord. The decree holder, the petitioner has lent a loan, a hand deposit to the respondent sugar factory, respondent number 1 sugar factory, and they failed to repay the same. And an award was passed in the year 2015, and execution petition has already been filed, Lord. And the state respondent number 1 cooperative sugar factory has already been leased to a private entity. And the execution petition is pending. I filed an application seeking for attachment and everything. I filed an application seeking for the garnish order under Order 21 Rule 46 and 46A. And notice has already been served and they have appeared and judgment letter has also addressed his argument and everything. Only I have a limited this one that to direct the execution court to consider my application and dispose of that. I'll take a hand
When is the
summons.
application?
Application is annexure H, my lord.
When is it filed?
It was filed on 10/12/2025. my lord.
Then why should we give a direction? It is just
No, no,
recently
already,
filed.
no, my lord, already the even judgment letter has also filed a written argument. Everything is heard. The matter is being adjourned. That is the only thing is today. What has happened?
We can't give directions to the family,
No, no,
to
at
the
least
courts just like that.
No, no, I'm not seeking for a time bound. I'm only seeking for this one to consider and pass appropriate. What has happened, my lord? The lessee who has taken on lease this sugar factory is paying the rent regularly to the judgment debtor. And my amount is.
If there is a coordinate delay on the part of the court, at least we can understand.
Yes, my lord.
You file an application.
No, I
Not
will.
even at 25 end. And now you say that, no, that there shall be a direction.
No, no, my lord. Only thing is the application. Everything argument is concluded. Everything is concluded. The court is the only thing. It is posting the matter for further hearing. If they pass any order on my application, because more than 10 crores amount is the outstanding amount, my lord.
Notice.
So on the date may be fixed, my lord. I may be permitted to take hand summons also.
They put hand summons on the counsel appearing for the respondent. Shall file a memo. Once the memo is filed, list the matter.
Please.
Number 19.
Lord, here is
Order 19.
petition is a sugar factory. And as per the policy of the government, my lord, and we had set up an ethanol plant. And the respondent number 2 to 3 have entered into a long-term offset agreement with me, and wherein, based on my investment, my lord, they had agreed to take a certain quantity of ethanol every year. And that is at clause number 6.2 at page 33. And what has happened, my lord? They floated a tender.
12/20/25. Where is the representation?
Representation is that, my lord, page number 143. And this honorable court in a similar matter has already granted an interim order.
Let us see where, what is the representation?
Representation is at page 143. And I have submitted a bid for 35,875 kiloliters, and they have given allocation of 25,453.
Enhance the allocation of the supply of ethanol and meet the annual offtake quantity of so and so. Yes, who appears for the respondent?
Respondent number 1 and 2 is the central government, sorry, 1. 2 to 3, 2 to 4 is Mr. C.V. Angadi appears. And
Is this a corrected? No, the respondents are, to whom, to which respondent you have given the representation?
2 to 4, now. 2 to 4.
Huh?
2 to 4. Respondent number 2 to 4.
Indian Oil Corporation.
Indian Oil Corporation, Bharat Petroleum, and Hindustan Petroleum. These are the oil marketing companies.
Who are the councils appearing?
C.V. Angadi is the only. C.V. Angadi appears for all.
To all.
Please.
So, Mrs. Angadi is directed to take notice on behalf of the respondents. This is matter on Monday. Serve the copy on him.
Please.
Yes, 20.
Number 20.
Which is covered matter, not the petitioner has not submitted a proposal for circulation of to registration of new society. Like that.
Let's see what is the prayer you're seeking.
Not pray, not.
To quash the impugned order passed by the second.
Annexure B is the not impugned order. Petitioner has submitted a proposal.
What is the order passed by the second respondent?
Or the petitioner submitted a proposal for circulation of the registration of new society. That not the second respondent rejected my proposal, stating that not there are 4 societies there, not viability, not that already not. Annexure C is not my lord's order. This issue already not decided.
Annexure C in page 50.
Identical matter, not page number 50. Annexure C.
Same thing? Have you seen?
Yes, I have seen.
It is covered?
It is covered, my lords.
On the same ground he has rejected?
On the same ground.
Not viable?
Yes, on the same ground. In page 54. 54 of the my lordship's
The
judgment.
order I have seen, I'm asking you
Yes.
from the rejection.
Yes, it is same.
I'll record that your status of the then counsel for the present petition is filed, seeking the following prayer. It is the case of the petitioner that the petitioner is an agriculturist and permanent resident of Poganoli village. The government of Karnataka has taken a policy decision to provide financial assistance to the farmers who are the members of the primary cooperative societies without charging any interest. As such, the villagers have called for a Gram Sabha meeting on 1/8/2025 at Poganoli village, and in the said Gram Sabha, they have decided they have discussed about the financial aid given by the government to the farmers. And they have decided to form a society for the welfare of the farmers in the village who decide to become the members of the society. The petitioner was elected as the chief promoter. Then they have requested the proposal to the second respondent to grant permission for floating the collection of share amount from the eligible farmers for registration of the cooperative society. It is a grievance of the petitioner that the second respondent, without even hearing the petitioner, without considering the contents of the proposal, has rejected the proposal submitted by the petitioner, which is contrary to the provisions of the Act. He had relied on an order passed by this court in WP number 100232 of 2026, dated 13th day of January 2026.
It's para 3 of my lordship's judgment.
Para?
3 of my lordship judgment, which my lordship has just now referred. on the same similar set of facts. Para 3.
And he submits that this court at paragraph number 7 has observed as follows extract. It is submitted that in the light of the same order may be passed. Learned AGA submits that as it is covered by the order passed by this court in WP number 100232 of 2026. This court, having heard the counsels on either side, peruse the order passed by this court in WP number 100232 of 2026 and the impugned endorsement of the respondent. And considering all this court is passing the following order. See, this name of the respondent, this all will change. Look at it here. Yes.
Take notice for R1 and R2.
No, for appearance, my lord, any date no. 26 for appearance before the second.
What is the date?
Date is also
26, my lord.
When? 26?
26
Ah,
too.
26.
Grateful.
I take notice for R1 and R2.
R1 and R2.
R2.
Yes, next 21.
Till number 21. Rajshekhar Burji.
Lord, the petitioner herein, my lord, is a marketing committee, my lord, has called in question the order passed by the respondent, my lord, under the Payment of Gratuity Act.
What is the respondent?
Please.
Yes, 22. Similar
I
matter you
appeal
filed.
for the- I'm sorry, I
Yesterday,
appear,
my lord.
Yes, 22.
in 22, I appear for the petitioner's counsel. May I be
Yes.
permitted to point out first from the cause title who the parties are? The petitioner before the court is a generator of renewable energy in wind turbine, has and set up number of wind turbines across the state. Now, the grievance is that I have been given a government order permitting me to install certain wind turbines. There are regulations which require that there should be some space available so that when the wind turbine blades turn, there should be no obstruction. The whole grievance is respondent number 5 has, if I may pardon, the court would pardon this one, thrown caution to the winds and says, I don't care about you, and is trying to install some lines across that. That is what the grievance is. Obviously, if there is an electric line that is installed across where my turbine has to turn and the generation, and about the scientifically, there is some parameter as to how much space.
Who are the respondents?
I may just point out. Please be kind enough to take the cause title itself. State of Karnataka. The main state entity which has to do this is R2.
Notice on behalf of respondent number 1.
Please.
2 who appears, any counsel for 2?
There is a counsel, one Mr. Piyush Jain, who is the standing counsel.
So and so is directed to take notice on respondent number 2. 3,
3 and
Union of
4
India.
is Union government. I'll take my lord on the standing counsel if the court would permit.
Venkatesh Karvi.
So and so.
R5 is a private notice. I'll take emergent notice.
3 and 4. For 5, emergent notice.
I may request for status quo for this reason. In identical matters, status quo orders have been passed by this court. May I just show the court that? May I just show
We have to understand. We have to understand, hearing for the respondent, what is happening.
I bow down. Can I will point out. I have placed the photograph. I'm not shying away. I may just show the court.
I'll ask, no. Who is doing it? Which respondent?
I will show the court. Please permit me to show the documents, and thereafter, if the court still feels it should wait till notice, I will accept it. Please permit me to show the court. Please permit.
I'm asking which respondent,
Respondent number
is answerable to this.
Respondent 2 and respondent 5 are the ones.
Number 5, basing on a permission from whom?
That is my whole point. They don't have the permission yet. They need a permission under section 164. They don't yet have it, and still they're doing the work. That comes in interference with me. That is my whole case. That is my whole.
Pertaining to the state or the center?
No, this comes under the state. The permission under 164 is under the Telegraph Authority.
State, we will ask the state to respond. I get instructions on this. This is
Please, on the ground work is going on. Kindly protect me till then. In identical matters,
Monday.
state support has been granted. I will also not do it. Monday. I'm great. I'm great.
Get instructions by Monday.
My Monday, my lords, 18th,
Huh?
18, at least 1 week.
17th.
In that case, kindly protect me because work is going on the ground. I may also be
Let
put
me
to
see
search.
on that. Yes.
Very great.
You have to get instructions on that day, then I'll record it.
Yes.
Yes, 23.
P. Sharana Basava.
Lordship, I'm appearing for the petitioner, Your Lordship.
Lordship, in this matter, both the parties are ready for settlement, Your Lordship. They're ready for compromise, so it may be referred to mediation, Your Lordships.
It is submitted that the matter may be referred to the mediation. The parties shall appear before the mediation center at High Court Mediation Center.
Yes, sir.
On which date?
Any date may be given. Next week, any date may be given, Your Lordships.
On 19th?
Yes, sir.
Yes.
Much obliged, Your Lordships.
Yes, 24.
Number 24, Vinayak R. Bhatt.
My Lord, petitioner, I am a registered timber merchant, my Lord, and I have also a successful bidder in e-auction conducted by the respondent department.
This is 12% one.
Forest development.
It is similar orders at 12%. Yes, next, 25.
Dispose. Still number 25, P. Habballi.
Here for the petitioner. Application under order 38 rule 5 was filed by the plaintiff, and that is came to be allowed. That is attachment before judgment. Now, my lord, so far as my lord, the application was filed along with the suit. It appears he did not press that application. When the case was listed for evidence, he suddenly made a submission before the court that application is pending. Now that application, Lord, that copy was kindly see page 39. Lord, when the case was listed for plaintiff's evidence, page 39, Lord, the advocate for the plaintiff presented, submitted so and so is pending, hence prays to consider the same. This application was not served upon me. I was not called upon to file the objections.
Then let's see what the court says.
Now that application is allowed. Lord, my submission on the main is concerned. The suit itself is filed for recovery of 11 lakh, my lord. As against, my lord, your lordship will get, my lord, plaint.
Suit is of the year 23, which
Yes.
order is passed in 26.
Yes.
Then counsel appearing for the petition submits that the suit for recovery is filed in the year 2023. Along with that, an IA is filed seeking attachment before judgment. And the same was not pressed, nor it was served on the petitioner. And to the surprise of the petitioner, on 11/11, on 3/12/2025, the plaintiff has mentioned about the same. And by order impugned, the court on 22/1/2026 has passed this order. It is submitted that is contrary to the purport of it is contrary to the purport of order 38 rule 5. Considering the submission, they shall be stay of all further proceedings pursuant to the order dated so and so. Petition is permitted to take out emergent notice to the respondent and shall file a memo to that effect. If the memo is not filed by 3rd of March, the stay granted by this court stands vacated. Yes, next.
Still number 26, Afshan Shahbaz Khan.
My lords, this writ petition has filed to quashing the ballot paper along with the symbols dated 4/2/2026 passed by the respondent number 2, produced at annexure E2.
Quashing the ballot paper.
Yes, my lord. Symbols, my lords, the respondent number 2 election officer without any legal and valid grounds has issued the electoral ballot paper of election to the members of managing committee.
Everything I could is only there taking care. No, there is no mechanism under the act. Yes, Mr. Where is the AGA?
Serial number
26.
Quashing the ballot paper.
Please.
It's regarding.
Ballot paper.
This copy is not served on.
My lords, no, my lords, they are not the party in this case. This is regarding the Waqf, Karnataka State Board Waqf Tribunal.
Then who appeals for the buck?
Lord Khan appears.
So and so.
My lords, the matter is posted, election is proposed to be on 15th, my lords. Kindly.
Why did you come now?
My lords, in this case, they have done.
Without hearing the respondents, I will not grant any order. This is not the way the court functions.
My lord, kindly it may be kept.
To take notice. on behalf of so and so.
My lord, kindly it
The-
may be kept by Alsab, afternoon it may be here, my lord,
The
because
petitioner is permitted to serve the copy of the writ petition on the council.
tomorrow,
This is matter tomorrow.
please.
Your name to be printed?
Dear Lord Khan.
You will take notice. You accept notice?
Please.
Yes, so and so accepts notice, so paper
Please.
on him tomorrow, get instructions.
May.
Orders matters.
Date.
Seal number 27, tomorrow.
Please.
27, Mrutyunjay Saldikeri.
A memo is
What are the
filed
values?
stating that the update is more than 15 lakhs and the same may be posted before the revision bench. Registry is directed to place this matter before the revision bench.
My lord, may I request one date?
Huh?
Date, my lord. May I request date?
Yes. 28.
Seal number 28, Mahantesha Siremat.
So I may kindly permit to withdraw the petition minutes.
Take that. Memo is first seeking to withdraw the petition dismissed as withdrawn. X 29.
Please.
Seal number 29, Jagdish Patil.
Affidavit.
Pawan.
Please.
Yes, take the affidavit.
My lord, there is a direction to file an affidavit. Court officer.
Take that.
Yes.
My lord, now the principal secretary has filed an affidavit. Subsequent to that, my lord, he has narrated saying that
Have you seen?
Please, I've seen that. So I've gone through it. Well, my humble submission is now they are giving an affidavit undertaking that they'll complete the acquisition proceedings in 6 months. We are not before this honorable court asking them when they are going to complete the procedure. Manoj, our only please.
According to you, you are seeking a no objection.
Please, Manoj.
According to them, preliminary notification is issued.
Please,
and they are
Manoj.
going to acquire the land.
Please, Manoj.
The whole purpose of giving a no objection is that this property is not under acquisition. That is what I want.
Please.
When they were going to complete the acquisition,
Please.
and how can they give a no objection?
Please.
What I asked them, now either you don't acquire the land or you don't give the no objection. No, they said they will be completing it within 6 months.
Please.
So in the light of that, I have to record it.
Please, Manoj. It may be recorded, Manoj. My grievance is till today they
Then how will they give? Then I'll ask them to give you under the Right to Information Act, saying that they are not going to, this is under acquisition, so no objection cannot be granted.
no. Manoj.
See, you have to understand the legalities of it.
Please, Manoj.
You want, what is that you want from them?
Manoj, an NOC stating that the land has not.
Under the acquisition.
Please.
According to them, it is under acquisition.
Please.
And then what I said on the last occasion the matter came up, when the preliminary notification is issued in the year 2011, Till
Good.
such time, why are you keeping quiet? And how can you say that? It is under accusation.
Please.
No, they say that for various reasons it's pending, we are going to conclude it. At this juncture, can the court say, give them no objection?
No, my lords, a direction to.
You have to question those accusation proceedings,
I need
which
not
they
question.
cannot conclude.
No, my lords, I need not question. That's what the division bench of this honorable court has said. My lords, my humble submission is, in this case, there was delay in 14 years, my lords. In my case, it is 16 years. So since there is no bar under KIDB Act, my lords, reasonable time does not include 16 years, my lords. Reasonable time, which is something that can be considered.
Judgment this court cannot consider because the acquisition proceedings are not under challenge.
Please.
You understand that?
Even in this case, they were not under challenge, my
So
lords.
basing on this,
Please.
I think you're not understanding
My
what the
lords,
court
I
is
understood,
trying
my
to
lords.
say.
My lords, my grievance
For
is.
your prayer, they cannot grant when they say that they are acquiring it. You understand
Please,
that?
but my lords, at least they have to, an order to an effect that my application may be considered in accordance with law if it is
And
passed,
then
my
I'll
lords.
tell them, then if that is what you want, I'll record all this and I'll say, inform the same to the petitioner. That's what you want.
But my lords, now only to prevent me from converting my land into non-agricultural use, my lords, this affidavit they're filing, my lords.
Anybody can have an order from the court or any relief in accordance with law.
Please, my lords.
So what was the whole endeavor made by the court? You see, they are retaining they're not giving you no objection, nor they are going ahead with the acquisition proceedings.
Please.
No, they have filed this affidavit. You are aggrieved by it, you question it. And you can't have a positive order from the court.
Please, my lords.
Please come.
My lords, one more submission, my lords. So now, since they have undertaken to conclude the acquisition proceedings within 6 months, my lords, that may be noted, and an observation with an effect that if the same has not been concluded within 6 months, they have to issue NOC to me. If that is ordered, my lords, then
You should straight away come to that first.
my lords, my only grievance is, my lords, all these years they have troubled me, my lords. Now they come up with this affidavit.
Court is also aware.
That too, when this honorable court has come down very heavily on them from last 3-4 occasions, my lords.
That's how it is. It has come.
Please.
Otherwise, this also wouldn't have come.
Please, my lords.
So you should be happy with that. The present writ petition is filed, seeking the following prayer. It is a case of the petitioner that the petitioner is one of the joint owners of the agriculture land bearing RS number 31 and measuring 12 acres 4 guntas, situated at Mumigatti village, Taluka district, Dharwad. The land was originally a tenanted land and occupancy rights of the same were granted by the land tribunal. And subsequently, petitioner's family members have become owners and who are in actual possession and enjoyment of the land. The petitioners want to get the land converted into a non-agriculture, wanted to convert the agriculture land into non-agriculture to form a layout by laying plots for residential use. And while seeking the conversion, one document that is required is a no objection certificate stating that the land has not been acquired by the respondents. Hence, the petitioner have approached the respondents by making a representation on 31/5/2024, requesting the respondent to issue an NOC that the land has not been acquired under any scheme. Right from 2024, and thereafter they have given another representation on 28/4/2024. Petitioner that they have not, there is no response and to the said representation. It is stated that after issuance of the preliminary notification, till date in the year 2011,
Please, my lords, 2011.
date the petitioner and his family are in possession of the land and the possession has not taken by the respondents. Final notification has not been issued and as such the land has not been acquired by the respondents. Hence, the petitioner has come before this court questioning the inaction on the part of the respondents. The coordinate bench of this court had passed an order on 8/9 2025, and directed the respondent to file an affidavit on or before 19/9/2025. After taking time on two, 3 occasions, an affidavit is filed on 21/11/2025. When this matter came up before this court on 28/1/2026, this court has passed the following order extract. Again, an order was passed on 2/2/2026. Extract this order. Pursuant to the order thereto, the respondent has filed an affidavit before this court. Paragraph 4 till the end. Extract the affidavit. Learned counsel, Learned AAG, appearing on behalf of the respondent, submits that they'll be completing the acquisition proceedings, and there is no time limit for the acquisition proceedings under which act?
Under the Karnataka KIDB Act, KIADB Act.
KIADB Act. KIADB Act. There is no limitation. There is no limitation, and they will be, as undertaken before this court, they will conclude the proceedings within 6 months from today. The Land Council appearing with the petitioner submits that the 2011, the proceedings are initiated. Until now, they have not concluded the acquisition proceedings. Neither they are acquiring the property nor they are giving no objection to the petitioner to convert the land. It is submitted that though there is no limitation prescribed, that doesn't mean that the petitioner, the respondents eternally will not conclude the proceedings and will not permit the petitioners to convert the land. It is submitted that when he has given a representation, the respondents ought to have responded to the same. As this court has passed an order, an affidavit is filed before this court. It is submitted that the petitioner has his own apprehensions that they will not take it to a logical end even after 6 months. Anything else?
That's
Even after 6 months. Next part. Having heard the counsels on either side, the counsel for the petitioner and the learned additional advocate general for the state, this court peruse the material on record. The learned AAG has submitted about the act and that the affidavit discloses that thousands of acres are under acquisition, and the proceedings are initiated in 2011. And relying on certain judgments, they submit that there is no limitation under the KIADB Act for issuing a final notification or an award. Prima facie, this court is not convinced with the submission made by the AAG. If any limitation is not prescribed under the Act, it is assumed that within a reasonable time, a particular activity has to be concluded by the respondents. And according to them, from 2011 to 2026 cannot be a reasonable period. Be that as it may, the prayer that is sought before this court is to issue a no objection certificate by the respondents, NOC, in the light of the representation made by the petitioner. The respondents ought to have communicated the same to the petitioner by this time. If the petitioner is aggrieved that, yes?
Yes, no.
If the petitioner
Because
is aggrieved,
reasonable, sorry, Your Lordship, permission. The division bench of this honorable court.
no, that is,
Yes, Your Lordship.
but we can't
No,
deal with that.
Only humble request is that the fresh notification from the 28/1 it has to be started. Otherwise, they say that no, originally that 2011 they will pass our award.
Learned counsel for the petitioner had relied on a judgment of the division bench in writ appeal number 557 of 2021. dated 23rd March 2022, where a division bench of this court, considering the submissions made on behalf of the government.
Paragraph 4.
7.
Paragraph 4, it says there is no limitation, however, it should be reasonable time.
6 and 7 it has been, that is there.
Why is required for that? It is a settled law. Para 6 of the order. Next, come to this. What was I dictating? Within a reasonable time, they should conclude the same. But they cannot say 2011 to 2026 is a reasonable time and no limitation is available. There is no limitation under the act. Be that as it may, considering the scope of the writ petition before this court is passing the following order. In the light of the affidavit that is filed before this court, the respondents shall conclude the acquisition proceedings within 6 months from today. If not, they shall issue the no objection. Number 2, if the petitioner is of the view that if the petitioner is so advised that the acquisition proceedings cannot be concluded after such a long lapse of time, he is at liberty to question the proceedings that are initiated by the respondents. Yes.
Only thing, Your Worship, even if they start proceedings, Your Worship, the originally 2011, now in 2026, it has to be started from the 28/1, Your Worship. Automatically it lapses because of the delay. Because that I will not get the amount because they say that no, in the 2011 only we have passed a 28/1. It has to be made clear. That's the only my.
What I said is, as per the affidavit filed before the court, they have to conclude the proceedings within 6 months from today.
Yes.
How they do it? If you feel that they cannot conclude the proceedings or they cannot take it further, you are at liberty to question it. So if they are not concluding it within 6 months, they should issue an NOC.
Only my grievance is, Your Worship, that they will take 2011 as a market value. That's only because that after 14 years, even if they don't do it, that's what my.
You are at liberty
Yes,
to
yes,
question
that's
it. Because if I observe all that in this writ petition, that is enlarging the scope of the writ petition. Already I have enlarged it.
Yes, Your Worship.
Yes.
From the present day market only, let them take up. We have no objections.
Yes.
Now they have offered some amount, Your Worship, my already put across my clients. I don't know whether if it is agreeable, they will go ahead with the matter.
Yes, 30.
Seal number 30. इसके कायक मत.
Maintainability of the appeal.
My lord, appeal has been prepared by the insurer under section 173 MU Act, my lord. The office has raised the objection that the award amount is less than 1 lakh rupees as is not maintainable.
Questioning the maintainability and on liability.
Yes, ma'am. And no, my lord, this appeal has been prepared by the liability, not on the quantum, my lord.
That's what I'm saying. It's on liability. On what is the liability? What is
Unauthorized passenger in a goods vehicle.
The office has raised the issue with regard to the maintainability as the amount that is awarded is below 1 lakh.
Below 1 lakh.
Below 1 lakh. Then council submits that it is submitted that the appeal is maintainable as the insurance company is on the ground of liability. The office objection with regard to maintainability is overruled. Yes, next, 31.
All the objection has been complied, my lord. IA is also attached to the stay, my lord. Stay.
Where is the stay petition? Considering the fact, the IA number so and so, it is submitted that the claimant is an unauthorized passenger and is not entitled for any compensation, and this aspect was not considered by the court. 50%, 4 weeks, and no permission to withdraw. Yes, 31.
Much obliged.
Seal number 31.
My lords, once the bid is completed, once the bid is completed, my lords, he has a remedy under section 16 of the act.
No interim order in this.
No interim order.
No representation on behalf of the petitioner. This is matter after 4 weeks. Yes, 32.
Seal number 32.
30.
Harish, yes, 32.
And we have filed the memo stating that we have served the hand summons to the trial court advocates.
What is the name of the advocate? That is what we have to record, isn't it?
The interim.
Did he say so? Petitioner shall file a proper memo indicating the names of the advocates on whom the service is affected. Yes, next 34.
My lords, again, my lords, we are taking fresh steps to R2 to R5. That Shara, my lords, we have served the copy of the, my lords, hand summons to the trial court advocate. In the meantime, we have paid the PF. R2 to R5, we are going to take fresh steps.
And registry is also directed to issue the notice.
And interim order may kindly be extended.
The order earlier granted is extended. Yes, 34.
33, Arjun. Number 34. Omkar Lakshman Desai.
For the respondent.
Avinash Pankar.
34 connected matter, my lord, I appear for the petition.
What are these matters about?
These are, my lord, admissions insofar as my matter is concerned, my lord, admission of 2 students, my lord, to the postgraduate Ayurveda courses done without, my lord, counseling process. Now they have almost completed their course and.
Why you have done?
Pardon?
Why it is done without the counseling process?
Yes, I shall submit that. This is, my lord, in respect of postgraduate courses, my lord, no regulations have yet been framed by the, my lord, regulating body, that is the National Commission for NCISM. In respect of the, my lord, undergraduate courses, my lord, regulations are framed by the commission in the year 2022. For the first time, my lord.
Before you submit, if you have, for the counseling, when you are done for the other students, when you are aware of it, why not for 2 students?
My lord, as per, my lord, section 59 of NCISM Act, which, my lord, saves the, may pass on, my lord, the act.
No, this question you can answer without going into all that. You say only 2 students counseling was not done as, for all other students, one method, 2 students and other method. If your submission is the correct, that there are no rules in place, you should have done it for everyone. But you have not done so. You have done only for 2 people. Why is it so?
I shall submit. My lord, I have only 12, my lord, intake capacity.
12
in
intake.
2, my lord, PG seats. My lord, 2 subjects, my lord, I am conducting, my lord, PG courses, my lord, by name.
No, let us take it whatever it is.
Yes. So each, my lord, the subject, I have 6 intake, my lord. Out of which, my lord, 5, my lord, seats have been allotted to the management, that is, my lord, the petitioner, which is the privately managed, my lord, college. And 2 students have been, my lord, allotted under NRI quota, which are, my lord, to be filled by the management, my lord, of the petitioner college. Rest of the, my lord, state quota, my lord, 3 seats have been allotted, and all India quota, my lord, 2 seats have been allotted. Now, my lord, previously under Indian Medicine Council Act 1970, in respect of the management quota and NRI quota, my lord, admissions were conducted, my lord, at the college level by following the fee structure, my lord, fixed by the state government, my lord, without the undergoing the process of, my lord, counseling by the KEA. KEA, my lord, used to conduct the counseling process, my lord, for the students and allotment of seats only in respect of all India quota and the state quota. Now, my lord, under the new act, the commission is required, my lord, to, though, my lord, it is empowered to regulate the mode, method and manner of the, my lord, admission to PG courses, but it has to do that, my lord, by way of, my lord, the regulations, which is, my lord, mandatory under the, my lord, provisions of the act. And the regulations, my lord, so framed, my lord, by the commission under the exercise of powers under section 55 of the act, the regulations, unless and until, my lord, are approved by both the houses of the parliament, my lord, have no effect, my lord, or no, they can't be, my lord, put into effect. So far as, my lord, PG education is concerned, the commission has not, my lord, framed regulations as yet.
Answer my question.
I am coming to it, my lord. I am coming to it.
First you answer that, then you make other submission.
Yes, my lord.
In respect of 10, what is the procedure followed? In respect of 2, what is the procedure followed?
In respect of 10 students, my lord, students were allotted, my lord, by the KEA through counseling process.
On which regulation?
Pardon?
Basing on which regulation?
No regulations.
But you accepted.
No, my lord, that is, I am challenging, my lord, they are doing this, my lord, by way of publishing the guidelines, which is not permissible. My lord, the field has been occupied by the regulations framed under.
Where is the writ petition? Give the papers.
Yes.
Which is your writ petition?
Annexure E, my lord.
Page, no, which writ petition? There are several writ petitions. 34 point?
34.1, 1056.
Give that.
Prior to that, my lord, may I request my lords to kindly take the order of this honorable court, my lord, dated 19/2.
Let me understand what is that you're seeking.
That precisely has been, my lord, recorded by this honorable court on 19/2/2025.
We'll read it from your papers.
Yes.
Quashing the impugned endorsement dated 3/7/2023 issued by the fourth respondent. What is this 3/7/2023? Please come
That
to
is, my lord, approval of these two students was rejected, my lord, by the state. Thereafter, my lord, university also rejected, my lord, the approval of these two students, my lord. That was also sought to be, my lord, challenged by way of filing an application seeking amendment and questioning. Later, my lord, an application for amendment of the petition and seeking additional prayer for seeking questioning of the, my lord, guidelines is also filed, my lord. That is before my lords, my lord. On the last occasion, my lords, my lord, posed me a question regarding several applications pending, my lord, in the matter. On every occasion, my lord, there was an application filed by the petitioner seeking, my lord, permission to appear, my lord, for the examinations and accept the examination fees and permit them, my lord, to the appear for examination. Once examination is,
I think if there are, even as per there are no regulations in force, so their permission is not required, their examination is also required. You only conduct your examination and complete your studies. Why anything, why all these procedures should be in place?
college, my lord, is affiliated to the university.
No, not required. You run on your own.
That is not, my lord.
That is very unfortunate. These kind of entertaining these kind of writ petitions and giving orders one after the other. Are we not diluting the process of this education? What is the purpose of keeping all this?
This is, my lord, only in respect of the PG courses. So far as you
said, out of 12, how 2 are different, 10 is 10. When you can understand about 10, why are you not understanding about 2?
Lord, this, my lord, 2 seats, my lord, remained vacant even after, my lord, all the rounds of, my lord, counseling was conducted by the KEA and 2, my lord, seats of management quota.
Not supposed to bring it to their notice. Why should you take the students, and why the students are, without any probable all permissions, why are they taking admissions? And why should this court say that you permit them, you let them study, let them write exams?
Peculiar case, my lord, so far as these 2 students may kindly be seen, my lord. These are the 2 students, my lord, who are academically qualified.
I will hear this matter. I am going to pass an order so that these kind of writ petition, there should be an end to this.
Lord, with the permission, may I make? Yes. Lord, insofar as these issues are concerned, my lord.
You said that there is a
Please,
judgment
may I-
and we will impose costs, sir. This case requires a calls for a cost. This matter on 24th.
In the meantime, my lord, there is a final examination, my lord, last date for, my lord, submission of application and this.
Which year they have come now?
Pardon? My lord, he is now in the final of semester.
No, what is the purpose of, without even deciding whether such a thing is right or wrong, and keep on giving the permissions and finally validating inaction, some wrong done by you? I'm not understanding what are these writ petitions, what are these orders? The issue is very limited, whether you are permitted to take or not. If you are not permitted to take, it would have, that should have been decided long back. And why are we perpetuating the illegality like this?
Seats, my lord, these are the national resources, your lordship may kindly see. Though there are students, my lord, they won't get the seat. And though there are, my lord, colleges, they don't get, my lord, the students.
Saying is, whatever
This is, my lord, due to, my lord, policy failure by the commission.
It has to be decided at the threshold. Not like this, years together, keeping it pending, completing their course, what they are learning. In some cases, they don't even comply with the basic requirements. Still, they are made to run the colleges. And what education the children will receive from those kind of colleges.
So far as the
it's high time that the course should stop running the school, running the colleges. There are
one submission, my lord, I would like to make. So far as these 2 students, your lordship may kindly see, they are more meritorious than the candidates which have been allotted, my lord, by the KEA. These are the students who have registered themselves, my lord, with the KEA.
Give me more intelligent than Einstein. We are not concerned.
Ranking, AIA, PGT ranking and the marks.
Concerned with what is the procedure that is in place, whether it is followed or not. We are not concerned about the individual performance.
There is no procedure, my lord, laid down, my lord, by the regulations, by the commission. Is what
for 10 people, the institution understand the procedure. 2 people, it doesn't understand. So that is very clear to me.
Now, my lord,
but I want to hear it elaborately and pass an elaborate order, and I'm indicating that cost of whatever it is, I'm going to As of now, subject to what you say, I'm going to impose cost on the institution.
So far as those, my lord, cases are concerned, those are undergraduate BA, MS courses, my
Whatever
lord.
it is,
One second, I'll at least.
Blatantly, the institution who is aware of the procedure, on your own convenience, for some students, you understand. For some students,
It
you
is
say
not-
regulations are not in place. If regulations are not in place, why did you take the candidates as per the counseling? You shouldn't have taken, there are no regulations. And whatever wrong you have done, the courts will not take it forward like this by making them sit for the exams.
Now, in those cases, my lord, your lordship may kindly see, the very permission, my lord, to the colleges was denied for the particular year. They, my lord, admitted as many as 20, 39, 31, 27, my lord, students. Here is the case, my lord, I have intake of only 12 seats.
Number will not, if you have committed murder of 1 or 15, it is only under 302. Separate provision
There is
will
a
not be there.
fundamental difference, my lord, in that case and my
Fundamental
case, because
difference. As an
admissions were conducted, my lord, notwithstanding, my lord,
As an institution, you have failed.
regulations,
That's the
my lord,
point.
were in place.
Point. Number is, doesn't matter.
In-
Now you let them, it's been, you're also happy with it. What is the procedure that's happening from 2023?
No, my lord, we have.
How many times have you filed a writ appeal? Have you filed?
Every, my lord,
Any interim order that
they are
is
not
granted, permitting them to write for the exam, sit for the exam,
No writ appeals.
then
No, my lord,
be
my-
happy with the
my lord,
orders.
my lord, the similar issues have been, my lord, have
The
been, my
IAs
lord.
are filed before this court, stating that the last date for examination of the students is so and so. It is submitted that from the last 3 years, the courts have been passing orders and permitting the students to write for the exams, to pay the college, the fees and to write the exams. The respondent have not preferred any appeal against any of the interim orders that are passed by the coordinate benches of this court. In that view of the matter, all the IAs that are filed in this case are allowed with regard to this payment of fees. When counsel for the respondent has relies on a judgment of the division bench. When this procedure is going on from the last 3 years, this court is not able to understand why the respondents have kept quiet and they were letting the petitioners to appear for the exams, and why they have not preferred an appeal against these orders. Yes, list these matters on 24th. On that day, this court will, on 25th, on that day, this court will finally hear these matters and will pass an order.
Bless.
Yes.
Bill number 35.
Same matter.
In all the matters, wherever there are IAs for this, that all those IAs are allowed. Yes.
35. Real Lord Khan.
Lord, please.
CGP.
Lord, for dispensation of a certified copy in this first matter, my lord. Dispensation application. And there is an.
Mention of Annexure B. What is Annexure B?
Annexure B is a letter written by the municipality, local body to the HISCOM authorities to disconnect my power on the count that the objection.
1/24 is filed seeking dispensation of the production of the certified copy of Annexure B, same is dispensed with. Yes, next.
They
36.
have obtained interim order of stay. We are seeking for demolition of illegal construction building, my lord. They have
We'll hear
obtained
it.
interim
What is
order
it?
of stay, my lord.
My lord, first case, my lord. Here in a case wherein the municipality issues me a letter to the HISCOM authorities to disconnect my power line on the count that there is no building permission. May I request your lordship to turn to page number 11, my lord.
No, if who appears for the.
For HESCOM, my lord, I appear, my lord. Municipality, my friend appears.
Now, why should you write a letter to them if a property is constructed without a permission? Can't you issue a notice and demolish it?
Then again, afterwards, my lord, we have taken action for demolition, my lord. We have.
More important. That you
We have
do
issued
it,
notice, my lord.
that you do it, having let them construct, having living in that. Why should you say the connection be disconnected? Why can't you demolish it?
In the next matter, my lord, we have issued.
That is the second matter, my lord.
This matter I will dismiss. This matter I will allow their matter. Second matter I will hear. Now, that is your duty to take action in accordance with law. You are not, it's not that you are helpless. Why should you ask them to disconnect for them to disconnect? There are certain reasons to disconnect the power. The present petition is filed.
One submission, my lord.
Annexure A is only a notice to explain that we are not disconnecting.
No, why should you? It's
Please,
not your
please, then,
concern. If there is an illegal construction, they will take
Please,
care.
please, please.
The
No
present
grievance
petition is
against
filed.
the
Seeking the
notice on the-
following
Correct.
prayer.
My lord,
Land
kindly
Council,
take
it is a case, it is a case of the petitioner that petitioner has constructed a building in his property by obtaining necessary building license from the municipal corporate council for construction of ground plus 2. It is.
Commercial complex.
What is the deviations are there?
There are certain deviation. The claim of the local body is that I have encroached.
My lord, I have filed a detailed objection, my lord. In the two sides, my lord, he has encroached the government nala, my
If a
lord.
person is, he has taken the permission, constructed the house, if there are deviations, you will write a letter to the department. Can you do that?
My lord, even if we are going to demolish the building, my lord, first we have to disconnect the electricity supply, my
You will
lord.
demolish
My lord,
entire building.
my lord,
You
he
can
has,
demolish the deviations. For that is for doing that, you have to issue notice to them. You have to
we have
pass
issued
an
notice,
order.
my lord. We have issued
Further
notice.
course of
After that, what happens? He will give his explanation. You have to pass an order,
Please.
and you should give reasonable time to him to question that order.
We have
Then
issued
only you can
please, my lord,
demolish.
please, my lord. Meanwhile, my lord, after issuing this notice, my lord, we have given a three notices, my lord. He has given,
Order. Pass an order.
and
Who is
meanwhile, he
stopping
has
you?
approached before this honorable court and obtained the interim order, my lord.
No, I will.
In the
I'll-
second
I'll-
matter, my lord. That is the reason, my lord.
He has obtained the permission on 16/3/2021 for construction of cellar ground plus 2. Said building license was renewed for the period 16/3/2022 to 15/3/2023. The petitioner has applied for the electricity supply connection to the said building, and the same was granted.
Annexure C, my lord.
Petitioner building was given commercial meters. The respondent number 1, Town Municipal Council, written letter to the respondent number 3 to connect electricity power supply. The petitioner came to know about the said information after respondent number 3 issued notice dated 9/12/2024. It is served on the petition on 12/12/2024. It is stated that the respondent municipality cannot issue a letter to the BESCOM to disconnect the power supply. It is submitted that the construction is made after obtaining the necessary permission. Land Council appearing for the respondent, it is BESCOM.
HESCOM.
HESCOM.
HES.
HESCOM
HESCOM.
submits that. They have issued a notice and the petitioner has come before the court questioning the notice. They should have represented the same to the respondent. Land Council appearing for the municipality submits that the petitioner has made an authorized construction and they've already issued notices and he has not appeared before the authorities and has come before the court and obtained stay. As such, they are not able to take further proceedings. The next para, having heard the council's on perusal material on record. If a person, after taking the permission, constructs with the contrary to the sanctioned plan, if any construction is made, the response.
May I make a submission? The grievance of the municipality is that I have constructed in my property, the area which is meant for reserved for access. Access to the, if their own document speaks the contrary, my lord.
That we were not going into.
Please, my lord, please, my lord. Because the second petition is with respect to that aspect.
If the respondent has made any construction contrary to the permission or any other laches on the part of the petitioner, the respondent municipality is not helpless. There is a mechanism in place for them to take action. The course available to the municipality is to issue notice to the petitioner, to pass an appropriate order, and basing on that, if they want to demolish the property after an order is passed, then if they require any assistance from the ESCOM, they could have obtained, but not at this stage. And the said notice issued by the ESCOM or the requisition by the municipality are contrary to law. Accordingly, this court is passing the following order. The proceeding dated so and so set aside and the respondents, is set aside, and without following due process of law, I think nothing is required. That is.
No,
that is set as-
that suffice as far as my part of the
Yes.
legal requirement.
Next petition. Next petition.
Notice,
Notice, name petition then.
Second petition is there, my lord, wherein I have challenged the notice issued by the municipality with respect to the proceedings under the Public Premises Act. Though the notice doesn't speak as to under what provision of law under the Public Premises Act they are intending to take action, nor under the Municipality Act, the notice speaks that what is the proposed action.
What is this notice?
My lord, in
Annexure
this,
A,
my
my
lord, after obtaining survey report from the concerned authority, my lord, it goes to show that, my lord, he has encroached 80 meters, he has been encroached in the government nala, my lord. We have given 3 notices, my lord, he has given a false reply.
Respond to that.
No, already I have given notice, reply has also been
Order
filed.
passed.
Till date, they have not passed any orders.
Meanwhile, we are going to pass.
So
the
let
order,
them
my lord.
pass the orders in accordance with law, because under the Public Premises Act, there is a forum available for me to challenge their orders.
Where is the question of, no, the municipality has issued a notice under the Public Premises Act.
The government, the other day, government took time in order to ascertain and make a submission whether the land in fact belongs to government or not.
All that we will not.
No, my lord, my submission is only bringing it to the notice of the court.
Not necessary that we should decide all these aspects.
No, my lord, I'm not, because my interest is required to be protected, for which I am before this court.
No, they have issued a notice, they will pass an order,
My submission, my
One
lord.
minute, you will submit your representation, they will pass an order. If an order is passed, you will come before the court.
No, my lord, my submission is that if they have issued me a notice under the Public Premises Act, that should be in accordance with law for submission. If the note,
Competent authority to issue a notice.
that only my grievance is that somebody issues me a notice.
Municipality is the competent authority. Since municipality is the competent authority, since the property which he has encroached, which comes under the municipalities, not in the limits of the municipality, it becomes a property of the municipality.
Municipality.
They have a power to issue notice under Annexure A.
I
which is the
already
notice
issued.
afresh.
Yes.
I have already given a reply to the very notice
Why did you
also.
come to the court?
I came to court because they straightforward come to with stating that within 7 days they are going to demolish my property.
That's in the first case at Annexure A, it has been stated that only 80 square meters have been encroached by him. That under the,
No, in this case, notice is ordered or a order is passed.
yes. No, Annexure A in first case, ma'am.
No, I'm talking about the second case.
Second case.
Second case.
Is it a notice or is it an order?
Second, my lord, in this only, totally, my lord, we have issued 3 notices, my lord.
No order is passed.
No order is passed, my lord.
He has submitted his explanation.
Please. No, he has submitted a explanation, my lord, but meanwhile, he has approached this honorable court and obtained the interim order of stay.
Now you are yet to pass the order.
Please.
Please pass the order.
Please, if our lordship directing us to pass order, we will proceed against that.
Please come.
Till that time.
Without following.
Please, ma'am, please.
Without, how will they take action?
Please,
without,
no, unfortunately, this is the third notice.
While seeking the
One submission, my lord.
prayer.
In all the 3 notices, the threat is that they are going to demolish. They are not going to pass orders.
Sub survey report, my lord, we have issued.
Even Annexure A, within 10 days they are.
You are a state,
you have given
you can't be high-handed.
Please.
That is my grievance, my lord.
It is submitted that the petitioner has constructed the building, same like facts are all like earlier in the other case. The respondent number 1, continuation of earlier, this is, at the behest of the local elected councillors has issued notice dated 24/6/2025, alleging to be under the Karnataka Public Premises Act. No, you just say, you filed the earlier writ petition, notice is issued.
No, my lord. That is my grievance, my lord. The grievance is that having approached this.
To paragraph number 8.
Please,
What
my
did
lord.
you say? Look at it.
It is submitted, respondent at the behest of the local councillor has issued a notice 24/6/25 alleged to be under the Karnataka Public Premises Act. That is, may I refer to Para number 8 or page number? Para
Para number 8.
Copy of the notice is produced.
And after that,
There.
what did you
It is
say?
submitted, petitioner has not filed any other proceedings, appeal, impugned
These
notice.
are all common paragraphs. Those are all common paragraphs, 9 and 10. After that, what is wrong with that? You didn't say so.
My lord, my grievance is that, my lord, proposed demolition is contrary to law, my lord, without issuing any notice to me.
3 notices are issued.
There is no application of mind.
Application of mind to the respondent, but what is the application of mind while seeking the prayer before the court?
No, my lord, I am before this court, my lord, to seek a writ of certiorari, quashing annexure A, my lord.
Understand what am I referring to?
Please, my lord.
You should have stated something after paragraph number 8.
My submission is that, please,
There
please.
is no submission that. You have to say something after paragraph number 8.
I'll make necessary
Why it is wrong. So and so it is submitted that the respondents are without following the due process or are trying to
Para number
demolish the
14, I
property.
have. Para number 14, that is I have.
That is grounds. Grounds is a different aspect.
Yes.
That they are going to demolish the property. They have no such power they have no such power to do so. It is submitted that before demolishing the property, an order needs to be passed, but straight away the respondents have taken a decision to demolish the property. Land council appearing for the respondent, the municipality submits that the petitioner has encroached the public property, the road, and made the construction.
No.
As such, the property, all the public premises vests with the municipality. Municipality has a power to issue notice under the Public Premises Act. It is submitted that the petitioner, without the petition, even before the order is passed, the petitioner has come before the court and obtained the order. It is submitted that they will follow the due process before taking any action. Next para.
But
The
objections already filed. I have already given a reply to the legal.
all that is not necessary. Having heard so and so. If the petitioner has encroached any public property, the municipality is always had the right to pass an order, issue a notice. And as contemplated under the Public Premises Act, they have to take action. Take action. Now in this case, they have issued the notice. Petitioner has already submitted a reply. The respondents, as contemplated under the Public Premises Act, shall pass order in accordance with law. Till such time, they shall not take any coercive steps.
Please.
All other matters, I'll not take up there is a bench in the afternoon. What is this, 37?
Please.
36.
I am the beneficiary appeal, my lord. In this appeal, we are challenging the LSC order of 2042 of
Any other
2007.
connected matters in this?
No, matter. A similar matter has passed the order.
Where is that? Page number? You have the copy of the order?
No.
Look, just check it. We have passed several orders in this and at least with regard to the division bench order. Just check it. Same order if it is there, or else we'll post it next day. Is 37?
Notice issues.
This and all it will be taken care of. 37?
37?
Beneficiary appeal, my lord, there is a delay of 17 days, my lord.
Notice to the respondent. You take notice for? For which respondents you take?
Yes, yes.
Which respondent?
R1, my lord.
R1, AGA takes notice. For other respondents, notice 38.
Public.
38.
My lord, appeal by the insurance in the quantum of compensation, appellant admit the liability to the extent 50%, that he has no objection for releasing that amount also.
What is the amount granted?
5,29,000, my lord.
What is the admitted amount?
5,14,000, 50% award amount. Amount is disputed, 5,30,000 is a disputed, my lord.
Submitted that the insurance company is on quantum. Considering the submission, 50%, 4 weeks permitted to withdraw. Case 39.
39. Corporation appeal challenging the quantum. In the connected matter, this honorable court has passed the order.
Same order. Yes, 40.
But serial number 40, my lords, it is pertaining to foreclosure of a tender contract unilaterally and subsequent issuance of new tender. It has been stayed, my lords. Interim order.
Filed
like
objections filed in
interim
this
order.
case. I have also filed application for vacating stay.
Any
State
date,
has
my lord,
also filed
6
a-
weeks,
It's a
we are
matter
ready.
on Tuesday. This matter on Tuesday, interim order earlier granted is extended.
Great.
41.
Number
Great,
41, G. Narsim. 41, Narsamanavar.
Lord, I
41.
have for amendment of prayer, my lord. Matter pertains into imposition of 12% Forest Development Tax Act, my lord. As per direction of our lordship, my lord, I have deleted the prayer number 1, my lord.
So the IA number 2 for amendment is allowed. The petition shall carry out the necessary amendment. Stay petition like 12%.
Please, kindly be
That
allowed.
means it can be disposed of if it is 12%. We'll dispose it of.
Dispose, ma'am. Kindly be disposed of, ma'am.
Disposed.
Please.
Is 42.
Appear for the petitioner in this case, my lord. Your lordship, like kindly have it on next Wednesday, 18th, my lord.
Yes, next Wednesday.
Of
Yes, 43.
My lords, it is a case of death next week. Only, my lords, 1/3 or 1/4, that has to be decided.
Yes, then the afternoon matters are
Please.
listed along with that, this
Please.
matter, afternoon matters. 43. Yes, 44.
44.
My lord. Similar matter, my lord, NCI.
No, this also,
25th.
which day?
25th.
25th. Yes, 45.
Number 45, NP Vivek Mehta.
Look at it if interim order is there, extend after 2 weeks. 46.
46.
Condition 45. Tomorrow, 45 tomorrow. 46.
Number 46, Santosh Bhimani.
Look at it after 2 weeks if interim order is there, extend. 47.
47, Rajshekhar Burji. Should I appeal? They can't next week.
2 weeks.
48 absent. 49 absent.
50.
Aiva Patil.
Tomorrow. 51.
51.
Look at it, interim order is there, extend, or else, otherwise also 2 weeks. 53.
53. Girish.
This also same.
Dharwad.
All these further hearing matters, let it come tomorrow. Further hearing matters and part heard shall come tomorrow. And in all these matters, any interim order is there, extend. Final hearing?
60.
Final hearing, we can do some other way.
Court officer. Court officer.
Sir. Girish sir.
Sir, serial number 53 call out ಆಗಿತ್ತಾ sir? ಹಾ, serial number 53 call out ಆಗಿತ್ರಿ?
ಆಯ್ತು. ಆಗಿತ್ತು.
ಹಾಗೆ, ಹಾ, ಏನ್ adjourn ಆತ್ರಿ?
56 ಅಲ್ರಿ? Tomorrow.
53 sir, 53.
53 2 weeks.
ಹೌದ್ರಿ? ಓಕೆ ಸರ್. ಅದ್ರಾಗ ಒಂದು ಇಂಟರ್ ಮೋಟರ್ ಇತ್ತು.
ಇಂಟರ್ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗುತ್ತೆ.
ಆಗ್ತಲ್ರಿ ಸರ್? ಸರಿ ಸರಿ. ನಾನು 1:30 ಆಯ್ತು, ಒಂದು ಮನಿ ಓಪನಿಂಗ್ ಇತ್ತು ಅಂತ ಬಂದ್ಬಿಟ್ಟೆ. ಸರಿ ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಹಾ ಸರ್.
ಕಂಪ್ನಿ ಮ್ಯಾಟರ್ಸ್ ಬಂದವಲ್ಲ ಎಲ್ಲ ಬಂದ್ಬಿಡುತ್ತೆ.
Raichur.
GN Raichur.
Which is the insurance company?
SK Kayakmat.
Why is this listed?
Kayakmat.
New India Assurance Company.
Please.
He has to take steps.
He has to take steps. Ma'am.
Huh?
He has to take steps. Ma'am. R1 and R2 died. Ma'am. Insurance company has to take steps.
It is submitted that R1 and R2 are no more. The appellant shall take appropriate steps. You have given the details of the details are already furnished. Steps shall be taken within 10 days or else the appeal shall stand dismissed against the respondent. Yes, next.
Number 2. DV Patta.
My lord, order be passed with the pay and recovery order. No DL case, my lord, prior to.
The appeal is filed by the claimant.
Well, furnish memo of calculation.
Memo?
Calculation.
For the announcement of the award amount.
What do that? It's a case of death or injury?
Death case, my lord.
Have you seen?
I have seen.
As it is?
Bachelor.
So only thing is that future prospectus is not
Not
added
awarded.
by the trial court. Now it is added.
Added.
Yes.
Agreed with award passed in MAC number 617 of 2012. The claimant is before this seeking enhancement of the compensation. The claim petition, the tribunal has awarded the compensation as per the table given below at page number, internal page 12. Land counsel appearing for the claimant submits that the tribunal has fixed the liability on the owner of the vehicle on the ground that there is no driving license. It is submitted that still the insurance company is liable to pay the compensation and require the same from the owner of the vehicle. It is submitted that the court has failed to grant 40% future prospects. Anything else?
Yes.
That's the only thing. The counsel appearing for the respondent insurance company submits that the tribunal has rightly granted the compensation and there are no grounds to interfere. Next part. First, coming to the aspect of liability, though there is no driving license, valid driving license, still the insurance company is liable in the light of the law laid down in Saran Singh versus so and so. Then coming to the compensation, the accident had taken place on 27/4/2011 and the deceased is 27 years. As per the table, the income is taken at 6,000. 40% future prospects would come to 2,400. Then the income is 8,000. But where is the 50% deducted? Oh,
So
a bachelor.
8,400. If 50% is deducted, that is, it comes to 4,200 into 12 into 18 is 9,07,200. Towards consortium 88,000, convention towards funeral expenses 30,000. Altogether, the claimant is entitled for an amount of rupees 10,28,200. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 6,38,840 to 10,28,200, and the enhanced amount, the entire amount shall carry 6% interest. The insurance company shall pay and recover from the owner of the vehicle.
with liberty to recover.
Huh?
Liberty of pay and recovery.
I said so.
Please.
Yes, next.
Delay period interest is not.
Huh?
Delay period. There is delay in filing the appeal.
Where is it? Is it not come down till now?
Yeah.
Look at it.
Denying the interest for the delay.
What is this 14/10/2025 order? Please come here. Look at the cause list. What is this of main? What is that? Yes.
Please.
Delay, where is the delay located? IA for condonation of delay. How much delay?
1,875.
Say 1,875.
Yes.
delay condoned on condition that they are not entitled for interest of this period. Yes.
Please.
Seal number 3. Nagaraj Kalluri, Y. Lakshmikant Reddy.
This is the case wherein he was traveling on this mudguard of the tractor, my lord.
We'll hear it, yes. This is matter after 4 weeks. Yes, 4.
Seal number 4.
In 3, what about notice to R2 and R5? Process shall be paid for issuance of notice to R2 and R5. Same, within a period of 1 week, default order. Next 4.
Seal number 4.
Notice to respond number 2 and 4 are dispensed.
Memo is filed second dispensation of notice to
R2 and R4, they are drivers.
Memo is taken on record and notice is
And
dismissed.
kindly connected to the another case connected.
List along with so and so after 2 weeks. Yes,
And
fine.
connect with the serial number 9 also same,
Serial number 9.
9. In that case, I have taken the note. RR Mane has filed appeal on behalf of New India.
Let us deal with it when it comes.
Both.
Yes, 5.
Seal number 5. Nagaraj Kalluri.
Lord, we are on quantum.
Yes, Hiremat.
I'm appealing for claimants. For claimants, claimators.
So what do you say?
For the year of the accident, my lord, income is as per the Lok Adalat chart for 2014 is 7,500, wherein court below is considered 8,000. That is the only.
Quantum awarded is 2,60,000.
So what we do is, instead of, what is the amount as per this? Have you calculated? Do it.
Yes.
Yes, next. Pass over. So in between the figure. Now if you have to take 8,000, I mean 7,500, there is a 500 difference. So in between some figure, you please calculate and talk. Yes, 5.
Seal
6.
Seal number 6.
6.
The claim petition is dismissed, my lord.
List
Trial
is-
court records may be summoned.
List this matter after 2 weeks. Yes,
Copy
7.
may be,
Plus.
copy
Number
may be
7.
served. I have not received copy.
I'll serve a copy of
Precious
it,
good.
please.
Yes, 7.
Seal number 7. Nagaraj Kalluri.
Steps
It's
to be
also
taken.
quantum.
No, steps to be taken in respect of deceased R2.
Please. Only it's an injury case, madam. So I will file the dispensation application for the owner, since we have challenged quantum one. That is the only point.
R2 is who?
Owner of the.
Owner. Then file a memo.
Please, my lord, I will file.
A memo is filed second dispensation of notice to R2, dispensed with at the risk of appellant. This is matter after 2 weeks. Yes, 8.
Seal number 8.
Appeal by the challenge the quantum of pumping. R1 is the owner, my lord, owner of the claimant. Notice yet to be served. I'll take a fresh step.
Process shall be paid for issuance of notice to R1, a week's time, default order. Case 9.
Seal number 9.
Memo is filed second dispensation of notice to R5 and R6, dispensed with. Then R1 and R2. Within.
In cross objection.
My lord,
R1
is the claimant, my lord, who has filed cross objections.
Please,
R1 and
Mr.
R2.
Guru Kumar VA, my lord. He may be directed to
your
accept
name?
notice.
Guru Kumar V.
Guru Kumar, my lord.
Guru Kumar VA is directed to take notice on behalf
For
of
R1.
on behalf of the claimants in both the matters.
No, in the other matter, he is appearing, my lord.
Yes, yes, it's already crossed. Yes.
Yes.
2 weeks.
Cross objection, my lord, I filed dispensation memo. In crop, my lord, I filed dispensation.
In the crop 9.3, the memo is filed second dispensation of.
R1, R2, R4, R5, my lord.
Give that, take that first.
Please.
And my lord, I accept notice in the cross objections, my lord.
1, 2, 4, 5.
R3,
Dispensed
MI
with
my lord.
The
R3.
Mr. Ravindra R. Mane is directed to take notice on behalf of
R6.
R2. Yes. Yes, next.
R3 I will expect the notice.
R3?
R3 I will expect the notice.
So R3 so and so.
MI kitty.
Seal number 10. Seal number 10.
What is
the
this
case?
Insurance
SK
company is
Kayakmat.
not there in 10?
SK Kayakmat.
SK Kayakmat.
SK Kayakmat.
Appear for respondent, my lord.
Okay.
Award has been satisfied. Trial court award has been satisfied. Trial court award has been satisfied.
Satisfied. Case of death.
Injury.
Case of injury.
Injury.
What is the amount granted?
Copy has not served upon me. There's a difficult I'm facing.
Land counsel for the petition serve the copy of the appeal memo on the counsel appearing for the respondent. This is matter next week. Case 11.
2 weeks. Cell number 11. Nagarasi Kalluri.
My lord, I will take steps in this matter, one adjournment.
For whom? R2, no such person in the address. The shall take, this is second time. But you should take appropriate steps. See, this is R2, default order. Case 12.
No DL, my lord.
Steps to the notice to R3 returned as refused, amount to deemed service of notice. 12.
No DL, pay and recovery as liability is fixed on the owner, my lord.
Pay and recovery will apply. Where is he?
Pay and recovery, my lord. Suresh Gundi.
Yes, pay and recovery. Pay and recovery.
The claimant is before this court, agreed with the award passed in MBC number 139 of 2020, dated 4th February 2022. The extra hand, the lady is available. Ask her also to come because so many are happening. Tell the ARJ, judicial tell. Agreed, MBC number 139 of 2020, dated 4th February 2022. The claimants are before this court. When counsel appearing to the claimant submits that the claimant is only on the ground that the liability is fixed, somebody else. Liability is fixed on the owner of the vehicle, only on the ground that there is no driving license. It is submitted that even if there is no drive, same that Swaran Singh's case, still the insurance company is liable. Then counsel appearing for the respondent insurance company submits. The court had rightly the liability on the owner of the vehicle. Considering the law laid down by the export insurance case, still the insurance company is liable to pay the compensation accordingly. How much is the interest granted? Accordingly, the appeal of the claimant is allowed.
6%, my lord.
Only that the insurance company is liable to pay the compensation. Require the same from the owner of the vehicle. Yes, next.
Please.
Hello. 13.
Cell number 13. Nagarasi Kalluri.
My lord, claimant is the grandson, my lord, wherein the dependency is awarded. Only loss of estate they are entitled, only quantum, my lord. That in the rest of the cases, he is the only person in all the cases claim petitions. Altogether.
This matter will see, because list is more, will not go into any disputes now. 13 after 2 weeks, is 14?
2 weeks. Cell number 14.
What about 14?
14.
Is 14?
14. Nagas.
Who is R7?
Vidyashankarji Dharwad.
My lord, section 3, my lord. Section 3 pay and recovery order. Section 3 is only on no DL case we are in.
Who is R7?
R3.
R7.
R7 is the claimant.
Notice is not served.
1 minute. R7 is the owner.
No, he is a necessary party if it is pay and recover.
That's the only thing.
The petitioner shall take, the applicant shall file appropriate application for substituted service of notice on R3 within a period of 10 days, or else the appeal shall stand dismissed against R7. Is 15?
Cell number 15. Nagarasi Kalluri. J. Shetty.
Who is R2?
My lord, it's only on quantum, my lord. I will.
R2 is
Owner of the vehicle. I will file the dispensation. So only on quantum, my lord. Dispensation memo I am filing.
Memo is filed seeking dispensation of notice to R2.
Only thing is that, my lord, the injuries are fracture of right.
What is admitted amount?
My lord,
Admitted amount.
my lord, 8 lakh rupees, my lord.
according to you, according to
Yes,
the-
ma'am.
And what
Well-
is granted by the court?
Trial court award is 12,16,685, ma'am.
12,16,000?
856. Kindly, I will draw the attention to the page number 27 of the
Oh,
judgment.
that's on the merits of the matter, I understand. Yes, like, what is,
Only 2 points, my lord, I will submit. For pain and suffering, they have awarded 1 lakh rupees. Then also, loss of future earning is calculated. Even then, loss of future prospectus, 1 lakh rupees, again they have awarded.
yes,
1 lakh 50 through 50,000 for future medical expenses.
let us see, what is the calculation? Come to that table,
Page number 27, my lord.
20.
Internal page number 27.
What are the injuries?
My lord, the injuries are fracture of right distal of tibia and fibula bone and fracture of right patella bone with proximal fracture of right tibia. So only for this. Pain and suffering, they have awarded 1 lakh rupees, my lord.
Will grant 80,000. Medical expenses, as it is,
Yes.
3,56,656. What is the disability according to the doctor?
So doctor assessed the disability. My lord, 24%
To the limb or to the whole body?
to the limb, my lord.
To the limb. What is
Yes.
the income?
My lord,
What is the income?
income as per the chart, my lord.
Which
The
year is
court
the
below
accident?
has considered 15% disability.
Why? It should be 24% if there is evidence of the
They,
doctor.
they have taken 15%, my lord.
If we calculate, what will happen?
My lord, we are not disturbing that part also.
No, no, you will not. Now we are,
We are only on pain and suffering, food nourishment.
you are on that point. We are recalculate, now we are looking at the calculation.
Yes.
In that process, we recalculate. We
Yes.
have to,
Yes.
because we are looking at it. If we recalculate.
My
and
lord,
take-
income considered is of 21,150 as per his income tax return.
What is wrong in that?
They have produced. So we are, for income part, we are not disturbing or we are not touching that particular point.
Income part, you are not, but
Yes,
this
ma'am.
disability part, we have to consider. What am I trying to say is,
Yes.
now if we recalculate on that basis, it would enhance to some amount.
Please,
So instead of that, we'll dismiss the insurance company's appeal.
my lord, we have no objection to consider the income at 21,150.
So let's see. So loss of future income, 21,000. And because the disability is 24%,
The court below has considered 15%.
what 15%?
Disability considered by
That's
the
what,
court.
it is wrong. There should be some basis for the court.
1/3 has to be taken, 8% is to be considered.
No, you said it is a whole body disability is 24%.
No, my lord.
That's what you said. I said, I asked you whether it is a limb disability or whole body disability.
My lord,
Come to
though the
that paragraph.
though the PW4 has been opened, the petitioner has got permanent disability to the 24%, but it is with respect to affected right lower limb and not to the whole body in page number 54 of the judgment.
That's what I asked. It is 8%. How much the court had taken?
The 15% considered by the court below. Even then, we are not disturbing that particular point.
Yes.
Kindly be passed out, my lords. Kindly be passed out. Seniors engaged in other court.
Ask him to come.
Yes.
Pass on.
Pass.
Next.
Appeal number 16, Ashok Nayak. Nagarasi Kalluri.
My lord, week's time may be granted, my lord, for steps, my lord.
Huh?
Week's time may be granted, my lord, for steps, my lord.
Lord.
Division bench.
My lord, one small submission. In all the cases in serial number 16, with the connected matters, we have settled and we have filed the joint memo. Subsequently, they have some issues with the trial court advocate.
No, what they say that it has to be.
Here we are paid, my lord, no problem.
No, no. What they say is it has to go before the division bench. Appeal is, value of the appeal is more than 15 lakhs.
Please,
This is
please.
matters before the division bench.
Please.
I'm not served with a copy, though I'm
Counsel for the petty appellant shall serve the copy of the appeal memo on the counsel appellant for the
respondent
insurance
three.
company.
Bajaj Insurance.
Then 16.2, for steps to R1 to R4, a week's time default order.
Same, I have not
Please,
resolved.
Yes.
Seal number 17. H. Bagi.
I'm for
Dharwad
respondent.
Katiki.
What is this?
Injury case.
No representation on behalf of the counsel for the appellant. This is matter for dismissal next week. Yes, 18.
18. Seal number 18. Nagarasi Kalluri. BM Patil.
My lord, it's a WC case wherein the driver on the wheel does not possess the license at all. Section 3 is levied. That is the only contention.
Pay and recovery.
WC matter.
Yeah, even in WC also, even Act policy also pay and recovery is there. My lord,
Replace the judgment.
Kudi.
I will give, my lord, in fact, what has happened is,
No, nothing else to be looked into. Place the judgment saying that even under the WC Act also, this pay and recover will apply when there is no driving license.
next week, my lord,
Yes.
next week.
This is matter after 2 weeks. Yes, 19.
2 weeks. Seal number 19.
No,
Ashik.
in 18, all this
Steps.
R4 to R5,
There,
a
my
week's time. Then in 18.1, R1 to R3, a week's time default order. Yes, 19.
19.
I've made the needful as far as 1 and 3 is concerned.
Ashik.
And R2, it's been refused.
R2, notice to R2 returned as refused, amounts to deemed service of notice. It is submitted that as far as R1 and R3 are concerned, needful is done, list after service of notice. Yes, 20.
Seal number 20. Hanumat Reddy Saukar.
I paid the process today, minutes.
It is submitted that the needful is done.
My lord, in this we have paid the trial court award.
This is matter after service of notice. Mrs. So-and-so takes
Nagarasi
notice on
Kalluri.
behalf of the respondent
3.
insurance company. Yes, any scope for settlement in this?
From general.
Endorsement, my lord, passing the any amount.
Huh?
Any amount that may be arrived by this court, we are ready to file the joint.
No, but liability is there, minute, I think. Liability is there, minutes.
On
On
the-
the ground of is not an employee.
Oh, employer.
A was the owner. He sold to B. I was the employee of the B. So that is the reason why it is.
Notice. Yes, 21.
Seal number 21. Hanumat Reddy Saukar.
What about this?
Sharmila
Yes,
Patil.
request for 2 weeks time, minute. I already paid the process for some respondent.
Hmm.
Second time, minute, it
No,
is.
you are appearing for the claimant.
Yes, Clement.
Liability is on whom?
It is on the, minute, the
Insurance company.
insurance company. minute.
Memo is filed seeking dispensation of notice to R1 and R4, dispensed with at the risk of appellant. R2 and R5, who are R2 and R5?
They are the insurance company, minutes.
Which is, they're already, R2 no such address, here R5 left without instructions.
Yes, ma'am.
Insurance company R2,
R6, minute, is the insurance company, national.
2.
R2 is
R2
national insurance.
R2 is General
Hello.
Shriram, my lords.
Huh?
R2 is Shriram Insurance.
No. R3, minute, is the
R3
general insurance.
And he is a private party.
Owner, R2 is the owner. 2 vehicles are involved, minutes. There are 2
R2 is the owner.
owner.
No, the liability is on the insurance company. Why notice to him? File a memo seeking dispensation.
No, liability is there, madam. One respect of one vehicle, it is liabilities and fixed. And another vehicle, it is not fixed. Madam.
Notice the step shall be taken in this R5, R2 and R5, a week's time. Yes,
Please.
22,
Seal number 22.
My lord,
Anjanayam.
matter is settled for globally 50,000. my lord.
50,000. It
There is a
submitted.
pay and recovery order, so same order. has been
It's already passed, pay and recover.
Already pay and recover, they have paid the amount.
It is submitted with the land council, by both the councils, that it is agreed to settle the claim at 50,000 globally. And in that regard, they will file a memo before the Lok Adalat. They'll file a memo before the Lok Adalat. This matter on Wednesday.
Pay and
Lord, pay and recovery,
Pay and recover is already passed. Why should we say it now?
but they are not
No,
ready.
it is already there in the order. Pay and recovery is there. Already the trial court has already passed an order of pay and recover. Yes.
Seal number
Please.
22. Seal number
23.
23.
A week's time to take process meet with respect to
whom?
respondent number 1,
Who is respondent number 1?
owner of the vehicle me.
Liabilities on whom?
Owner only.
Same for steps to R1 a week's time, or else, then what about deceased R4?
This is- I'll file necessary application to bring the
No,
LS.
so process in respect of R1, steps in respect of deceased R4. See, 2 weeks time, default order.
Publish.
Yes, 24.
Still number 24, Subhajya Baddi, Guru Kiran, Guru Kumar.
Insurance appeal.
So it is R5 is refused, not accepting means. Notice to R5 returned as the person not accepting the notice amounts to deemed service. Yes, what about this?
Appeal filed by the company, insurance company.
Appeal filed by the insurance company, ma'am. The IV vehicle is no permit to fly in the Karnataka. No permit to fly in Karnataka, ma'am. The 75% contribute will be pay and recovery, ma'am.
This matter, 4 weeks.
4 weeks.
Yes.
Number 25. Nagaraj.
Serial number 25 and 30, my lord, connected.
25 and 30.
30. And a week's time. Week's time to take steps.
Yes, 25 a week's time and 30 also. List along with, so in that 30, for steps a week's time default order. Yes, 26.
Still number 26.
Paid, my lord. Award is satisfied.
Where is the counsel? No representation. It's a case of death or injury.
Injury.
List this matter after 4 weeks. Yes, 27.
27. Suraj J. Suraj.
Yes.
S. Bololi.
Please, my lord, I am filing memo for dispensation to notice R1, my lord.
R1.
Memo is filed. Same R1 dispense with, yes.
Pardon?
On the merits of the matter. What is this?
Lord, there is a delay. 266 days delay.
That we will see.
Okay.
Is it a case of death or injury?
The case of death, my lord.
Come on, open the file.
Please.
Which year is the accident?
2015, my lord.
2015. What is the age of the deceased?
Please. 28 years.
20?
8 years.
8 years.
Please, ma'am.
Now, what was the income taken? Court has taken 10,000.
10,000.
2015. According to you, you are working and court already taken. So as far as that, there can't be any dispute.
Regarding
Because
income.
as for 2015, it is 7,500 to 8,000, but court had taken 10,000.
Please, madam, because my income was 10,000, madam. I have,
Yes, 10,000.
please.
Future prospects at 40% was taken or not taken. So we'll do the calculation on that. That is 4,000. 14,000. How many are the dependents?
1/3 deduction, my lord.
Rightly deducted.
Yes,
How many are the dependents?
Dependents. Yes, ma'am.
My lord, in the case, the claim has been made. The major children of the deceased, my lord.
1/3 is deducted by the court.
Please.
Same deduction we will make. If you make, it comes to 4,666. So 14,000 minus 4,666 comes to 9,334 to 12 into, what is the multiplier?
17, my lord.
17.
My future prospect.
Already calculated. It comes to 19 lakh 4,136.
Out of that, 25% is required to be deducted, as there were four pillions were proceeding on a motorcycle. Tribunal has deducted 25%.
Why it should be deducted?
4 pillions on a motorcycle. And he was riding the motorcycle along with the 3 pillions. And he was not having a license also. So 25% contributing negligence has been taken by the tribunal.
The deceased is not having a. It comes to 14,28,102. Three are the dependents.
Major son and the daughters.
1, 2. Only two are the dependents.
Only two answers.
Yes, 3 into 48. 1. 48 into 2. 96,000. So it's coming to
My lord, the petition number appears to be wife, my lord. Petition number 2 appears to be the brother, my lord. It's not cannot be independent. Petition number 2. Petition number 1 is the wife of the.
Court has decided that now you cannot, this is not your appeal. It comes to 15,60,102.
No, at least while avoiding comment the compensate because he's a brother, my lord.
Huh?
Petition number 2 is the brother of the deceased, not the.
Not concerned, you are, because it's not your appeal. You never
But though I am
questioned
not in the appeal, my lord, have I reassessed the compensation because as per the apex code as that.
Will not consider, that will not.
Reassess the compensation.
So, now, it is, what is granted is 14,11,800 is granted by the court. Now with this calculation, it is coming to 15,60,102. Shall I say that you are ready to pay? It is submitted with the insurance company that they are ready to pay an amount of rupees 15,60,102. And in this regard, they will file a joint memo before the Lok Adalat list on next Wednesday. Joint memo. Calculation is that one.
The last occasion also it was referred to Lok Adalat.
No, I have, what is the amount I have stated already? That is the calculation.
Please.
Yes.
Local, 18.
No, on the day you will file, nothing to be decided.
Please.
They have agreed. I have already observed in the order. Yes. Yes.
Still number 26?
It's already 28, I think you have to call.
Still number 29?
28, ma'am.
28. Sorry, 28.
Call for records, my lord.
Yes, what about this?
My lord, call for TCR, trail code records.
Trial court required, my lord.
Trial code?
Record
Trail
required.
code record is required.
Record is required.
Required.
The notice to R4 returned as refused amounts to deemed of service of notice. Registry is directed to call for the trial court record. Yes, next.
R4 refusal held sufficient, my lord.
That's already I said. You please follow. Yes, 29.
Still number 29? G. Narasimhanavar?
Case of injury, my lord. Lord, as per the evidence of the doctor, my lord, he has sustained 99% disability, my lord. But tribunal has taken 10%.
Talk to her. Talk to the officer.
Password?
Yes.
30 urgent. Still number 31? Dinesham Kulkarni?
In 30, notice to R2 returned as refused amounts to deemed service of notice.
31.
Huh?
31 serial number.
30?
31, ma'am.
I've called 30 now.
30.
In this, the steps to be taken for issuance of notice to R1, a week's time, default order. Yes, 31?
Still number 31?
For
Dinesham
appellant,
Kulkarni?
ma'am. I for appellant, my lord. Praise time. For steps. 1 week. Please.
What is this here?
Steps proposed.
I number.
I will
1 of
correct.
2024
Collect to correct.
is filed. To bring the LRs on record, 2 of 24 is filed. To set aside the appointment. I number 3 of 2024. I don't know what are these applications, sir. Not served. IA number 1 to bring the LRs on record. Then IA number 3 again to LRs on record. Which disease? We'll see this post after 4 weeks. Yes, 32.
Still number 32? Anjaneyam,
Yes, this is a notice to R1 to process within a week, default order.
default order.
Yes, 33.
33,
Week's time intended. Week's time.
A week's time default order for R1 and R2. Yes, next.
Serial number 34,
R1 is not claimed, my notice issued was,
Notice to R1 returned as unclaimed amounts to deemed service of notice. Yes, what about this?
my lord, liability is upon the owner of the vehicle.
Kalluri,
Owner of the
Vehicle.
vehicle on the ground?
No DL,
Huh?
no driving license.
Yes,
Nagaraj,
that's the only ground?
That is the only ground, my lord.
Give that. The agreed with the award passed in MVC number 333 of 2018 dated 3rd January 2020. The claimants are before this court. Land counsel appearing for the claimants of this, the claimant is agreed only on the issue of liability, as the liability is fixed on the owner of the vehicle, as the driver is not having a valid driving license. If you submitted that, in spite of the same, the principle of pay and recover will apply. Next para. Land counsel appearing for the respondent insurance company.
2016,
The liability is
minor.
rightly fixed on the
Minor.
owner of the vehicle. Next, having heard so and so, consider the judgment of the Honorable Apex Court in Francis versus so and so. The insurance company is still liable to pay the compensation. Accordingly, appeal is allowed, and the insurance company shall pay the compensation and record the same from the owner of the vehicle.
Please.
What is the interest?
8%.
On the entire amount, the entire amount shall fetch 6% interest.
Publish.
number 35. Jay Kumar Kotin, a kayak mat.
Notice issued to the respondent one, it is served, my lord.
What is this matter about?
My lord, the insurance company also preferred appeal.
What is the number?
I am sharing, my lord.
List along with that. Yes, 36.
Along with number 36.
My lord, serial number 35, the SK Kayakmat advocate, his name may be deleted, my lord.
Deleted.
Subhash, deleted, my lord. So, Subhash Paddi, he filed a appeal from.
When it comes
Please.
along with it, it can be looked into. Yes, 30,
Serial number 36.
Week's time is permitted to comply office objection.
permitted to?
Office objection compliance.
No, that we will see.
My
What
lord,
about
there is
the-
another appeal, my lord.
Huh?
Another appeal, my lord, connected.
Office objections shall be complied with, within a week, list along with another connected appeal number so and so.
Number
What happened in your case? Your,
Short reduction of 10,000 dinar.
huh?
10,000 has to be.
In the 10,000 deduction, call that matter. Which is the item?
Serial number
The 5.
Serial number 5. Yes.
It is submitted by both the council.
By
Huh?
Serial
By
number
both the councils that insurance company is ready to pay an amount of rupees 2,50,200. 2,50,200 at 6%, interest at 6%. And in this regard, they'll file a joint memo before the Lok Adalat, list on Wednesday.
18.
Yes. Next.
Serial number 37. 37 serial number list.
Claimants appeal also liability fixed on respond number 2 and 3. Respond number 2 insurance company and respond number 3 is the owner of the motorcycle also. There are the two vehicles involved in the accident. The charge sheet filed against the tipper of the lorry, the insurance company, and
Office objection shall be complied with within a week. Is 38.
please.
Serial number 38. CM Hosmani.
Respond number
Upadhyay
1.
Baddi.
Liability is upon the owner of the vehicle, man. A week's time.
R1 is the owner.
Yes, ma'am.
Steps in respect of R1 within a week default order. Is 39.
Publish.
Serial number 39.
Liability fixed on owner of the vehicle. I will take steps. Owner, that is the national permit.
39.
39.
It doesn't say so, that any process is pending.
Lordship, I have paid. I have wrongly I have made the dispensation lordship. That is why I will withdraw the dispensation. I will pay the respond number 1 and 2 dispensation, but liability fix on respond number 2 lordship on the ground that it is not permitted.
38 is over.
39 lordship.
In 39, where is the, where?
Again, please. Permit ಇಲ್ಲ ಅಂತ ಅಷ್ಟೇ, that is only permit, national permit ಇಲ್ಲ ಅಂತ, that is the only ground lordship.
39 or 38?
39 lordship.
Give that.
That is the only ground lordship.
Yes, pay and recover.
But you have given the dispensation memo to the owner.
I will take steps lordship. That is wrongly.
It is submitted that they've sought for dispensation.
He was
of
ex parte before the trial court also.
Is that, when is that order? We will recall that order.
Please,
File a memo. It
please,
is submitted that they have earlier sought for dispensation of notice to owner of the vehicle by mistake. Now it is stated that they'll come up with an appropriate application to recall that order.
Please, lordship.
Yes, list of.
They are ready for pay and record, but our owner has taken dispensation.
Yes, 40.
Seal number 40.
As per the notice to R1 returned as unclaimed amounts to deemed service of notice. Yeah, but what about this?
40, ma'am, will be urgent, ma'am.
Huh?
Urgent. 40, 41, ma'am.
After, if you just go through the file and tell the court what it is, then it will be of some assistance. So, yes. Where is your senior?
Senior is out of station.
Next, 41 also, unclaimed R2 amounts to deemed service of notice. Yes, Subhash
J. Baddi. 41.
41 to also be urgent, ma'am.
Seal number 42. Ashant Matapati, Subhash J. Baddi for respondent number 2.
What is this case?
Ma'am, this case is a mechanic and survivor not been examined, ma'am. Mechanic.
This after service of notice. R1.
Seal number 43. GN Narsamanavar, Subhash J. Baddi, Narsamanavar.
Caller. Even if when all your matters are listed, even if the concerned counsels are not present, please ensure that somebody, or like how it happened in Bangalore High Court, I mean principal bench, let somebody assist. Because the counsels are not there, we can't adjourn the
No,
matter.
I'll take care of it.
Yes. 40?
43.
43?
Please.
Yes.
Case of death, my lord. Case of death, my lord. My lord, he was aged about 41 years, my lord. Date of accident is 2020, my lord.
He's aged about
41 years.
which year is the accident?
4 to 2020, my lord.
20?
2020.
Income is 13,750. How much was taken?
My lord, 14,500.
So what is to be done? We have to reduce it.
Injury case or death, my lord. Injury case? Take death, my lord.
Dismiss
The court has taken 13,250, not 14,500.
In fact, what the award has been given by the tribunal is just and proper. It does not, award of the tribunal is just and proper. In the case of injury, my lord,
So first of all, what is the income? This is a case of injury.
injury, my lord,
So he said death,
43, 103-18814.
pain and suffering. It is a case of injury.
Injury.
Please sit with them and calculate.
Please.
Yes. Sit with them and calculate. So it's 44.
Seal number 44. Nagaraj C. Kalluri.
Lord, week's time may kindly begin.
A week's time, default order. It's 45.
Seal number 45. Girisha Solomon.
Another insurance company, my lord.
Tagmat GN Raichur.
MFA 100299 of 2025, 100300 of 2025.
They can post along with, so he's giving the number right on a paper and.
I'll give it, my lord.
Number ಕೊಡಿ. Seal number 46. Bahubali and Kanabarigi.
Weeks time to comply with the office of sections. Yes,
Seal number
47.
47. SK Kaikmat, Harishas Maigur,
Appearing.
for Deshpande.
Yes. What about this?
Forty-seven, 48, and 49, my lord. All the matters are liability, my lord. Gratuity says passengers in a goods vehicle.
This is matter of 3 weeks.
In the meantime, records may be called for.
Admit call for the TCR.
Undertake to file wakalat man.
Yes, next 50.
Seal number 48. SK Kaikmat.
Not 48, 47, 48, 49 are same.
Both are.
50.
Seal number 50. Precious Gund.
Respondent number 5, either that Bharat Exide, Nagaraj may have permitted to take notice on Nagaraj, Mr.
Directed to take notice on behalf of.
On behalf of respondent number 5, Bharti Exide, in General Insurance Company.
Yes. What is this?
Delay may be condoned for 69 days.
What is the?
And
matter
there we have challenged the liability as well as the quantum. He is still continuing to be in service.
Number 1 of 2024 is filed to condone the delay of 69 days for the reasons stated, condone, admit, final year NTCR. Yes, 51.
Seal number 51. Subhajya Baddi.
A week's time.
My lord, fresh.
R2 default order. Yes, 52.
Seal number 52.
Office
GR
of
Turmari.
Sections shall be complied 1 week default order. 53.
Weeks time, Lordship.
GR Turmari.
Weeks time, Lordship.
Yes, a week's time default order.
On 53, we are 53, ma'am. The trial court record is satisfied, ma'am. 53.
Yes, 54.
Seal number 54.
Lord, week's time may kindly.
Step in respect, notice returned as unclaimed in respect of R2, amounts to deemed service of notice.
Amount is deposited.
Then with regard to R3, R4, R5, R7.
Please.
Weeks time, default order.
Please.
Yes, 55.
55.
I'll do it in weeks time, my lord.
Time. Yes, 56.
56.
A week's time, 57.
Weeks time.
A week's
57.
time, 58, same.
Weeks time.
59 also same.
59.
60, same.
60. Same.
Same.
61.
Steps shall be taken in respect of the deceased R2, 2 weeks default order.
2 weeks.
62,
62 already disposed.
same. What happened?
62.
62.
Dismiss that.
Which one? 60? Oh, dismissed as withdrawn. Yes. Yes, 63.
Seal number 63.
Yes.
Very good.
Yes, 63.
My lord, regarding 61, my lord. In the
61.
same, my lord, in the connected matter, the coordinate bench of this court has fixed the liability on the owner of the vehicle.
No, you have to take steps on the deceased R2.
Please.
Yes, next. 63.
63, there's one more connected matter which has to be.
Just along with so and so.
Number please.
Yes, 64.
Seal number 64. Srinivas K. Germany. Amoy Katigi.
My name is deleted and NCK.
Huh?
NCK name is shown.
So and so, the name is, so delete the name of so and so. With the name of so and so. Yes. I number 1 of 20 is filed to condone the delay of 520 days for the reasons stated. Delay is condoned on condition that they are not entitled for. 65. Admit final year in TCR. Yes, 65.
DNP order for non-compliance office objections.
I 1 of 24 is filed to condone the delay of 3 days in filing the recalling application. For the reasons stated, the delay is condoned and the appeal is restored to file. Both IA number 2 and 1 and 2 are ordered. Notice to the respondents. Yes, 66.
66.
My lord, appeal by the insurer, my lord.
66.
On the ground,
It is on ground of liability with regard to there is no, not in the course of employment. There is no relationship of employer and employee.
yes, this also.
And, my lord, since the entire award amount has been deposited,
My lord, it is as per the apex court judgment. So vehicle was in stationer, it was for a repair. So he has taken a two-wheeler and gone for bring the materials. At that time also accident has happened.
Yes, after 4 weeks. Yes,
4 weeks.
67.
my lord, meantime, my lord, entire award amount has been deposited. It is a WC award, my lord.
In your 2022 MFA,
No,
it
ma'am,
is posted on the courts.
This, my lord, we have deposited entire amount because in,
Whatever you want to do, but I will not grant any.
no,
stay
already it
now.
has been deposited, my lord, not to withdraw the amount because it,
I will not grant any stay now in 22. Yes, 67.
67. Shapatpati. Nagarasi Kalluri.
Yes, in 66.
My lord, it's a claimant appeal for announcement, my lord. We discussed for arrived for 1,20,000 rupees, but the pay and recovery order, we are not unable to file the joint. There is an order of pay
Where
and
is the
recovery.
advocate?
MACT passed the pay and recovery order.
Where is the advocate?
Called and
Already MSCT has passed order.
MACT order passed.
So then the same thing, pay and recovery, it is like, I'll say that it is already a pay and recovery order is passed. This amount let that be paid. Both the councils submit that the insurance company is ready to pay an amount of rupees.
1,20,000 rupees.
One
In
lakh
addition to
20,000 in addition to what has been awarded by the MSCT, and the interest or without interest,
it includes interest, everything, man.
including the interest. Already there is a pay and recovery order passed by the MSCT. Yes, they will file a joint memo before the court.
Please.
Okay, 68. All the matters, wherever I say joint memo, that is Lok Adalat. Yes.
68.
My lord, there are two more connected appeals, my lord.
List along with so and so, so and so. Yes, 69.
69.
For the respondent.
My lord, it's on quantum.
I press time, my lord. I'm not having papers. I'm respond number 2 in this case, my lord. I'm the owner.
After 4 weeks, 70.
My lord, I appeal for the claimant, my lord. It is an enhancement appeal. I am out of town, my lord. Therefore, my request, lordship may condone the delay.
71.
Next week.
Seal number 71.
Next week, my lord.
My lord, I have for the appellant claim. Owner is the appellant before this honorable court, my lord. I have filed an application for impleading respond number 9 to 11.
IA1 notice.
Notice is already issued, my lord.
Sir?
Is sold.
Yes. Who is this? Who are these respondents?
Respondents, my lord. The appellant has purchased a new tractor from the respond number 9, your lordship. At the time of purchasing the tractor, he has paid the insurance amount to the owner, and he has paid to the insurance company, but the agent has not misused, and he has not paid to the insurance company. Hence, only proposal was given to us that was produced before the tribunal.
For a motor accident claim, how all of them are necessary parties?
My lord, in this case, the purchase.
They have done any mischief, you will file a criminal case against them.
Unless it is, unless the vehicle is insured, the dealer should not take up.
How many, why these many respondents, sir?
They are the claimants because the death case is there. They are the respondents. The claimants.
My lord.
On number 1 to 7 are the claimants.
Please make it very clear. IA1 of 2024 is filed. Impleading respondents 9 to 11. Who are 9 to 11?
10 is the owner of trailers, and the respond number 11 is the insurers of the trailer.
10
is the owner of the trailer.
They were not parties.
Not parties.
And number 2 of 24 is filed to implead respondent number 9 to 11. Notice is served accordingly. I number 1 of 24 is 2024 is allowed. By impleading the proposed parties or respondents number 9 to 11. The appellant shall file the amended cost title. Shall amend the cost title within a period of 10 days.
1/2/2023 delays. Delay of 84 days.
I number 1023 is filed to condone delay of 84 days. The reason stated condone. Yes, 72.
Call for the records. Call for TCR.
What about R7? R7 expired.
Legal heads are already on record. I have filed memo. Last time it is recorded.
Yes.
On
Yes,
submission,
next 72.
I am undertaken to file wakalat in respect of proposed response number 9, my lord.
TCR.
Council submits that he has instructions to file wakalat.
Please.
No, he is a respondent.
I think
For
it is-
respondent number 9. Yes, 72.
TCR may kindly record it. TCR.
Admit final hearing TCR. Yes, 72.
Copy may be directed to serve with the court.
Appellant should have the copy of the appeal memo. 72.
Prashant S. Masmani, M.Y. Katiki.
Injury case. Injury case.
Injury case. Where is the council?
Prashant S. Masmani.
Yes, list this matter after 4 weeks. Yes, 73.
73.
I am for respondent.
Tarlatu.
This is also injury case.
Yes, after 4 weeks, no representation.
74.
What about 74?
Case of injury, my lord.
Subhaji Baddi.
ECA matter, my lord. Case of injury, ECA matter, my lord.
4 weeks. Yes, 75.
My lord, delay may be condoned.
Amregoda M. 75.
Claimant appeal for an is a
The case of death or injury.
injuries, my lord.
Let's see.
In this case, my lord, the petitioner appellant, he is was a driver, and disability is 42%, my lord. 42 is the 44% disability, my lord. But the driving license was renewed. Driving license was renewed. Therefore, after the 7 months of 23 days, so therefore is not fit for disability consideration. Is not consideration of disability, my lord.
4 weeks. Yes,
And
next.
kindly, my lord, call for records, LCR.
Yes, admit, call for the trial court records.
Please.
Yes. Yes.
76.
This is a matter 100% disability, and we have given memo on 12/7/2025 for 33 lakhs. Still now, my lords, that memo, my lords, the company 30, that party was also present. It is within the knowledge of the.
Yes, list these matters after 4 weeks. Yes, 77.
77. Subhaji Baddi. AC Chakalabdi. 77.
The
4 weeks, 78.
liabilities, the decision was traveling in another passenger, my lord.
78.
Seal number 78. Vijay Kumar Kotin.
Appeal for
Precious
claimant in this
Kundi.
case for enhancement, my lord. This case for injury, my lord. I'm sharing a chart, my lord. Calculation. Earlier it was negotiated with officers, my lord, that PW2 doctor assessed disability, my lord.
Have you negotiated with them?
Negotiated, my lord.
How
Only
much they are
disabled.
saying? No, how much they are saying? How you? What is that you are claiming?
But that I am not remember long back.
How you do it? Now you talk to her. Give that chart. If it is possible, we'll do it right now.
I have
Yes.
given insurance
Yeah, yeah.
advocate also.
Give it to her. Yes.
First.
Yes.
Seal number 79.
One more connected appeal, my lord, this one.
This along with so and so. Yes, 80.
80. Vijay Kumar Kotin. Moy Katiki. R.S. Rani.
The trial court considered 30% contributor negligence of petitioner because he was not having driving license, my lord. LCR required, my lord.
And 279 also is
No,
filed.
in that
against-
case.
As per
no.
spot sketch,
In
my
in
lord.
that case, talk to them. In between, something we will take.
At morning only I discussed, my lord, they required LCR, so I
So
made a
the
submission.
officer is there, talk to her. That's
I'm
why
ready.
they are called.
I'm ready, my lord.
My lord, we are ready for 70% as per tribunal order.
17%.
70%.
70.
Our liability is
No, it is the contributory negligence is fixed at 30%.
petitioner 30%.
That's what 30%.
He is also filed charge sheet in
What is that you are ready? Court has already granted 70. You have not filed any appeal. So what is the negotiation here?
And they have complied, my lord, moreover, as per
On
spot.
that, in that 30%,
No,
what are you
he is
ready?
asking 100% liability of
What I am suggesting is not 100%, not 70%. I mean, 30% on you, on 70% on you. It should be a little more than that, in between some 85% or so. That's why I'm
As
asking him
per
to negotiate.
He is also charge sheet section 279.
Huh?
He is also charge sheet is section 279 and 3 and 181.
As per spot sketch, my lord, the
What is
offending
that?
vehicle came in
One
wrong
minute,
side,
one
my
minute,
lord.
1 minute, yes. Which is that?
78.
78. Hmm.
As per the chart.
Any scope for enhancement or not? 30,000 globally. Who appears in that 78?
My
You
lord,
wanted how much?
in that case, my lord, the petitioner was undergone surgical and his right knee
Before,
patella
I'll
fracture, my
hear
lord,
all that.
wound debridement, madam.
What they're saying is 30%, 30,000 globally. What is that you are expecting? I asked.
My lord,
Give that amount. That is that. Then I'll understand what is the difference between the two.
only 15% lordship considered for disability, my lord. I will give it, ma'am.
She says 30,000 they're ready.
Please.
What is that you're saying? If you talk, we'll understand
Yes.
whether it can be negotiated or we can pass orders on the
Yes.
judicial side.
Now itself I will give it, ma'am.
Yes.
For this case, my lord, serial number 80.
What in the next case also, the disability is fixed. I mean, the contributory negligence on him is at 30%. Whether if it can be made 15%, just look at it. Yes. Next. Pass over. 79 and 80 pass over. No, 78 and 80 pass over. Yes, next.
Seal number 81.
My lord, appeal by the insurance and the liability, there is a delay of 90 days and I sought the stay also, my lord.
Huh?
I have sought the stay, my lord. Telling the liability.
You have not filed the EP so far.
We have filed the EP.
When was the
Another
EP
connect-
filed?
There is a connected, they have also the appeal for enhancement.
105798 of 2024.
List along with so and so. It is submitted that you have deposited the money.
I'll deposit 50%.
What are you doing from
is that?
2024?
The 24, my lord.
24, that's what I'm saying.
The matter has been, earlier there is a delay, notice has been ordered.
Insurance company is on the ground of
A liability.
liability, same 50%, 4 weeks, no permission to withdraw, list along with so and so. Take his appeal number also.
Yes. Seal number 82. J.R. Turmari, Subhash J. Baddi.
The another connected 4 appeals, lordship. Kindly
List
post.
along with so and so. 83.
Number kodi sir.
Koಟ್ಟಿದ್ದು.
82.
83.
Number 83.
Same, lordship.
J.R.
That is also
Turmari.
connected and.
84.
Same. 84. Girishas Kulmani.
Notice.
Issue notice.
Yes, 85.
Seal number 85. Sureshas Gundi. Srikanti Patil.
I number 1 of 2025 to condone the delay of 164 days. Condone.
Stay is already granted in this case, Lordship.
Yes.
Yeah, in
Admit
fact,
file hearing, CCR.
No, I have filed the cross appeal in this case.
Admit file hearing.
He may be directed take notice for R3, R1 and 2, I am filing memo for this.
Mr. Soy is directed to take notice on behalf of
Suresh
the
Gundi, R3.
insurance company. Yes. 86.
Dispensation.
Dispensation for R1 and 2 minutes. 1
And 2.
Memo is for second dispensation of notice to R.
1 and 2.
and
Manvantara
And 2.
R1 and 2 dispense with. Yes, next.
85.1. Seal number 86. Suresh Gundi.
Notice.
Issue notice. Seal number 87. 87. Suresh Gundi.
86, there is a delay, Lordship. If you can give condone 20 days.
In
Stay.
which case? In which case?
86, Lordship.
You're seeking stay.
Stay is already granted, Lordship, and we have deposited before the term.
Not served. Notice is not served.
Notice is not, sir. I'll take steps,
So
Lordship.
that's
But
why that's why I ordered the notice. 87.
87. Suresh Gundi.
Stay is granted.
stay is granted in this case also.
Notice.
Please.
Yes, 88.
88. Lakshmikant,
My lords, claimant appeal, my lords, for the enhancement.
Notice.
notice.
89.
89, Manjunath, G. Patil.
Notice.
Notice.
90 notice.
90 notice.
91 notice.
My lord,
91,
for regarding
91.
respond 1 and 2, I am filing a
Which
dispensation.
one?
1 and 2, my lord. 91, my lord.
Serial number 91.
Memo is filed seeking dispensation of notice to.
1 and 2. For
One and two,
R3, Sriram General Insurance. For respond number 3, Sriram General Insurance. Notice or any penal advocate, lordship may direct.
Sriram General Insurance.
Nagarasi.
Please,
So
I will
you
serve
have to
the
take
copies.
notice, and you shall serve the copy of the appeal memo
Please,
on the council. Next, IA number 1 of 20, in this, 147 days condoned on condition, admit final hearing is here. 92,
Please.
92, Nagarasi Kalluri.
Yes. Trial court records are necessary, my lord.
yes.
Lord, I filed application for vacating. In fact,
What vacating?
for modification and withdrawal of, there is no good ground in the appeal. They say that
What it is vacating in MFA?
the fact that, my lord, they dispute that the owner of the vehicle itself, but RC owner is held liable and they are the insurer, my lord, a WC claim, my lord. And as per the schedule and as per the notification, income has been considered, my lord.
My lord, he is an unauthorized.
Correct, 2025 appeal.
Yes.
IA number 1 of 2025 is filed to condone the delay of 126 days condoned. Stay is already granted.
Yes, ma'am.
Already granted, my lord.
Yes, admit final hearing is here.
My lord, in fact, there is one more appeal filed by me. It is in still
With so and
in
so.
the FR number still. It is FR number, my lord.
List along with so and so.
Good, sir. Number good, sir. 93, Nagarasi Kalluri.
My lord, in this we sought stay in this matter, my lord. We have challenged the liability. We have challenged the liability of 50% settled on me.
The
2
insurance
weeks.
companies before this court question to contribute to negligence. Consider the submission stay 50% 4 weeks. Notice to the respondents. Yes, 94.
94,
Compromised yesterday for
Today I filed
57,000. Matter is settled yesterday for 57,000.
Wakalat.
57,000
Around
globally.
globally. And
Both the
50% each respond number 2 and respond number 4. my lord. Liability on the respond number 2 and 4 and 50% each out of 57,000.
Then where both of agreed?
Only two I filed. Next week I will file respondent for Wakalat. Liability is satisfied. Both are parties companies satisfied the award amount.
So I'm saying liability on two insurance companies. Who represents two insurance companies? For both. It is submitted that the two insurance companies, as for the award, are liable to pay the compensation.
And delay may be condoned 1186 days without denial.
Now it is submitted by the land council, or both the councils that they've agreed at an amount of rupees 57,000 globally, and they'll file a memo in this regard before the Lok Adalat. This is matter before the Lok Adalat on Wednesday. On Wednesday. Then the delay of how many days delay?
1186.
86 day delay is condoned.
And one more
Without no denial.
You have settled it.
Okay. And one more submission, my lord. Notice to respond number 193 dismiss, my lord.
Memo is
I filed memo.
dispensation of notice to
Respond number 1 and 3.
1 and 3 dispensed with. Yes, 95.
Memo good, sir. Admission but 95.
Implication of the vehicle, my lord. False implication of the vehicle in the accident.
Yes, admit. Post of final hearing, call for the DCR. Yes. 96.
My lord, it is on the negligence on the part of the deceased. Records are required.
Yes, admit final hearing DCR. 97.
Number 97, Nagaraj Appanavar.
Please, Lord.
Nagarasi Kalluri.
Of injury, lordship.
Pain recovery
Pain.
order.
Only that.
Please, Lord. Additional
We
intent.
want the additional enhancement.
Enhancement.
Some margin.
Calculation also given, lordship.
I have seen.
No. It is like, can there be a joint memo on that?
We are unable to file joint memo because it's a exoneration case, no liability on us. Trial court exonerated on the ground of no deal.
No deal.
It requires a judicial order.
Take that. Take the file, first one. MFA, yes, 100520. Agreed with award passed on MVC number 508 of 2014 dated 22/10/2013. The claimants are before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below. That is at page number, paragraph number 27. Extract that. It is a case of, it is argued that the liability is fastened on the driver of the offending vehicle as on the owner of the vehicle, as the driver of the offending vehicle was not having a valid driving license. Further, the claimant had sustained fracture of patella bone, and the court at the head of pain and suffering only granted an amount of rupees 20,000. But the loss of amenity is also, when the disability is 8%, the court had granted only 20,000. Coming to the loss of future earning on account of disability, the court had granted only an amount of rupees 63,000. Coming to the loss of income during the later period, only an amount of rupees 10,000 is 10,000, and incidental expenses of 10,000 are awarded. When counsel appearing for the insurance company submits that the tribunal has rightly granted a compensation and there are no grounds to interfere. Next, having heard the counsels on either side, there is the material on record. First, coming to the aspect of liability, though there is no driving license, as the petty claimant is a third party, still the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. Then coming to the compensation, considering the injuries that were sustained by the claimant at the head of pain and suffering, this court is granting 30,000. Even considering the disability of 8% towards the loss of amenities, this court is granting 30,000. Coming to the loss of future earning capacity, so why the difference in this?
My lord.
What was the disability considered by the court?
Lordship, total amount 2,23,600, Lordship. Tribunal awarded 1,28,000.
Loss of future earning, it was 41,250. Loss of future earning was 63,000. According to you, it is coming to 73,920. What is the calculation difference?
My lord, the court below has considered the income at 5,000.
5,000, Lordship.
As per the Lok Adalat chart, it is 7,000.
Yes, contingents. The income ought to have been taken at 7,000. So if the income is taken at 7,000, 7,000 into 12 into 11 into 8 by 100 is 73,920. Medical expenses, court has rightly granted, and this court is not interfering. Then coming to the loss of income during the later period, how will it come to 21,000? Oh,
3 months, 7,000.
3 months, 21,000. For 3 months, 21,000. Incidental expenses considering the hospitalization, this court is granting 20,000. Altogether, the claimant is entitled for an amount of rupees 1,79,920. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 1,28,000 to 1,79,920. The enhanced amount shall carry 6% interest. Then coming to the next, agreed with the award passed in MVC number 510 of 2014. Not 510, then we'll take 59. MVC 509 of 2014. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below.
Ninety-nine, 103. 495.
No, what is it? That is MBC number?
ನೋಡು ಒಂದ್ಸಲ ಚೆಕ್ ಮಾಡಿ.
508.
95
508. No, 509. The tribunal has awarded the compensation as per the table given below at paragraph number 30. It is a contention of the land counsel for the petitioner that in all these cases, liability aspect is the same.
Same, Lord.
The first liability aspect he has already taken as it is. Coming to the compensation, the land counsel appearing for the claimant submits that the claimant has sustained fracture of L3 vertebra and the court had granted only 20,000 towards pain and suffering. Then even for the loss of amenities also, for a disability of 8% only, the court had granted 20,000. Coming to the future loss of earning, court had taken the income at 5,000 instead of 7,000. It is submitted that loss of income during the later period also, court has granted only 10,000. Incidental expenses also are on the lower side. It is submitted that on all the counts, the compensation needs to be enhanced. Then counsel appearing for the insurance company submits that the court has granted just and reasonable compensation. No enhancement is called for. Next, having heard so and so. As far as the liability is concerned, still in the light of the law later on is so and so. Then coming to the compensation under the head of pain and suffering, considering the fracture, this court is granting 30,000. Coming to the loss of amenities, considering the disability of 8%, this court is granting 30,000. Then the loss of future earning, considering that this accident had taken place in the year 2013, this court is taking 7,000 as the income. 7,000 into 12 into 14 into 8 by 100 is 94,080. Medical expenses as it is. Coming to the compensation towards loss of income during the later period, 7,000 for 3 months, 21,000. Incidental expenses, 20,000. Altogether, the claimant is entitled for an amount of rupees 2,080,080. Accordingly, the compensation is enhanced from 1,21,250 to 2,80,000. Enhanced amount shall carry 6% interest. Then, next. This is MFA 510. Uh, 508, 509 are here. Just now I'll tell you 509. No, 5010, 510. The. Huh? No, that she can correlate. Here the numbers are there. Agreed with award passed in MFA 1 of 2014. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below at paragraph number 33. You extract the table. Same contention, first contention with regard to liability. Then counsel appearing for the claimant subjects to the claimant had sustained injury and dislocation of the shoulder. But under the head of pain and suffering, the court has granted only 10,000. Towards loss of amenities, considering the disability of 6%, court has granted only 20,000. Coming to the loss of future earning, court had taken the income at 5,000. And towards loss of income during the later period also, a just and reasonable compensation is not awarded. Same is contentions as it is. Considering the submission, having heard so and so, as far as liability is concerned, same finding. Coming to the enhancement, considering the injuries under the head of pain and suffering 30,000, loss of amenities 30,000, Loss of future earnings, 7,000 into 12 into 70 to 6 by 100, 85,680. Medical expenses as it is, compensation towards loss of income during later period, 21,000. Incidental expenses, 20,000. Altogether, the claimant is entitled for 1,91,000. It says 0. Accordingly, appeal is partly allowed, enhancing from 1,01,000 to 1,91,680. The entire amount, now because pay and recover is applied in all the cases, entire amount will carry 6% interest. Yes, next. It is 511. Agreed with about pass fee, MBC number 511. The 36 paragraph number 36. Same with regard to the liability, then the pain and suffering, the claimant has sustained fracture of patella bone and under the head of pain and suffering only 20,000 is awarded. For a disability of 8%, only 20,000 is awarded by the court. Even the income that is considered is 7,000, 5,000 instead of 7,000. And loss of income, same, all loss of income on all same grounds. So for pain and suffering, this court is granting 30,000. Loss of amenities 30,000. 7,000 into 12 into 11 into 8 into 100. 73,920 loss of future earning. Medical expenses as it is. Loss of income during later period 7 into 321. Incidental expenses 20. 1,79,920. Appeal is partly allowed, enhancing the compensation from 1,06,250 to 1,79,920, same 6%. Yes, next, MBC number 512. The table is at page number 46, not page number 46, it is paragraph number 39. The claimant had sustained fracture of L3 and L4 vertebra, but the court has granted only pain and suffering 15,000. Loss of amenities for the disability of 11%, only 20,000, and remaining are same. Hence, first liability aspect is same. Pain and suffering 30,000, loss of amenities 30,000. Coming to future earning, 7,000 into 12 into 7 into 11, 64,680. Medical expenses as it is. Compensation towards loss of income 7 into 3, 21. Incidental expenses 20,000. Altogether 1,76,000. Claimant is entitled for 1,70,680. Accordingly, appeal is allowed by enhancing the compensation from 96,750 to 1,70,680. Enhanced amount, the entire amount shall carry 6%. Yes. Next.
Please.
98.
Seal number 98.
My lord,
My
award
lords,
amount.
claimant suffering for enactment, my lord. I seek a two days accommodation, my lords, in this case.
This matter next week.
Next week. Seal number
Week.
9.
99,
Harish.
it is a ECA claim, that case, only statutory interest.
My lord, we have also filed the appeal.
Yes, just along.
Kindly
this
call
one.
along with me.
Long.
Yes, next 100.
Number ಕೊಡಿ. Seal number 100.
1014.
100.
What about 100?
Nagaraj C. Kalluri.
My lord, call for
Chittamannawar.
records. In this call for records.
Admit file hearing. Call for the DCR. 101.
101. Hermantar Latur.
Liability to the owner, records are necessary, my lord.
Admit file hearing DCR. 102.
Please.
102. Nagaraj C. Kalluri.
My lord, call for records.
Admit.
I am appearing for the respondent in this case.
103.
103.
My lord, company
Party.
appeal is there, my lord. Kindly call.
Post along with so and so. 104.
Number ಕೊಡಿ.
Another two appeals.
104. Geeta KM 104. Nagaraj C. Kalluri.
Yes, after 4 weeks. 105.
105.
I
SK
appear
Kayat.
for petition.
Liability, my lord. No nexus between injury and death. He sustained the injury while he is in the house.
Yes,
Trial
admit
court
file hearing
records.
DCR.
Trial court records, sir.
Yes, 106.
106, Nagarasi Kalluri, Chandrasekhar M.
Please. I
Admin
felt
final hearing is here. Yes.
107, Nagarasi Kalluri, Ganesham Badigir, 107,
Admit. Call for the DCR. 108. Admit. DCR. 109.
108.
108 disposed. Yes. 109.
109, Siddhappa Sajjan, Subhash Jabadi,
Appeal for
Admit. Final hearing DCR. 110. I think the
110,
connected matters are before the division bench.
Another two appeals may kindly connect with 110, my lord.
List along with so and so, but it says DB matter.
Sorry?
Some DB matter.
Oh, yes, so some DB matters, but connected along with this appeal, my lord. Maybe refer to division bench.
List all these matters along with the DB matter, the MFA number 101343 of 2022. Yes, next.
111, GN Narasimhanavar, Nagarasi Kalluri,
My lord, the company appeal is also there, my lord. Kindly call along with.
Please appeal number so and so.
along with number
112.
112,
My lord, kindly connect with the serial number 25, my lord.
Which one?
25,
Yes, ma'am.
serial number 25.
Serial.
112.
Oh, yes, connect with so and so, list along with so and so. Yes, 113.
113,
Call along with me.
Along with so and so. Yes, 114.
113. Follow.
114.
114, Chandrasekhar M. Hosmani,
this claimant appeal for enhancement, my lord. There is connected appeal filed by the company also.
Is there?
Is there? No?
It's on
already
quantum.
connected.
Quantum.
Then we can decide.
Yes.
Yes.
Case of injury, my lord. Year of the accident is 2016, my lord.
Come to the table.
Yes.
Come to the table. Where is it?
Towards loss of future income on account of permanent disability, my lord. It's awarded 2,03,819, my lord. Internal page 16 of the judgment. Pain and suffering, loss of permanents altogether awarded 20,000.
1 minute.
Please.
What are the injuries?
Injuries, my lord, fracture of L3 vertebra.
One fracture.
Yes, ma'am.
Pain and suffering.
Yes.
40,000.
Please.
My lord, shall I submit, ma'am?
Huh?
The question of loss of future earning does not arise at all. Since he has produced the IT return for the accident year and subsequent
See, we
year.
will see. Yes, does this matter?
Yes.
After 4 weeks. Yes, next.
4 weeks. 115,
Yes. Admit
115,
final hearing is here. 116.
PCR,
116.
116. Deepak S. Kulkarni,
Admit final hearing is here. 117.
117,
Same.
Hotel Teli,
117, I am told that it is already settled before Lokada,
117.
before the tribunal, 117. 117,
Is it
in
settled?
the execution petition, the payment has been made and a compromise has taken place.
List 117 tomorrow.
tomorrow,
Tomorrow as part heard
Potter.
on the top of the list.
Top of-
Yes, 118.
118, my lord.
118.
Case of death, my lord. Company prepare appeal on the ground of no DL. Pay and recovery is
On the ground of
no DL, my lord.
no DL.
No DL.
Ah.
So pay and recovery.
Hmm.
And my appeal is for enhancement, my lord. A death, case of death, my lord.
Yes, what are the details?
Please, my lord.
Details of the case.
Please, my lord. Accident is year of 2018, my lord.
How much was taken by the tribunal?
9,000, my lord.
It should be 11,750.
750, my lord.
What is the age?
Age 54, my lord.
Is he entitled for future prospect?
10% added, my lord, already.
Anything, only this?
Only this point.
So 11,750. How many are the dependents?
2 depends, 1/3 deducted, my lord.
What is the multiplier?
11, my lord.
It comes to
11,34,000.
11,37,444.
Please, my lord.
48 into 2. 96,000. 36,000.
Please, my lord.
10,000. It comes to 12,79,444. What is awarded?
9,96,200.
9 lakh
96,200.
200.
Please, my lord.
You said how much was considered as salary?
9,000, my lord.
Give the file. Agree with the award passed in MSC number 801 of 2018 dated 23rd March 2022. The claimant is before disclosing enhancement of the compensation and also questioning the liability. The tribunal has awarded the compensation as per the table given below at 25 extract. Land counsel appearing for the incident claimant submits that the tribunal has considered the income at 9,000 instead of 11,750 and granted the compensation. It is submitted that on all the counts the compensation needs to be enhanced. Coming to the liability, just because there is no driving license, the liability is fixed on the owner of the vehicle. It is submitted that the principle of pay and recover will apply. The next paragraph, and counsel appearing for the respondent insurance company.
My lord,
submits
they
that-
also prepared appeal, connected appeal, my lord.
Then counsel, there are two appeals.
Please, my lord.
Agreed
Company
with
appeal.
the award passed in MFA number 104374 of 2022. Both the insurance company as well as the claimants are before this court. MFA number 104374 of 2022 is the appeal of the claimant, and MFA 102112 of 2022 is appeal filed by the insurance company. You are on what ground?
Pay and recover, because no DL, therefore pay and recovery order is not passed.
Not ordered according
Not
to.
ordered.
Not order, my
But why
lord.
did you come?
That's why.
And moreover, the interest is 9%, 6%.
No, that is also you shouldn't have come. Pay and recovery is not ordered.
Not
Please.
ordered.
So whatever is the interest, you are not concerned. It is the driver who has, the owner who has to pay.
Yeah. Only thing now, if the lordship comes to the conclusion,
The land counsel appearing with insurance company submits that the court has, the tribunal has, the tribunal has rightly fixed the liability and rightly granted the compensation. However, it is submitted that the compensation is awarded, the interest is awarded at 9%. Next part. I've heard the counsels on either side. There's the material on record. First, coming to the aspect of liability, considering the fact that there is no DL and in the light of the law laid down in so-and-so, so still insurance company is liable to pay and record the same from the owner of the vehicle. Coming to the compensation, this accident had taken place in the year 2018. As per the table prepared by the Legal Services Authority, the income has to be taken at 11,750. The deceased is 54 years old. 10% future prospects would come to 1,175. Then his salary is 12,000, his income is 12,925. And there are two dependents. 1/3 has to be deducted. That is 4,308. Then his contribution to the family is 8,617 into 12 into 11. And the head of loss of dependency is entitled for 11,37,444 towards loss of consortium, 48 into 2, 96,000, funeral expenses 36,000, and in the light of the law laid down in Mekala, that 10,000. Altogether, the claimant is entitled for an amount of rupees 12,79,444. The accordingly, appeal of the claimant is partly allowed by enhancing the compensation from 9,96,200 to 12,79,444. The appeal of the insurance company partly allowed, and the insurance company shall pay and recover from the owner of the vehicle. The appeal of the insurance company is partly allowed, reducing the rate of interest from 9% to 6%. The amount in deposit shall be forthwith transferred.
The liability was imposed on the company, insurance company. Pay and recovery orders has to be passed.
That's fine.
Please.
First of all, your appeal shouldn't have been filed. Yes. Yes.
9. TNM Reddy,
Yes, no.
Anjaneyam,
Two weeks.
Vajiban.
Liability issue, my lord. Call for TC. They have challenged the liability, my lord.
2
Call for-
weeks. Yes, 120, admit file hearing this year. 120.
120, Girish Yadwad.
Award amount
Sir
satisfied.
Latur.
The owner has to challenge the liability, my lord.
Owner's appeal.
Owner's appeal. One is owner's appeal, another two appeals are owners. One is
Yes,
claimant.
after 4 weeks. Yes, 121.
4 weeks.
Please.
121, G. Narasimhan.
Admit file hearing this year. So 4 weeks.
Yes.
121. Admit file hearing this year. Yes, 122.
122, it is claimant's appeal,
No
my
DL
lord.
case, madam.
There is
No
no
DL case.
pay and recovery.
Accommodation, pay and recovery can't pass.
And one more,
2019 accident.
income as per, tribunal consider income as per the local chat, my lord. The multiplier age is 50, my lord. Tribunal by oversight took the multiplier 9. It is as per Sarala Verma, it comes 13, my lord. Multiplier is 13 for the year
What is his age?
50. As per own certificate also.
Not wound certificate. It's a case of death postmortem.
Injury case.
Injury case. 13.
13. And tribunal has not considered the loss of amenities, my lord. Amenity is not awarded by the tribunal.
Come to the table.
His age is 50. Occupation is agriculture.
Come to the table. Pain and suffering.
Pain
Only
and-
one fracture.
Two fractures, my lord. Tibia and fibula. Community fracture, shaft of tibia and fibula, left leg.
40,000. Rightly granted.
Doctor says
How many
37.
days you are in a hospital?
He was hospital. 2 times he admitted. First time, maybe 7 days, my lord, 8 days. For a period of 8 days. Exhibit P7.
What is the income?
That is 30,000 is on a higher side, my lord. That is whatever they award.
What was the income taken?
Income taken by 13,250. That is correct, my lord.
13,000.
250.
So loss of income during the laid up period, 13,250 into 3. Rightly taken, 39,000.
Yes, ma'am.
750.
Yes.
Loss of future income,
That's also considered.
13,250 into 12 into
12% disability.
13%.
13 multiplier.
into 13 into
Multiply the disability considered by tribunal 12% out of 37%.
into 12 by 100.
Please. It comes to 2,48,040.
It's coming to 2,48,040.
40. Please.
Then
And
loss of amenities,
not awarded.
how much? In all other cases, I saw
30,000.
30,000.
The only thing is that, my lord, food nutrition attendance charge just 30,000 is awarded for 7 days.
That
It
is on
should
the higher side, attendance charges.
15,000 may be
He
awarded.
was admitted in 2 hospitals. One is in
Only
How many days? Put
9
together.
days, ma'am.
Put together, how many days?
he was first occasion he was 8 days, my lord. Again he took treatment in Bangalore also, my lord.
How many days?
And follow-up treatment he gone to Bangalore, my lord.
Days.
My lord,
Yes,
7.
there is not admitted, but he gone to Bangalore.
Charges will make it 15,000.
Maybe it had taken
But that is on the
20,000
higher
because he
side.
took treatment in Kaveri Hospital, Bangalore also, my lord.
According to you, fracture is 1 or 2, Mr.
Comminuted fracture.
Fracture is 1 or 2.
My lord.
Fracture 1 or 2.
One.
Hey, 2. Tibia and
Tibia
fibula.
fibula means one bone, my lord. It is not
No,
two
no.
bones. They all the way they are arguing in the same manner,
That is also
submitting the
comminuted,
same manner.
not united. I leave it to your lordship.
That I have reduced. Your from the 30 to 15.
Well, increase the amenities if it is reducing in food and nourishment.
It's coming to 4,94,315 against 3,92,915.
Please.
There is no principal of pay and recover in this.
Sorry.
Liabilities on insurance company.
No, in liability is on the owner because of non-holding of the driving license. Now it is a pay and recover.
Agreed with the award passed it. MBC number 816 of 2019, date 7 November 2022. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given at paragraph number 17. When counsel appearing for the claimant submits that the court had considered the income, the court had applied the wrong multiplier. The liability is fixed on the owner of the vehicle. And under the head of loss of amenities, no amount is granted. Then counsel appearing for the responding insurance company submits that on all counts, the compensation that is awarded by the tribunal is on the high, is reasonable and no enhancement is called for. It is submitted that petition is not entitled and the principle of pay and recover will not apply. Next for having heard so and so. First coming to the liability, see the DL currencies. Then coming to the compensation. This court finds that as far as pain and suffering, the court has rightly granted 40,000. To his attendant charges, this concept in his contention. Though he was there for 15 days, 32,000 is granted for the insurance company. This court is granting 15,000. Medical bills as it is. Coming to the loss of income during the later period, rightly granted. No interference is called for. Towards future loss of income. 13,250 into 12 into 13 into 10 by 100 is 2,48,040. Loss of amenities 30,000. In the light of the law laid down is so and so. Legal expenses 10,000. Altogether, the claimant is entitled for 4,94,315. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 3,92,995 to 4,94,315. The entire amount shall carry 6% interest.
And
Yes.
insurance company directed to pay, then recover.
The insurance company shall pay and recover. Yes, 123.
123.
Appellant has challenged liability, my lord.
Admit fine layering TCR 124.
124.
Liability, my lord, employer bill.
Admit fine layering TCR 125.
125.
My lord, 125, my lord. I agreed for 60%, but company is saying that 55%. There is a contributory negligence
Oh.
on the part of charge sheet.
What is fixed by the court?
50-50 is fair.
50-50, my lord.
You are agreeing for?
I am agreed for 60. See, 40% I agree.
No, my lord, we are not agreeing, my lord.
My lord, in this case, bachelor death, my lord, 2/3 has been deducted. I agreed for 50%. Bachelor death. And so far as negligence is concerned, I agreed for 40%, at least 10%. They're saying that 55%.
Against the? Both.
Both vehicle.
Because it is a case of death, little here and there.
Shall I submit, my lord? 45% on the other vehicle, 55% on me. In between, via media, 55-45.
My lord, I'm seeking only 5%, that's all. I agreed to 2/3 to 50%. I agreed for that.
Next week, find out. I think it can be considered. What he's asking for is only 5%.
My lord.
This matter part, that same in the next week list.
My lord, the company appeal is also there, my lord.
A list
Call
along
along.
with so and so.
Please, please.
Yes, 126.
Number ಕೊಡಿ sir. Complaint.
ಇದ್ರಾಗೆ ಎಷ್ಟು issueಗೆ extent?
126 final hearing matter.
My lord, trial court records are necessary, my lord.
Yes,
Claim
call for the
petition.
DCR. 127.
DCR.
127.
127. By Lakshmikant Reddy.
Liability initiative next.
Call for the DCR. Is there? And then post after 4 weeks.
4 weeks.
Yes, 128.
128.
128.
My lord, we have paid the award amount.
Where is the count? Next week, 129.
129. Chandrasekhar Bosmani.
The no DL case, my lord, its company is exonerated, 2016 accident, pay and recovery order.
No, in connected appeal, they have satisfied, my lord. There are 8 more connected appeal. They are settled before the Lok Adalat.
No, so you settle this.
So only
also.
pay and
Please,
recovery.
please,
My lord.
Yes.
please.
What is the amount? Let's calculate and you can file a joint memo. Which year is that?
My lord, regarding the loss of dependency, no issue, my lord. Rightly taken income and added 25% future profit, deducted 1/3. With regard to conventional rates, my lord, 20% escalation.
Give that. File 129. Not there. So 11,37,330. How many are the dependents?
My
Three,
lord.
my lord, 3 major sons.
All are major, my lord, they are entitled for the estate.
Consortium, they are entitled 3 into 48 is on the conventional heads.
Yes, ma'am.
It comes to 1,44,000,
Yes,
36,000.
please. That's all.
Liabilities on whom?
Me only.
Huh?
On me only.
Insurance.
company. My lord, my submission is that, my lord. There's
Yes.
no deal, first thing, my lord. Second thing, they being the major sons, all the three, my lord, aged 33 years, 28 years and 22 years, my lord. They are not the dependents, only loss of estate may
What is their age?
38.
But in other cases, you have,
No, my lord, it's on quantum, my
no,
lord.
no, let us see. Let us see where, what is the age of the children? This is MBC number?
MEC number 634 of 2017.
This is the age is 48 years.
48 years.
33, 28,
Yes.
20.
Yes.
Seema Rani's case will apply.
Yes.
All, they're not that they're all old. One is still student. Other is also student. All are students. Yes.
My lord, 28, 33 years, my lord.
What is the difference now it is coming to?
Coming to
Where is the table in this? At page, paragraph number?
paragraph number, my lord, 28, my lord.
28. Court has granted 12 lakh 630.
630, my lord.
630.
So now it is
13 lakh 2,200.
plus. It's coming to 13 lakh 17,630. That is 1,17,000.
My lord, what is the total award amount, my lord? Total award amount.
13 lakh 17,630.
The loss of dependency comes to 11 lakh 37,000?
As it is,
Same.
Please.
both the council submit the insurance company is ready to pay an amount of rupees 1,17,000 in addition to what has been awarded by the tribunal at 6% interest.
Pay and recovery order.
It's already then,
Obliged.
and they will file a joint memo before the Lok Adalat list on Wednesday. And what about next one? Their appeal.
Please, ma'am.
Yes. 130,
130.
Claim has been dismissed, workman compensation case.
it is dismissed.
Dismissed because they have filed after 7 years.
4 after, list this matter after 4 weeks.
Please.
131,
It's paid, my lord. Award amount satisfied. Trial court award is satisfied.
My lord, in this case, after 2 months of award, my lord, the claimant has again admitted the hospital and taken treatment and incurred for 1,24,000. My lord.
now this court cannot decide that. If it is that you have to lead the evidence, it has, then the matter has to remand to the court.
Please,
Shall I remand?
please.
Where are the documents? Where is that IA?
I have filed, my lord.
Have you filed your objections to
I
the
have
IA?
filed.
No, my lord, I have not received the document.
I have,
And counsel for the petitioner
Definitely.
submits that he has filed an IA. Appellant submits that an IA 1 of 2025 and order 41 rule 27. Then counsel for the respondent shall file the objections. List
Please.
after 2 weeks.
Please.
Yes.
132.
My lord, pass over matter. my lord.
1 minute, we'll complete it. Only
Please.
2 matters are there.
132.
132.
Case of injuries, my lord, the claim petition is dismissed.
Yes.
The call for records
4
LCR.
weeks. Admit final hearing is here.
Call for LCR.
Please.
Please.
133. Harish S. Maigur. NR Kupeluru.
Yes.
NR Kupeluru. Harish S. Maigur. 133.
Claimant's appeal, my lord,
Harish Maigur.
for enhancement of the compensation.
Death or injury?
Injury, my lord.
Let's see.
My lords, it requires consideration because negligence is there. And my lords, as per the apex court judgment, there is no charge.
We'll call for the, is 4 weeks. Look at it, TCR is there, if not, call for the TCR. Yes, 135,
134 urgent. 135. 135. Subhash Jabaddi. Shwetar Kulkarni.
Quantum appeal.
we'll calculate.
Please, ma'am.
We'll calculate. Yes, you the
Because
file.
I'm only disputing the penalty. 25% penalty has been imposed.
What penalty?
Against the owner,
Corporation.
the corporation. So because the corporate, he was employee, corporation has not paid the amount in your section provisions of Employees Compensation Act, they have been imposed a penalty.
4 weeks. not less.
4 weeks.
This where is the Passover matter?
Password matters. This phone pass.
40? Yes, 43.
Please, my lords. Nindal.
Who appears for the respondent?
First list.
My lords, served. Company served.
Which company is that?
Cholamandal.
Cholamandala. Who is the panel counsel?
Money
for-
is appearing. RR money is appearing.
Print the name of so and so and list this matter next Wednesday. Next, Passover matter.
Yes. Password matter list number 2. Seal number 15.
50.
10.
15.
15.
Yes.
Quantum, my lord. Reduction of quantum.
Serial number 15. I am appearing for the.
It's the injury of my lord. Open comminuted fracture of right distal of tibia and fibula.
Where is the table?
My lord.
Table. No, any calculation is, any negotiation is done
No,
on
ma'am.
this? Huh?
We are not on the point of disability considered by the court below. The only thing is that on the amount of, they have not appeared for the settlement. They have not come. That's,
If you want,
No,
you
it
can
is
have a
not-
negotiation
he's-
on this.
Yes, my lord.
my lord.
There, the law
Yes,
officer is
my lord,
there.
and I will,
Talk
in
to
fact, he's till this date, my lord, he is bedridden. Loss of earning capacity has not been,
The law officer is here.
yes, my lord, I will.
Please
I
talk
can.
to her
Yes.
and what is happening, just see.
Yes.
This is matter next week.
Yes,
So please talk to her, talk to him.
Yes.
Yes. Any other Passover matter?
Yes.
My lord.
29.
20?
29.
Serial number 29, my lord, there's a 50% liability on the owner of the vehicle and 50% of the Sriram, my lord. Out of it, we have calculated 6,50,000. We are ready to pay 3,25,000 as our part of the sum.
Then what about the notice to them. Have they appeared? They're not appearing. This is 20?
29, my lord.
Subhash Jabaddi for R6.
You that?
I'm appearing.
No, owner of the vehicle is, which is the respondent?
Spot number 5 minutes.
Anandappa
Spot number 5, my lord.
is served. It is submitted by both the councils that the tribunal where do you get that?
Chart is at
Tribunal has awarded compensation of an amount of rupees 5,42,308 and 50% the insurance company was directed to be paid, 50% by the owner of the vehicle. 50% of the insurance company's amount comes to
3,25,000 now. 25,000.
3,25,000. It is submitted that the insurance company is ready to pay.
3 lakh total, the 6 lakh 50,000 total compensation. Out of that, we are ready to pay 50%. 3 lakh 25,000.
No, anyhow, you are ready, you have to pay that 3,25,000. Whose appeal is this?
Yeah, it is total associated is 6 lakh 50. Out of that, 325 will pay it.
That's what I'm not able to understand. Court has granted 6 lakhs and not.
Yes,
Total compensation is 10 lakh.
5 lakh 42. 5 lakh 42,308.
The claim petition are entitled for compensation of 10 lakh 28,000. Which is the MPC they said?
902, my lord.
902. 5 lakh 42,308. In that half. Half comes to how much? 5 lakh 42,308.
It is 271,154.
That is what I'm asking. What is the settlement if the same amount you are paying? 2,71,154.
This award has been satisfied by the company.
I understand.
Now over and above.
Enhancement. That enhancement is how much?
3,25,000 our part. Total 650. Over and above the recalculation is 5,42,308. I'll tell it, man. 5,48,308.
Your liability is 2,71,154 as per the award. That you have already satisfied. Now, what is the enhanced amount? Enhanced itself is 3 lakh? Oh, so this 3,25,000 is in addition to what has been awarded?
In addition to.
It is, so what did you write? It is submitted that the court has passed as per the award. The amount compensation granted is 5,42,308. 50% liability on the insurance company and 50% liability on the owner of the vehicle. Owner of the vehicle is served and it is unrepresented. As far as it is submitted that the insurance company has agreed to pay 3,25,000 with interest, including interest over and above the amount of compensation that is granted by the tribunal, that is 2,71,154, which is 50% of the liability which is fastened on the insurance company. It is submitted that they will file a joint memo before the Lok Adalat. List this matter on Wednesday for filing the joint memo.
Within the absence of, because he can totally has 6,50,000, my lord. With total assessment, reassessment is 6,50,000 over and above. It will come in 11,98,308. So that.
This is, he is now, as far as you are concerned, he has accepted and liability has gone.
None, I'm not disputing my liability, but so far as the claimant is concerned, he wanted to proceed against the owner for remaining amount.
That is, let us know. Now he has not contested. How can that order be passed in a Lok Adalat, this thing?
That's the reason it's not possible.
You have to, now it should be a full and final settlement. It has, in a judicial order, all these things will come. And how can you proceed? That is the question.
As per calculation, my lords, our lordship may candidate for judicial order.
He is seeking for the judicial order on this calculation.
Next week. Yes. Wednesday. Signatures. Note.
Password.
One more. What happened?
Serial number 78, my lord.
43, pass for matter of serial number 43. J. Narsamanoor, Subhash Jabaddi. Narsamanoor, 43.
Next week.
Next week, yes.
Serial number 78.
My lord, as per your lordship, given calculation, my lord, my calculation is comes, my lord, 1,24,000. They have globally 30,000 they have agreed, my lord. Because in this case, my lord,
So it is not, it can't be settled. Next week. This is matter next week.
please,
Serial number 80, pass for matter. Vijay Kumar
regarding
Potin.
the contributing negligence on the petitioner, my lord. Contributing negligence on the petitioner for the trial court fixed
Now we
30%.
are
my lord.
only on
They have agreed
whether
for
there is any
80%, my lord.
negotiation possible.
They have agreed 80%, my lord.
Agreed.
80%, my lord.
So what, how much is the calculation coming? It has to be judicial order.
No deal, my
If
lord.
he is-
90% I am.
No,
agreeing.
279. He is asking only no deal, my lord.
If you're not accepting, then we have to hear it on the, we have to pass an order on the judicial side. List after 4 weeks.
Please, please. Will my lordship order
Huh?
for LCR, my lord.
List, district is there to call for the DCR.
Grateful.
ಚಾರ್ಜ್ ಶೀಟ್ ಐತಿ.